अच्छा हो वो इसी सेट होता है प्रदीप सिंह गारू उनकी पूछे इससे पहला कौन होता इससे पहले उनके उनके अभी तेरे खत्म नहीं हुए क्या क्या अभी खत्म नहीं हुआ तेरा क्या कर
ಅಂದ್ರೆ ಇದು ಮೇಂಟೈನ್ ಡಿಸ್ಕಸ್ ಆಗಿತ್ತು RP ಮಾಡಿ ಅಲೋ ಆಯ್ತು ಆಗಿಲ್ಲ 1 lakh. ಈಗ ಡಿಸ್ಪೋಸಲ್ ಇದು ಸ್ಟೇಜ್ ಬಿಲೋ 1 lakh ಇತ್ತು ಅದಕ್ಕೆ ಇಲ್ಲಿ ಕೊಡೋದು ಇದನ್ನ ಕೊಟ್ಟು ಇಲ್ಲಿ ಬರಂಗಿಲ್ಲ ಅಂದ್ರೆ ಈಗ ಒಂದೇ ಇಲ್ಲಿ ಕೊಡ್ತೇನೆ.
Cooperative society ಯಾರು? Cooperative society ವಿಜಯ ಮೇಡಮ್.
ಇಷ್ಟೆಲ್ಲ ಪೇಪರ್ಸ್ ಇಟ್ಕೊಂಡ್ಬಂದ್ಬಿಟ್ರಿ
ಸರ್. ಅದು ಆಫೀಸ್ ಕಾಪಿನ ಸರಿ ಮಾಡಲಿಲ್ಲ, ಅವಸರಕ್ಕೆ ಅದನ್ನೆಲ್ಲ ಮಾಡ್ಕೊಬೇಕಾಗಿತ್ತು.
ಯುಡಿ ಅಂತ ಅಷ್ಟೇ ಯಾಕೆ ಹಂಗೆ ಬಂದಿದೆ
ಓಕೆ. ನಾವು ಈ ಕಡೆ ಇದ್ದವರು ಜಿಯೋ ಯುಡಿ ಅಂತ
ಮಾಡ್ಕೊತಾರೆ,
ಅಲ್ಲಿ ಬೆಂಗಳೂರದವ್ರು ಜಿಯೋ ಡಬ್ಲ್ಯೂ ಮಾಡ್ತಾರೆ. ನಂದು ಮಾತ್ರ ಬ್ಯಾಡ್ ಮಗನ ನೀನು
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಕೇಳ್ತಾರೆ ಸರ್.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಟೈಮ್ ಕೊಡ್ತೀವಿ.
ಹೌದಾ?
230 ಲಿಸ್ಟಿಂಗ್ ಸಿಗ್ತದೆ. ಬಿ ಗ್ರೂಪ್ ಮ್ಯಾಟರ್ ಎಲ್ಲರೂ ಒಂದು ಪೋಸ್ಟಿಂಗ್ ಸಿಗ್ತದೆ.
ಫ್ರೆಶ್ ಹಳೆ ಏನದು ಫ್ರೆಶ್ ಬರೀರಿ.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಸ್ ನಾ ಹೇಳಿನಿ ಎಲ್ಲ ಇಮಿಡಿಯೇಟ್ ಸ್ಕ್ರೂಟ್ನಿ ಆಗಿ ಇಮಿಡಿಯೇಟ್ ಪೋಸ್ಟ್ ಆಗ್ಬಿಡೋದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಸ್.
ಇಲ್ಲ, ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕು.
ನಿನ್ನೆ ಹೇಳಿದ್ರಿ ಇವ್ರು ಚಂದ್ರ ಹಿರೇಮಠ ಅವ್ರು ಆಗುದಿಲ್ರಿ ಹಂಗ ಮತ್ ಕೋಆರ್ಡಿನೇಟ್
ನಾನು ಇದ್ದಲ್ಲ ಸರ್. ನೀವು ನಾನು ಫ್ರೆಶ್ ಕೊಡ್ರಿ.
ಸಿಂಗಮ್ ಬರಂಗಿಲ್ಲ
ಸರ್
ಫ್ರೆಶ್
ಪ್ಲಾನ್ ಬಂದಿತ್ತಲ್ಲ ಯಾವ್ದು
ಎಲ್ಲ ಆಮೇಲೆ
ಅದೇ ಸಿಂಗಮ್
ದನಿ ಸ್ವಲ್ಪ ಸ್ವಲ್ಪ ಐತ್ರಿ ಉಳದೈತಿ, ಸ್ವಲ್ಪ ಹೋಗಿಲ್ಲ. ಮುಂದಿಟ್ಟು ಮಾಡಿ ಜಾಕಿ ಮೈಕ್. ಅಲ್ಲ ಏನಾರ ಮತ್ ನೋಡ್ರಿ ಎಲ್ಲಾರ ಮೊಬೈಲ್ ಇದಾಗೈತಿ ನೆಗಡಿಗ್ರಿ ಇವತ್ತು ಮತ್ತೆ ಭಾಳ ಇತ್ತು.
ಹೌದು.
ನಿನ್ನೆ ಅದು ಫಸ್ಟ್ ಡೇನ ಬೇಯಿಸ್ಬೇಕು. ನಿನ್ನೆ ನಮ್ಮ ಆರ್ಡರ್ ಬಾಂಬ್ ಇಲ್ಲದಂತ
ಪೆಂಡಿಂಗ್
Yes. February. Yes.
February.
Sweat off. When was it issued? When was it issued? When was the order? It's coming up on when? Yes, Thursday. By the? When is the order? No, when was the order passed? How was it possible to take up all these matters? Tomorrow court is sitting only half day. Yes, tomorrow. Yes, whatever I'll be able to complete, I'll complete by afternoon.
Tomorrow is the last date. Petitions have been imposed which is favoring only one company, making sure that there is no competition. Tomorrow is the last day.
When did you file?
Yesterday, I filed the matter, fresh matter.
When was the notification issued?
23rd, 23/12.
Or what were you doing from then?
Once the notification is issued, in span of 15 days, it was not possible for me to get the certified copies of the documents also. Once I received, I filed it on 5th. Yesterday.
Thursday.
Please.
Huh?
Submit a proposal for registration of new society. That proposal is rejected.
I didn't get you.
Submitted a proposal for registration of new cooperative society. That proposal came to
No, please tell the court why you should be taken tomorrow out of the turn. That I want to know. If it can wait, it will come next week or thereafter. Yes.
This is a labor matter, Lordship. On,
It will be listed. Yes.
on labor matter, Lordship.
Huh?
Labor matter. Wherein the order show cause notice has been issued to be implemented on 9th, that is day after tomorrow. Yesterday I filed the rate petition.
Tomorrow, yes.
Stay matter, my insurance company appeal, my lord. Previously, as there was delay on the,
Let it come next week. Yes.
madam,
Tender
attachment
matter,
is
my lord.
issued and bailiff is at the doorstep of the insurance company, my lord.
When was the award passed by the tribunal?
Award was passed and notice is issued by the Honorable High Court and notice is duly served on respondents, my lord.
Stay is not granted by the
No,
court.
stay
when
is
the
not
matter came.
granted because of delay.
Yes, tomorrow.
Thanks.
It's a tender matter, my lords, wherein the conditions are modified, my lords, to such an extent, only to suit a particular person. The tender, my lords, the date of filing, my lords, tender is on 12th. Some urgency, my lords.
When is the tender going to be open?
When tender notification, my lords, is the filing of the technical bid, my lords, is supposed to be filed on 12th. My lords, if the interim order is not granted, I will be prevented, my lords, from filing the tender.
We'll have it on 12th Monday. Yes.
12th, my lords, that
That day
would
we
be
will
the
see
key.
Monday. Yes.
One matter,
Not in a
GMC.
position to participate, my lords, to solve the matter.
Then what were you doing till the last minute? What were you doing till the
Day
last
after
minute?
tomorrow, my lords,
Huh?
day after tomorrow, my lords, would come.
Day after tomorrow. Day after tomorrow. Yes, day after tomorrow.
Lords, one matter,
Same
lords,
matter, my
GMC.
lord. Same matter, my lord, same matter. Same matter, my lord. Same notification, my lord.
Lords, one matter, GMCPC, lords. I filed an application for amendment of written statement as well as the counter, lords.
When is the impugned order?
Impugned order at December, lords, December 2nd, lords. Immediately after I filed a writ petition, lords. But last occasion I could not able to get. But your lordship, day to day, the trial court has given a date, lords. At least,
Have the time after next week someday.
that is not. Today is also listed, matter listed before the trial court, lords.
Can't help it.
Regularly.
There are so many.
Tomorrow,
matters.
day after tomorrow, lords. Please, your lordship, day after tomorrow.
Next week.
Well, fresh matters, LIC matter.
It will
Right.
come fresh matter. If it is a fresh matter, it will come.
In
Buy a memo for that. Yes.
My lord, one MFA, my lord. Yesterday, your lordship have allowed the MFA, my lord, for being spoken to. There, my lord, the impugned order was set aside, my lord, by the virtue of a writ appeal order, my lord. If that impugned order was set aside, it defeat the order of a writ appeal, my lord. It is contrary, my lord. Earlier, there was a status quo order, my lord.
What were you doing yesterday? How can there be a being going to? Yesterday order was passed. You were very much here.
Please, it was at the end of.
So what?
Please, man.
No, you argued. You argued. I heard that's the order. Why you are being spoken to again? We will see. Yes.
Milords, one matter for withdrawal of the writ petition. Milords,
11:30, my lord.
Huh?
One matter at 11:30, I request, my lord. The auction is at 12 o'clock, my lord. I have moved yesterday date was given, but memo.
Auction
Is at 12 o'clock, my lord.
Gatti matter.
No, my lord. Joint Register of Corporates pass an award, my lord. Now auction
Monday
is.
on the top of the list.
Milords, one GM tender matter, Milords.
Impleading application, my lords,
Huh?
my impleading application, my lords, was rejected. Impleading, I'm the owner of the property, my land is acquired. The tenant, my lords, is the party to the proceedings. I being the owner, I am not arrayed as a party. Matter, my lords, is on 12th before the trial court. For release of the amount, the compensation amount deposited by the NHI. Now, my lords, I am not there. My impleading application is rejected.
Or, yes.
Milords, on GM tender matter, Milords.
Liability.
Then what the insurance company is doing without filing appeal and waiting till the attachment is ordered?
Next week.
Next week.
Plus,
Yes.
IA seeking substitute service against the unserved respondent writ, my lord, is to seek orders on.
Next week. Yes.
Minimum age is set, assistant commissioner order was challenged before this.
Here is the
court.
petition.
PCR filed, Lord, petition filed in April 2025.
Writ petition which year?
25, Lord. April 2025.
We will see. Yes.
Milords, GM tender matter, Milords. GM tender matter, Milords.
Next-
Auction has already concluded, Milords.
Any date, Lord.
Yes.
Auction has already concluded, Milords. There's a cloud of suspicion that only to benefit some of the bidders, the entire website was taken down, Milords. Now, Milords, the Huda Development Authority is likely to issue allotment letters to the bidders, Milords. If allotment letters are
The
issued,
auction conducted.
auction was conducted on 16th December, Milords.
We will see. Give it to
Milords,
the
at
court
least
of-
have it on Monday, Milords.
No.
The very filing of writ petition
Get
would
thereafter,
become
yes.
infractious, Milords.
Lord, one matter for the end of the list, it is matter pertains to the Lord, medical termination of pregnancy, Lord. Yesterday I moved the matter, but I could not comply.
Tomorrow.
Lordship,
Yes.
GMCPC matter, my lords. Lords, my application for amendment of written statement has been rejected
When?
on 17th of December, my lords.
We will see.
Lordship. Lord, withdrawal, Milords,
Yes.
simpliciter.
Huh?
Withdrawal, simpliciter.
Yes.
Tomorrow.
Yes.
Pending matter.
I think with this we will go till 11:30.
Lord, any date next week in the,
Give it to the court of.
yes.
Yes.
2025, society's resolution is not approved of the new members.
Please don't mention any matters which are pending, yes, unless there is urgency.
Next
Yes.
week, my lord.
May I request it on 19th?
For what?
It's an issue with respect to employment of a petitioner is concerned, pending since 2021.
Yes.
My lord, MFA, my lord, MFA, next week amputation case enhancement, old matter, next week.
Monday. Just leave
Next
it.
week.
We will see. I will list of MFAs for entire day. One day I'll give for MFAs.
Very
So
well.
not now. Yes.
Yes.
Fresh matter, my lord, sir. Execution, we have filed an execution petition. Yeah, next date is 12th, madam.
What is urgency? They have filed or you have filed?
We filed execution, my lords, suit for permanent injunction. Court has said to appoint court commissioner, my lords. Kindly have it.
When
This
was the order passed?
next date is 12th, my lords.
Take it next week, someday.
My lord's insurance company appeal, my lord.
Give it. Yes.
Memo for withdrawal, your lord.
Yes.
Tomorrow.
Yes.
Manchavalal.
Unless there is a
I think already you mentioned, I said no, please don't mention it again.
one request.
Yes.
Unless there is a memo, my lord, scrutiny will not done.
Huh?
Unless there is a memo, my lord.
Why? Without a memo, why they are not listing? Huh? Call the registrar judicial. Yes.
Application for renewal of passport is rejected on the ground of
Unless memo is there.
When did you file? And what is urgency? Huh? It will come. It will come. Yes. Huh? It will come. There is no urgency for that. Yes. When did you file? When did you file that petition? Huh? Oh, you want a vacate petition? We will see. Yes, call the list.
Lordship.
Huh? When was the impugned order? Huh? No, that's what, whenever you file it, it's not the urgency. I'm saying tomorrow the court sits till afternoon. How many matters the court can take up? Day after tomorrow.
Lordship, there is urgency. Order 39, Rule 1 and 2. My 2 applications are rejected. Construction is going on.
When was it rejected?
Pardon, Lordship?
When was it rejected?
When was the improvement?
On 1st December, Lordship, I have got the certified copies on 16 December.
We will see next week. Yes.
Lordship, there is urgency. Construction is going on, Lordship.
It can, even if it is taken up next week, nothing will happen. Call the
Day
list.
after tomorrow, Lordship. This is a humble request. Construction is going on, Lordship.
Still, we will take up. Please call the list.
My lord, one GM rest matter, my lord. My lord.
I think it's difficult for the court to again answer the same advocate after even rejecting it. Please understand. Yes, call the list.
My lord, one GM rest matter, my lord, for hearing or IF for vacating stay, my lord, by suppressing the second compromise.
We'll see next week. Yes, call
My
the
lords,
list.
three
Call the
matters
list.
pertains to work, my lord. Three matters pertains to work. I request any date on the next week because, my lords, in one matter, my lords, we are seeking for vacating of stay. In another matter, my lords, we are seeking for the
See, we will see. Yes, call the list.
Page wise adjournment. Page number 1, serial number 1 to 5. Page number 2, serial number 6 to 11. Page number 3, serial number 12 to 19. Page number 4, serial number 20 to 30. Page number 5, serial number 31 to 39.
Lordship 37, I for the petitioner. Day
This
after
one.
tomorrow, your lordship.
Naveen Chatra.
Why you want adjournment?
Lordship, senior is argued.
No, you will ask adjournment again tomorrow. You will come up with the memo. It's not
No,
possible.
Lordship.
So whatever the listed matters, please argue.
Please.
This
Yeah.
is my next week.
Please,
Next week Thursday.
please, your lordship.
At the request of non-counsel the petitioner. Yes. Huh? It's 15. Then Wednesday. Yes.
14. Page number 6, serial number 40 to 44.
My lords, for
see.
serial number 44, my lords. Senior has got surgery, my lords.
Which one?
44, my lords.
44.
4 weeks time I have granted, my lords.
It is submitted that the counsel for the petitioner is not keeping well. This is matter.
Same extension, my lords.
This is matter on 28th January.
Same extension. my lords.
Yes.
My lords, serial number 41. I appear for petitioner, my lords. I pray for a week's accommodation. We need to secure some instruction.
Yes, come.
Have you informed the other side?
My lords, I have already informed. 41, first list.
41.
Please.
It is at the request of learned counsel for the writ petitioner, list this matter on 21st January. It is submitted that they've already informed to the counsel for the respondent.
Interim order may kindly be extended.
Wherever
Yes.
interim order is there, extend. Yes.
Page number 7, serial number 45 to 50.
49. 49.
Uh,
Wait for petitioner. Petitioner.
uh.
Next week,
Have you informed the other side?
he's not local advocate. He's
We'll
not-
see. We will not adjourn the matter without, information to the other side. Yes, next.
Lords, 46,
Huh?
46 minutes. I am for the petitioner. My senior is here, my lords. I am requesting for some time, my lords, in this matter.
Respondent matters.
Yes, this is matter in the month of February.
There's an interim order, my lords, please.
About all the
Please.
is extended. Switch off that AC, why AC is required? Yes.
List 2. Page number 1, serial number 1 to 3. Page number 2, serial number 4 to 11. Serial number 12. Page number 4, serial number 16 to 20. Page number 5, serial number 21 to 26.
22, my lord. There is
List
another
to
three
20.
connected matter.
Uh,
There are another three connected matters.
36,
So, my lord, there is a division bench matter. Post, connect along with.
Other matters are pending before the division bench. Take that. It is submitted that the connected matters are pending before the division bench. This is matter along with so and so. Yes.
Page number 6, serial number 27 to 34.
My lordship, serial number 28 and 29, my lordship. May I seek adjournment? Please, my lordship.
8 and
29 both.
Oh, this matter is a 24 MFA, not even notice is ordered till now. Why should we adjourn this matter? We'll see. Yes.
Grateful, my lordship.
Page number 7, serial number 35 to 41.
My lord, serial number 36. The petitioner has not served us with a copy. We are the cavator.
Oh, if you wait, if they come to the court, they will serve the copy.
If the direction is given, I will intimate them to serve me.
No, let them come. Then only they'll serve. Yes.
One more submission, my lordship. Serial number 41, my lordship.
41.
I have informed the other side already, my lordship.
At request of learned counsel, the petitioner lists this matter on 3rd of February.
There is an interim order, my lordship.
Wherever interim order is there, they'll extend.
Grateful, my lordship.
My lord, serial number 40, my lords, 40. Serial number 40. I am for respondent, my lords. I informed the petitioner and the matter is likely to be settled. It was adjourned for the settlement itself. 2 weeks.
At the request of the respondent, lists this matter on 18th of February.
There is an undertaking, it may kindly be
To the counsel for the petitioner.
undertaking that I will not put up the construction, my lords. It may kindly be extended.
Yes, the interim order earlier granted is extended to the next date of hearing. Yes.
Lordship,
Page 8.
my ladyship, serial number 6,
Serial number?
second list.
Second list, serial number 6. Yes, yes, sir. 14%.
I have filed this writ petition for direction, but they are not obey the order of this court. And they have filed the objection and they have not served the copy of the objection to me. Last time the court directed him.
That's why please wait till the matter reaches. We'll ask the other side to serve you.
No, you kindly give me adjournment 21st because I'm coming from Belgaum.
Then when will you, how they will serve the objections on you
No,
if you're
the-
not in the court?
Court directed them to serve the copy to me last time.
That's why you wait till the matter reaches, they will give you. I'll ask them to serve you. Otherwise, this will be like that forever.
Adjourn, you give me 21st January, 21st January.
You don't want it now?
No, next time.
This is matter in the month of February, 12th February. Yes. Call the list.
Kindly mention, kindly serve the copy of objection system to me.
They are not here. What is the purpose now?
No, you point the order, they serve the copy. Last time they committed before the court.
Submitted by parting person, the objections are not served on him. Respondent shall serve the objection. Yes.
Lord, with the lordship's kind
Okay,
permission,
oblige.
on memo, my lord, I apologize, Lord. So the amendment of the written statement has been rejected and it is.
What is the urgency?
It is set down for final arguments.
21st January.
When was the impugned order?
17/12, my lord.
21st January.
17,
17/12, my lord.
next week.
Please.
On submission. 1 minute.
Now the mentioning is over already. This has also started.
Emergency. Yesterday also Millers have made a mention regarding Millers, the difficulty Millers problem. The
Yesterday I
advocacy.
couldn't, now the Registrar Judicial will come, I'll ask him what it is. Yes, call the list.
One matter. List number 1. One matter Miller. This is a matter Millers wherein my premises has been Millers taken for the hostile purpose. After 1 year Millers, without there being any intimation, they have left out. I'm not disputing, but they are due in Millers rent. They are not Millers releasing the rent from the Millers proper government, proper authority. I have made a representation in detail. They have to consider my representation. That is
We'll see, there is no.
tomorrow Miller. Loans are Millers laying
We will see,
against
we
him.
will see. Yes,
Any date, next week, any date
we
Miller.
will see. Yes, call the list.
My leadership, I am obliged. I am obliged, section number 21st January, give me.
Yes, 21st January, yes.
List number 1, serial number 1. Orders matter. Prashant S. Kardevar.
Give the pen. It is done. The letter is addressed by the Principal Senior Civil Judge, Gokak, dated 12/12/2025, seeking extension of time, further extension of time of 6 months for disposal of OS number 51 of 2016. Writ petition 10092 of 2018 was disposed of on 7/8/2023, wherein this court has granted 1 year time to dispose of the matter. That 1 year time expired on 28/9/2024. Now a letter is addressed on 19/12/2025. When there is an order to dispose of the matter by 28/9/2024, if extension of time is required, a letter should have been permission ought to have been asked by the court way back in the year 2024. And what the, right from 28/9/2024 till 12/12/2025, why the extension is sought, this court is not able to understand. The learned judge shall place a report before this court. Why? The letter is, why the extension is not sought from 28/9/2024. Registrar Judicial is directed to communicate this order. This matter on 13th. By the time the report shall be placed before the court. Yes.
Serial number 2. CB Angadi.
Petition seeking appointment of an arbitrator.
The postal shara notice to the respondent returned as refused amount to deemed service of notice. Yes.
Yes, ma'am. I prayed for appointment of an arbitrator, my lord. I prayed
Switch on
for,
the mic, please. Yes.
I prayed for appointment of an arbitrator. The respondent is the dealer with the petitioner corporation and supplied petroleum products worth about 19.5 lakhs, and he did not pay the same. Thereafter, the notice was issued as per Annexure D, my lord. And then that also got answered with the postal shara addressee left without information. Page number 63 may kindly be perused, my lord. That was the official address where the business was being carried out. Page number 63 is copy of the legal notice invoking section 21 of the Arbitration Act. Page number 65 is the copy of the postal cover bearing the endorsement address left without information, hence returned back. And clause number 68 provides for appointment of arbitrator. Arbitration clause 68 at page number 23.
Yes.
Clause number 60 at page number 23 may kindly peruse, my lord. That's copy of the agreement and the relevant clause, dealership agreement.
Where is the clause?
Clause is at 68, page number 23. And then the second part, any disputes and differences of any nature whatsoever or regarding any right, liability, act, omission on account of any of the parties herein arising out of or in relation to this agreement shall be referred to the sole arbitrator of the director of marketing of the corporation. This agreement was executed in the year 2012, my lord. Post amendment to the Arbitration Act in the year 2015, any person having relationship with any of the parties is not permitted in accordance with section 12(5) of the Arbitration Act and read with section schedule 7. Therefore, my lord, any arbitrator as deemed fit by this honorable court on the panel here may be appointed.
Yes, will pass orders.
Much obliged.
Yes, next. Heard it.
Heard. Reserve.
Yes, next.
Seal number 3. Hearing on seal number 3. Anjaneyam.
Clement appeal, my lord.
Yes,
108 days delay.
Item number 2 of 24 to condone the delay of 108 days. Condone on condition.
Please, my lord.
Admit final hearing this year. Yes, 4.
Seal number 4. Kannur, Madan Mohan.
My lord, it's appeal from the corporation and it's an injury case. The tribunal awarded already in the 10 lakh something.
You are on what ground?
My lords,
You are on what ground before this court?
my lord, income is already in higher case and
Huh?
income,
Huh.
it's already in a higher case and they have to already 13,000.
It's a case of injury.
And yes, my lord,
Land council.
a stay is already granted in a connected matter, my lord. Here is a
Why
copy.
the stay petition is again reflected?
These are connected matters, my lord.
No, in this matter, there is no stay.
Yes, my lord. We are sought for stay.
I number 1 of 25. No, the I number 2 of 25, seeking stay. Land council appearing for the appellant submits that the court had taken the income on the higher side and the compensation that is awarded by the tribunal. Tribunal is contrary to the, if not considering the same, there shall be stay on the condition that they deposit 50% of the amount within 4 weeks. And on such deposit, the petition, the respondents are at liberty to withdraw the same. Notice to the respondents. Yes.
Seal number 5. Subhash Jebati.
The insurance company challenged the liability in this case.
On the ground?
On the ground that matter that the vehicle is, the insured vehicle is a goods vehicle. The petitioner was traveling as an unauthorized passenger in the goods vehicle.
Then counsel appearing to the appellant submits that the petitioner is an unauthorized passenger in the goods vehicle. And without considering the same, the tribunal has granted the compensation. Stay 50%, 4 weeks. In this, no permission to withdraw.
Yes.
No permission. Seal number 6. Rajshekhar S. Arani.
Company appeal is challenging the liability on the ground that falsely implication of the vehicle. My lord. And the police have filed the C report.
Huh?
Police have filed the C report. And my lord, in this case, tribunal has granted 2,50,000. It's a 164 a petition. And he says that his monthly income is 35,000. In the 163, my lord.
Submit, the land counsel appearing to the appellant insurance company submits that the income of the petitioner is 30,000 per month.
Yes, ma'am.
The claimant was 30,000 per month, and an application to section 154A of the Motor Vehicle Act is filed, and the same is not maintainable. These aspects were not considered by the tribunal. Consider the same. They shall be stayed 50%. In this also, no permission to withdraw. In this also, no permission to withdraw. Notice.
Number 7. Sibhuti.
My lord, I am appearing for the appellant. Corporation appeal, NWCATC appeal, challenging the negligence and quantum. My lord, the accident occurred between the tractor trailer and the bus. The tractor hit the, my lord, bus from the hind side. 50%, my lord, liability has been saddled. This is a case of injury. 12 lakh and odd has been awarded by the tribunal. My lord, the 40%, my lord, future prospectus has been added in case of injury, my lord.
It is submitted by the land counsel appearing to the appellant insurance company that tribunal has failed to fix the contributory it is fixed at 50% on both of you.
50% upon the corporation and 50% of the insurance.
Submitted that. the contributory negligence that is fixed of 50% on the corporation is contrary to the evidence on record. And further, the income that is taken by the court is on the higher side. Considering the same, they shall be stay 50% and they are permitted to withdraw 4 weeks.
Please.
Notice, yes.
My lord, 8, my lord, the accident occurred between the bus and the auto, my lord. 50%, my lord, saddled upon the, my lord, the corporation, and 50% upon the insurer of the, my lord, the auto. And my lord, the
The insurance company is before this court.
Corporation.
Corporation is before this court, questioning the quantum as well as the negligence. The same stay 50% permitted to withdraw.
please.
Notice.
Notice.
Yes, next.
Seal number 9, Subraya Vishnu. AG.
This is an appeal by the insurance company in respect of the damages to the vehicle, madam. Accident between the truck and the KSRTC bus. Accident was in there 2014. Claim petition was filed after a lapse of 6 years, claiming the idling charges of 1,32,600 and repair
The
charges.
non-counsel appearing for the applicant insurance submits that the claim petition is barred by limitation. And it's filed after 6 years from the date of the accident. Considering the submission, stay 50%, no permission to withdraw. Yes, notice.
Seal number 10, Ravindra Armani.
My lord, I am for the appellant insurance company, my lord.
Yes.
Appeal only on quantum of compensation, my lord, challenging addition of 40% to the income of the claimant, my lord, towards future prospects in a case involving only 9% disablement, my lord. There is a recent Supreme Court judgment wherein it is held that in such cases, my lord, future prospects cannot be added. So the tribunal has awarded 5,86,345. Please, my lord.
Appearing for the appellant insurance company submits that the tribunal has considered the future prospects at 40% when the disability is 9%. Considering the same, they should be stay of all further proceedings. The condition that 50% permitted to withdraw. Notice.
Seal number 11.
And 50% can be allowed to be withdrawn, my lord.
Yes,
But
that I have said already. Yes.
Appearing for the, my lord, the appellant, insurer of the appellant. My lord, the claimant is, my lord, unauthorized passenger. My lord, the trial court, my lord, the tribunal has awarded, my lord,
That vehicle.
goods vehicle, my lord, that is a goods vehicle.
It is submitted that the petitioner is the claimant is a gratuitous passenger. He is not entitled for any compensation, but the tribunal has granted the compensation. Considering the submission, stay 50%, no permission to withdraw.
Please.
Yes, notice. Next 12.
Seal number 12.
I'm appearing for the appellant KSRTC challenging the liability, my lord. Initially, my lord, the claim petition has been dismissed by the tribunal. Thereafter, my lord, they have filed.
Of death or injury.
My lord, injury, my lord. My lord, sorry, my lord. Death, my lord. Death. And my lord, this honorable court, my lord, specifically directed the trial court to frame the issue regarding the negligence of the claimant also, my lord. He, my lord, put the right hand in the windows. At that time, my lord, one lorry dashed it to the, my lord, the right hand of the, my lord, the claimant. Due to that injury, my lord, he died in the hospital during the treatment.
Then where is this bus involved?
Please.
Where is the bus involved?
Bus, my lord, only, my lord, the charge sheet has been filed against the bus. That,
He's traveling in the bus.
please, my lord, he is traveling in the bus. My lord, since, my lord, the lorry, my lord, hit the bus. That is a, my lord,
What is the finding of the court on that aspect?
that's, my lord, the charge sheet, since the police have filed the charge sheet against the driver of the bus, the entire liability has been saddled upon the, my lord, the bus only, my lord.
What is the evidence adduced by you?
My lord, I have examined the driver of the bus before the tribunal.
So he will say the same thing. What is the police report, police investigation?
Police
Charge sheet says,
investigation, my lord. The lorry also, my lord, the involved in the bus. My lord, there is a 6 days in filing the complaint by the, my lord, the brother of the deceased, my lord.
anyhow, it is admitted, accident is admitted. How will the delay come? It is admitted, the accident is admitted. The delay will not make any difference.
But my lord, due to negligence, due to, my lord, the rash and negligence on the part of the,
Did you say in your written, in your objections or the written statement?
please, Please, my lord. I have taken that, my lord, specific defense that, my lord, due to rash and negligent driving of the lorry, the alleged accident took place, my lord.
Due to the,
Alleged accident, my lord, due to the rash and negligent driving of the lorry, driver of the lorry, the alleged accident took place.
there's a different aspect. What you are saying is the claimant has kept his right hand outside.
Please,
the
my lord, I have taken, my lord, specific ground in the written statement.
Let's see the finding.
Please. My lord, page number 16, para number 12, my lord. May I read, my lord?
Yes.
On perusal of the materials on record, it is worth note that exhibit P4, there is reference of wording air conditioned on rear side of the bus. On surfing in the internet, the following image is available in respect of offending vehicle model, and same is extracted better understanding. The said image indicates that the bus is fully air conditioned. The description referred in the Caesar measure exhibit P4 is aptly matches to the above image. In the case of air conditioned bus,
Yes.
no window of the either side of the bus.
So
is-
why are you opening the wind, keeping it open in an air conditioned bus?
My lord, that is not a air conditioned, my lord, air conditioned bus, my lord. The tribunal, my lord, taken the, my lord, the internet, my lord, image, and my lord, holding that, my lord, he is, my lord, kept his, my lord, hand.
Exhibit P4,
Please.
in exhibit P4, there is a reference of wording of air condition on rear side of the bus.
Please, ma'am.
Let's not mechanically admit these appeals, that too in a case of death.
Please.
In a case of death, let us not admit the appeal just like that without any ground. Now, according to you, there is a contributory negligence on the part of the deceased. And he has kept his right hand outside. Because of that, the accident has occurred. Now, the court says that it is an air-conditioned bus.
Please.
Where what is the material placed by you to say that it is not an air-conditioned bus, it is an ordinary one?
My lord, I have examined the, my lord, the driver of the bus, my lord.
How will it is not, how will he say that? Whether it is an air-conditioned bus or not, that's the first thing.
My lord, first thing, my lord, it is not a air conditioned bus, my lord.
Where from we have to get that?
My lord, lord, can you pass over, madam?
Tomorrow.
Yes.
Number 13.
At the request of non-counsel appellant.
My lord, the claimant sustained, my lord, simple injuries.
What is the compensation?
Compensation, my lord, 1 lakh, my lord, 71,000 has been awarded by the tribunal. My lord, the tribunal taken the 5% disability and awarded, my lord, 1,71,000, 1,17,384, my lord.
1,70,000. It is submitted with the counsel to the appellant insurance corporation. That is, corporation is before this court questioning the quantum compensation that is granted by the tribunal, considering the same stay 50%, 4 weeks permitted to withdraw notice.
Please.
Yes.
Admission matter seal number 14. Shivraj Sipelaki.
My lords, this is the appeal filed by the beneficiary of the land acquisition. The acquisition is under the new act, my lords. We have challenged the judgment and award of the reference code for enhancement of compensation. My lords, we have sought for stay in this matter. My lords, in a similar connected matter arising, stay of operation and execution of the reference court judgment, award and judgment of the reference court.
Your Lordship, you get, if you're entitled for any enhancement, you will get the enhancement, isn't it?
We are the beneficiary, my lords, KNNL.
You're the beneficiary.
Yes. My lords,
On what ground you are before this court?
My lords, the reference court has failed to appreciate that SLO has passed the award following the parameters that is mentioned in section 26, my lords. That is, they have obtained the market value of the lands by considering the sale deeds, taking into consideration the 3 years, my lords. Then reference court has relied on sale deeds at exhibit P8 and P9, my lords, which are
Let's see the award. There is the award. Page number.
SLO award is at page number 45, ma'am.
40? The petitioner entitled for total compensation of rupees.
Lords, SLO awarded 1,15,482 per acre, my lords. The reference court has enhanced to 5,19,675 per acre.
Where do you get that? Where do you get that order? Page number?
Lords, page number 36, my lords.
36. There is something wrong with the pagination. Writ petition number, this WP.
MFA.
No, it's writ petition you have given.
Sorry.
M.
Page number?
36, my lords.
Why this 22 appeal is coming up now for stay? 22 appeal.
Please, Your Lordship. The compliance because of office objections.
So that means there is no urgency now. We don't have.
Execution has been filed by the claimants, my lord. In a connected matter, other matters, connected matters arising out of same preliminary notification, this honorable court has granted interim order subject to 50% of the amount.
So let's see the order.
Lord's reference court has relied on exhibit P8, the previous.
Let's read that paragraph, how it fixed 5 lakhs.
Please, please. Page number 31, my lords, para 31. May I read?
No, 17, para 17.
Para 7.
Paragraph 17.
Paragraph 17, the learned advocate appearing for the claimant argued that the land was acquired for the purpose of Ainapur two-stage lift irrigation under Hippargi barrage project.
When was the notification in this case?
Preliminary notification. 21/2/2013.
So please, what is wrong with this award paragraphs number 31? Already in the year, a preliminary notification of the year 2005, it was fixed, the rate was fixed at 3,69,000 plus 5% escalation every year.
The reference court has relied on the earlier judgment, my lords, earlier judgment and award. This is under new act, my lords, relying on earlier judgment and award, which is contrary to.
As per the market rate of the land is concerned, how it will make any difference?
Lords, they have relied on.
Under the new act, there is specific provision, my lord, that earlier award, my lord, passed cannot be relied upon because there are different, my lord, section 26, different procedure has been given. This issue is still pending, my lord, to be considered under the new act.
According to you, what is the market value? What is the exhibit you have relied on for that purpose?
My lord, those are SLO, my lord, he relies.
2013 notification.
Please. The SLO, my lord, he relies, my lord, on the, my lord, all the sale deeds, my lord, previous 3 years, my lord, will be listed.
The year 2013.
Please, my lord.
What is the market value as per?
My lord, that, my lord, I need a award, my lord, entire.
Please look at it, because it's a matter of 20 to know, it need not be stated. Yes, let's start next week. Next week, come up with your, please submit your arguments. List next week.
Seal number 15?
Yes.
15
next week.
Same. Next week. Notice.
Seal number 16? Naveen Chakra?
This matter, respond number 1, my lords, reported to be dead on 4th, my lords. I'm reporting the death.
Yes.
Awesome.
Taking necessary steps, my lords.
The memo is filed with the counsel for the respondent, reporting the death of respondent number 1 on 4/1/2026. Then who are the legal heirs for respondent number 1? Who are the legal heirs?
Respond number 2 and 3 and another son is there.
They're already on record.
Only 2 are there, my lords.
Then you should have given the details also so that you'll file an application.
I'll furnish, my lords.
The petitioner, the respondent shall furnish the details to the petitioner with regard to the legal heirs and an appropriate application.
Please.
Shall be filed with an appropriate.
Please.
Yes.
Seal number 17? Sas Niranjan?
Please, my lordship.
Jay Gachin Bhatt?
To appointment of arbitrator, I filed a petition, my lordship. There is a dispute between 2 brothers. It is a family partition agreement, my lordship, between running the industry. Later, some dispute was arised between the brothers. Now, the father, mother, and wives of both the parties want, some of them are interested to retire from the firm. There was a dispute regarding account maintainability. For that, my lordship, there was a reconstitution deed. Initially, he was issued for settlement of the accounts. He was issued 2 checks. When we have filed for encashment, those checks are dishonored. Against that, I filed a case for under the NI Act. Later, he was appeared before the proceedings, and subsequently, the father, one of the partner, he was decided to settle the dispute between the 2 brothers. For that, he was prepared a reconstitution deed. All the other partners are consent for that reconstitution deed. The only thing is respondent and his son, his upcoming partner, denied to sign that agreement. Now there is a dispute regarding the settlement of the capital, investment of the capitals. For that, we are requested him to appoint a arbitrator. Name was suggested for them, but he is not ready to settle the dispute. For that reason, I have filed this petition.
Kindly see page 15. The agreement is not signed by parties. Not at all. Page 15, my lords.
And he's seeking enforcement of that. He's seeking enforcement of
He's
that.
seeking, he's based upon this agreement, he wants the arbitrator to be appointed. Kindly see page 15.
He is the continuing partners. They are not ready to settle my accounts. Other partners are signed that.
Where is the clause for appointment of an arbitrator in the agreement?
There is a clause regarding appointment of arbitrator. Para 18, my lordship, page number 14.
And where is the signature to this?
Also, for that reason, my lordship, the other partners are ready to settle the matter. The other partners, they are ready and they are signed, my lordship.
Can that be done? When if you say that your Like, he is a consenting party to this agreement. And as per the agreement, any disputes have to be.
He is a
settled by the
continuing partner,
arbitrator.
my lordship.
Huh?
He is a continuing partner and he some come under the continuing partner.
You're seeking appointment of arbitrator as per this.
Agreement, my lord.
Agreement between, at page 10 to 15.
May
To
please.
that agreement, he is not the signatory to that.
My lordship, but the other partners are ready to settle the dispute, my lordship.
That we can't do it. Please come.
My lordship, in the reply letter also, he says that there is a dispute. We are partners.
Whatever it is, when you want the appointment of an arbitrator, there should be an agreement between the parties, for which he is not even a signatory to that agreement. We can't pass. Yes, please come. The present petition is filed, seeking the following prayer. It is a case of the petitioner that the petitioner entered into a partnership deed along to the respondents. They're all family members and they all together started industry in the name and style of Mr. Sri Raghavendra Industries. The respondent is the active partner of the said firm. He is managing all the business affairs of the industry. On 18/3/2023, the petitioner and petitioners desired that they want to retire from the firm, and by reconstituting the partnership firm, a reconstitution of the partnership deed was entered. For the outgoing partners, the respondents have issued the checks to the petitioners in respect of their initial capital share as on 31/3/2022. The said checks were dishonored as they were insufficient funds. The petitioners have filed a criminal case against respondent under section 138 of the Negotiable Instruments Act, and the said case is pending adjudication. Further, it is stated that the respondent agreed that balance capital of the petitions, if any, will be paid after finalization of the accounts of the firm for the financial year 2022-2023. And further, he will pay and agreed to pay the capital of the year remaining outgoing partners within reasonable time. The petitioner has repeatedly requested the respondent to submit the details of the account of the firm and further requested him to pay the balance capital amount. But the same was not done. The respondent has not agreed for the same. And they also came to know that the respondents have misutilized and misappropriated the loan amount borrowed from Axis Bank. And also, they've shifted certain machineries and parts of the industries to his Harivom Sales Corporation. And it is a case of the petitioner that the respondent had purchased several properties by misappropriating and misutilizing the funds of the firm in his name and his wife's name. When the petitioner came to know about all these things, he issued a notice to the respondent on 1/4/2025. But he has not responded to the same. It is stated that after issuance of notice dated 1/4/2024, the petitioners have issued another notice on 25/5/2024 to their advocate for appointment of arbitrator, and names are also furnished. It is stated that as per clause number 18 of the reconstitution deed dated 18th March 2023, there is a specific stipulation that all the dispute between the partners of the firm should be referred to the arbitrator, should be referred to arbitration as per provisions of the Indian Arbitration and Conciliation Act 1997. But the petitioner, the respondent, has not adhered to the same, which made the petitioner to come before this court. Next paragraph. When counsel appearing for the petitioner submits that, in the light of the agreement reconstitution deed between the parties, the petitioner ought to have come forward for appointment of the arbitrator, which would settle the disputes between the parties. It is submitted that he is a continuing partner, and there is an obligation on the respondent. Next paragraph. When counsel appearing for the respondent has drawn the attention of the court to the deed and submits that the said reconstituted partnership deed dated
18th March 20,
uh,
18th March month,
18th March
2023.
2023 is not signed by the respondents and the same is not binding on the respondent. It is submitted that the petitioner cannot seek enforcement of an agreement to which the respondent is not a signatory. Next paragraph. Having heard the counsels on either side, there is a material on record. As rightly contended by the learned counsel appearing for the respondent, the reconstitution deed is not signed by the respondent. When he is not a signatory, question of the said deed is not binding on the respondent. In those circumstances, this court cannot appoint an arbitrator as per the clause mentioned in the said agreement. Hence, this court do not find any reasons to appoint an arbitrator as sought by the petitioner. Accordingly dismissed. Yes.
Seal number 18. Jitesh Pandey.
Appearing for
Yes.
response.
Appointment of arbitrator, my lords. Dispute is against the land, my lords.
Where is the agreement first?
Please, my lords.
Where is the agreement between the parties?
There's an agreement between the parties which is at Annexure A. Kindly see page number 13, my lords.
13.
Clause 5 of the agreement.
Clause 5.
Clause 5, my lords. May I, my lords? It is mutually agreed that the rice mill industry shall be installed at the survey number 139, situated at Raichur Road, Gangavati, which land stands in the name of first party, that is Sri F. Shanmukappa, son of Fakirappa Chalwadi, which is respondent number 1, my lords, father of the petitioner. Measuring 2 acres, and the same has been contributed to the firm by way of his share capital in the firm's business profits loss as such. The said land shall hereafter become the assets of the firm. Here, my lords,
Where is the arbitration clause?
At para 14.14,
Para 14,
clause
my
14.
lords.
May I
Page
read?
number 14, my lords.
Then
My lords, kindly see page number 14, clause 9, my lords.
clause 9.
Clause 9. The duration of the partnership shall be for a period of 20 years or till the loan advance to be advanced with Karnataka.
This agreement, the partnership deed,
Please, my lords.
12th of April 1994.
1994, my lords.
20 years will end when?
20 years?
20 years, 12th of April 1994.
1994.
2014, my lord.
What happened till
There
the
is
loan
one.
advance
There is
to
one
the
clause, my lords. That is.
Karnataka State Financial Corporation is
Please,
fully
ma'am.
cleared, whichever is earlier. Loan is not cleared.
Loan is paid, my lords. Loan is paid, my lords. My lords, here, my lords. We are here for settling of accounts, my lords, not for dissolution of partnership deed, my lords.
Difference of opinion between the partners as to the conduct, activities of the management of the firm. Now, this clause number 14 has to be read along with clause number 9.
Please, my lords. That the difference of opinion between the parties as to the conduct activities of the management of the firm's business.
So, as
yeah,
long as the
same
firm's business is there, disputes are there, that has to be settled by way of
that has to be
arbitration.
settled, my lords.
So, the partnership itself has gone because the duration itself is fixed at 20.
Partnership has not been dissolved yet, my lords.
What is this?
It is.
We'll
Please.
read 9 again.
It states that 20 years of the partnership deed,
Or the
or
other one
until
is,
the loan amount is repaid.
so both are now
Both are.
worked out. So
So now the property contributed by the first partner in favor of the partnership, that stands in the name of partnership. But the father of the this petitioner, he is the owner of that property. Now he is alienating that property. When the property becomes the absolute property of the partnership firm, one partner has no any right over that property. That is the crux of the matter.
that is true.
That has to be decided.
No. When you look at this 9 and 14, what is the scope of arbitration? Read that 14, clause 14.
Yes.
It says that the difference of opinion between the partners as to the conduct, activities of the management of the firm, business, the same shall be settled by arbitration. Now, the firm is not in existence at all by virtue of clause number 9. When the firm itself is not in existence, how we have to read this clause number 14?
That accounts have not yet been settled.
Uh-huh.
That account or not yet been settled. The contribution paid by each of the partners has not been yet settled. Officially, that partnership has not been dissolved. That has to, if the other party wants to dissolve the property, the accounts has to be settled. When the property is in the name of the partnership firm, no one party has no any absolute right over that property. That has to be settled. That is the dispute.
Yes, what do you say?
Please, my lord. My lord, as per clause 14, my lord, now the as legal notice issued by them for arbitration, my lord, it is at page 16 to 18. Page 18 may kindly be seen, my lord. For the purpose they are seeking appointment of arbitration, my lord. May I read, my lord? Therefore, my client being authorized by clause 14 of the partnership deed, so and so, my lord, at page 18, para 5, my lord. Appointment of advocate whose details are given below as an arbitrator for carrying out the dissolution process of the firm and settling the partnership account, including my client's share therein, and calls upon to give my consent to the same. My lord, they are seeking partition, my lord. They are seeking partition, which cannot be the scope of arbitration, my lord. And in the clause 5 of the arbitration agreement itself says that the property involved in the arbitration in the partnership deeds was standing in the name of respondent number 1, my lord. It is absolute property of respondent number 1. For the beginning of partnership deed, he has entrusted his property for the son has no right over the property. Even being in the relationship, my lord, they have to file a partition suit for claiming his share in the father's property. That cannot be decided under arbitration, my lord.
Yes,
Reserve.
Please, ma'am.
Seal number 19, Irungoda K. Kapoor, K. Anand Kumar.
Give it respondent.
My
lords, the appeal has been filed under challenging the judgment and award dated 25/7/22.
You are the
Appellant, my lords.
You are the beneficiary.
Beneficiary. Beneficiary.
Challenging the judgment and award dated 25/7/24 passed by.
The operative portion of it.
39, my lord.
30.
Para 39.
Yes.
My lords, the reference court has erred in determining market value. They have considered the sale deeds based on the other villages which are.
Let's see that particular paragraph. Where is it?
54, page number 53, my lords.
Paragraph number?
Paragraph number 40, my lords.
40?
40.
Please read that.
The average sale price per gunta comes to 27,870.60, rounded off to 27.870. If it is multiplied by 40 guntas per acre, it will be considered as 11,14,800 per acre. Would be just and reasonable market value, my lords. Above that, my lords, there is a box which has been considered, my lords. They have considered the sale deeds of that particular survey numbers, my lords. They are pertaining to the village of, in the next page also, my lords. The list of agreements of sales taken in Corwin Koppa and Kadroli, my lords. They have considered the villages, those sale deeds, my lords.
What is
which
the
are-
present village? What is the village involved in this?
Budihal village.
Budiyal, my lords.
Budihal
Budiyal,
village.
which are far away from these villages, my lords. They have considered these sale agreements and determined the compensation amount.
What are taken per acre, how much?
My lords.
Per acre?
11 acre, 40,800 per acre.
11
11 lakh, 14,800.
14,000?
800.
How, what is determined by the land acquisition officer?
4,73,200.
200.
What do you say?
As per the sales statistic, my lord,
There are no sale deeds of this village.
no, the land was acquired by the Malaprabha project, my lord. The village of the Budihal village submerged of the water. Yes, the trial court has taken a nearby village sale deed.
These lands are submerged.
Submerged in the backwater of the dam.
Any other connected matters?
My lords, they are saying that they are submerged and they are nearby, my lords, but they are far away, near the, more than 100 to 150 kilometers far away, my lords. The land differs, my lords, and they another sale
What are the
deeds.
documents that are placed by you before the court?
Please, ma'am.
What are the documents that are placed by you?
Sale deed, my lord.
Sale deed of that other villages?
Please, ma'am.
Sale deed of other villages?
Nearby village. Adjusted village.
What is the distance between both the villages?
Almost 8 to 9 kilometers.
There is, like there is no other sale, no sales have taken place in this village near to that?
In the year of 1991, the land was submerged in the dam, my lord. 91, my lord. They have taken a position in the year of 91.
Position was taken in 91?
91.
Then where from they'll get the sale?
Parole notification at 16.
The sale transaction of the recent years. If the property was acquired in the year 1991 itself, where from they'll get the sale deed? No, then in 1991, there must be some sale before the acquisition.
Note 411 notification 21/1/2016. The
1999.
91 ದಲ್ಲಿ acquire 1991 ದಲ್ಲಿ acquire. The land was submerged in the dam, my lord. My lord, the 4 notification 11/1 notification issued on 21/1/2016.
21/1/2016.
The sale deed produced by 14, 15, 16. Exhibit P1, P2, P3.
Better argue these matters. Better argue these matters. We'll corporate acquisition of 1991, again granting stay and keep these matters pending. You can argue it.
Please,
We can decide it.
please, short date.
When
Sure.
do you want?
1 week, next week.
Yes. Let's this matter next week. Not next week. We'll have it on 21st.
Notice not issued.
Notice maybe.
R1.
I'll take notice for that.
And
So only R1 needs to be.
30.
So and so takes notice for R1. How many of the respondents? Only two.
two,
You are-
1 and 2. In the connected matter, same notification, same village. This honorable court granted 50% stay subject to the.
No, this is not a big issue that's involved. We can dispose it on.
Please,
That's why I'm saying we'll have it on 21st.
Please,
please.
Even give those connected numbers also.
Please.
Connected numbers also you give, they will be
Give,
listed
I
on
will
the day. He'll take that number on 21st.
MFA number 100761
Write on a paper and give. Yes, next.
Please,
please, ma'am.
Seal number 20, MM Patil.
Appeal, appellant. Beneficiaries appeal, my lord. The district court has committed an error while considering the Lok Adalat award in deciding the market value, my lord. It is against the judgment of the Honorable Supreme Court, my lord. And also, the other sale deeds are considered by the tribunal, my lord. They are far away from the,
What is the market value?
my lord. The market value, my lord.
By the court.
The SLO has awarded 66,550 my lord per acres my lord. But the tribunal has awarded 5,63,000 per acre my lord.
5,63,000.
63,000 per acre my lord.
When is the notification?
My lord, notification is my lord. 2013 my lord.
7/3,
2013 my lord. 11 on notification my lord.
2013.
13 my lord.
Sale deeds of which year?
Said lead my lord. They are 2013, 14, 13 and 14 my lord. In page number 42 my lord. And
According to
the
you, they are not of the same village.
different villages my lord. One is my lord Kausalgi village and another one is Adwad village and another one is Kalligudi village and another one is Adwad village my lord. But the present land is situated in Adwad village my lord. And two other, the tribunal has considered another village's sale deeds my lord. And moreover, serial number 4, they have considered the Lok Adalat award passed by the in a different matter my lord.
The council appearing to the applicant submits that the land acquisition officer has fixed the value at 66,500
Yes.
per acre.
Per acre.
And the same was enhanced to 5,63,000 by the court. It is submitted that while enhancing the market value, while fixing the market value of the land, the court had considered the sale deeds that are pertaining to the other villages and also the award that is passed with the Lok Adalat. It is submitted that the same is contrary to the settled law. Considering the same, they shall be stay on the condition that the appellant shall deposit 50, they shall be stay of all further proceeding pursuant to so and so on the condition that they shall deposit 50% of the amount within 4 weeks.
Notice, Your
R1
Lordship. I'll take notice for
government-
respond above.
So takes notice to
Respond.
on behalf of
Respond number one.
R1.
Yes, R1 and R2 notice.
Public.
Seal number 21. Salkar.
My lord, it is case of appointment of arbitrator under Arbitration Act. The Honorable Court has directed me serve a copy to the panel advocate. In fact, the client were served earlier notices, but today I will serve him the copy of this order.
No copies are served.
And statement of objection has to be.
Submitted that the counsel for the petitioner will serve the copy of the petition on the counsel for the respondent. This is matter on 19.
Please.
9. Seal number 22. English V. Kataman.
Beneficiary appeal my lord.
Yes.
This my lord in the covered my lord in the both of matter my lord in the clubbed matter my lord already is my lord division bench my lord already stay is granted my lord 50% my lord in the my lord amount is my lord in the preliminary notification my lord in the on my lord in the
Preliminary notification is which year?
my lord 2013 my lord 2014 my lord 23/6/2014 my lord new act my lord in the
What is the market value fixed?
market value my lord in the 3,22,000 my lord.
3 lakh?
3,22,141 my lord. Well, my lord in the SLO is my lord in the 64,000 my lord. The my lord in the district court my lord in the 4,79,667 my lord. 4,79,667 my lord. Difference is my lord in the
So what is wrong with this?
my lord difference is my lord in the is my lord in the land is agriculture land my lord in the my lord in the documents only my lord in the sale deed is documents is produced my lord in the other than documents is not produced my lord in the
No. The claimants have relied on the sale deeds of which year of which village?
village is my lord in the Karbanhalli my lord in the
And this village is?
same my lord in the
Then? No, I'm asking you, what is wrong with the award?
wrong is difference of my lord amount is my lord in the 3,22,000 my lord in
That is
the
true. That is basing on some sale deeds of the relevant year, isn't it? He has considered the sale deeds.
yes.
Please come to the exhibits. What are the exhibits marked?
Exhibit, my lord, in the P1, my lord, is my lord in the reference application, my lord,
Reference application.
in the SLO, my lord, in the Huinadagal, my lord.
Is notarized copy of, yeah.
Yes,
Now,
my lord.
he has relied on a sale deed of 2011,
Yes, my lord.
2012. Then your acquisition is on 7/3/2013. Then sale deed of 2015.
2014, my lord.
This 2011-12 sale deed, what is the market value?
Market value is, my lord, in the 3,22,000, my lord.
3 lakh
22,000, my lord.
22,000.
Yes, my lord.
But according to you, the court has taken 4,99,667.
Yes, my lord.
Where is the discussion? Let us see.
Is, my lord, page number, my lord. Page number 38, my lord.
38.
Yes.
Let's see, please read. Not 38. Where is the discussion I'm saying? Which paragraph? Please come to paragraph number 32. The acquired lands are situated at, that's at page number 35.
Yes, well, the enhancement of 10% of from date of notification dated 5/8/2020 2004 till the date of publishing the notification of this case on 3 lakhs as per the 1,79,660 rupees and as per occur. Hence, the point of point number 2 and 3 is answered is the affirmative. Melody in the pay 150 melody in the already stay is granted melody. Club, there are two matters melody in the clubbed matter melody in the very same judgment melody in the.
But these are all small, very small matters where the issue is whether they have relied upon a sale deed pertaining to this village of that contemporary, that particular time or not.
Yes.
That we can pass an order. Accusations are all of, 10 years back, 12 years back. Then counsel appearing for the appellant submits that in respect to the very same accusation, the division bench has granted stay in MFA number 1000638 of 2025. And he has placed before the court the said order. The division bench had passed the order as follows. Extract this. In the light of the order passed by the division bench, they shall bestow of all further proceedings on the condition, say whatever is the order extracted. Write it in the operative portion. Yes, notice respondents. So
R1 to R3 melody government melody in the.
R1 to R3, so and so.
Government
the
melody.
government
R4
has
melody in the
fixed
notice.
quotas. There are any other respondents?
Only one respondent. R4 melody. Private
R4
melody.
notice to R4.
Yes, seal number 23. Patil.
Appellant, ma'am. This is beneficiary appeal, my lord.
Is it connected with the other matter or not?
No. My lord, the notification in the year 2013, my lord. The SLO has awarded 3,87,500, my lord. The district court awarded 7,93,220, my lord. The district court has taken the previous sale deeds, my lord, and previous sale deeds, my lord, and they are pertaining to Kauzulgi village, my lord. But this land is situated at Kulgodu village, my lord. There is a difference of 5 kilometers from the acquired land, my lord. And the claimant has specifically admitted in paragraph 42, my lord. He has admitted the suggestion that Kulgodu village is situated at the distance of 4 kilometers from the acquired land, my lord. Therefore, there is difference in the market value, my lord. The district court has, without taking into consideration these aspects, passed the order, my lord. Therefore, my humble submission, my lord.
Please come. The learned counsel for the applicants of the SAR. The court had, while fixing the market value at 7,93,220 by enhancing it from 3,87,500, court had taken into consideration a sale lead pertaining to a different village which is situated 5 kilometers away from the present village. It is submitted that on that ground the appellants are before this court, considering the same 50% in all these matters that are to be deposited in the earlier order. It is there. Yes, next. You
My
know,
lord.
this for 1, 2,
R1 and R2, my lord.
R1 and R2.
To the government and others for notice.
So and so takes notice. For the other respondents, look at it. Notice to the other respondents. 1 and 2 she takes notice. Yes.
What
So
about
the next
24?
one?
Appealing for
Ma'am,
the beneficiary, my lord.
Yes.
It is similar to the previous matter, my
Same
lord.
one. Yes.
Similar. My lord.
Yes. Same, that also takes notice and.
1 and 2 for the government and others notice. My lord.
Yeah. Yes. Next.
Number 25, English containment. English containment.
Beneficiary appeal, my lord. My lord, in-
Is it connected to the other one? 22?
Yes, my lord, not my lord.
Not connected.
Yes, connected, my lord. It's
Yes.
different. My lord, in the notification is stated, my lord, in the 7/8/2021, my lord. Is the
What is the value fixed?
value is, my lord, in the one lakh 64,000, 1,64,465, my lord, in the is SLO, my lord. My lord, in the district court award, my lord, in the 4,76,480, my lord. Is difference is, my lord, in the 3 lakhs.
What about the difference, sir? What is wrong with that? What are the orders?
My lord, in the other villages of sale deed is, my lord, in the exhibited is produced, my lord, in the. It's not in the.
In this also, like the court has considered the sale deeds of other villages,
Yes.
but not of the same village, and enhance the same from 1,64,465 to 4,76,485, considering the same 50% that amount to be deposited and all. So and so respondent number 1 and
1 only, my lord.
respondent
Government
number
one.
1 so and so takes notice to other respondent notice. Yes, next.
Next matter same, my lord.
Next matter also same. Yes, sir. Yes.
Preliminary hearing. Seal number 27, B.S. Kamte.
Lord, these, Lord, the matter is covered by the Honorable Supreme Court judgment, my lord.
What is this? I
Lord,
think
the-
notice is not ordered till now.
Lord, the petitioner is the Lord KPTC, my lord. KPTC has drawn, my lord, power lines, my lord. While drawing the power lines, my lord, so whatever, my lord, the,
1 minute. Please come to the cost item.
Yes.
There are 2 respondents. Notice is not ordered.
notice is not ordered. Lord, I will take out emergency notice to the response so that matter could be disposed of, my lord.
Petition is permitted to take out notice on the.
Emergency notice, my lord.
1 and 2. And file a, shall take out notice.
Asked.
Respondent 2.
Pleasure.
And file proof of service. Once a memo is filed, list this matter. Yes, 28.
Number 28,
Pleasure.
Anand Kumar.
Petitioner.
Yes.
Well, land survey number 572, measuring 47 acres, my lord. The, out of the 4 acres, my lord, the petitioner cultivated the land, my lord, since 18 years, my lord.
All
For
respondents you are representing?
8 notice. Yeah, respondent number 8 to go to notice, my lord.
Notice has to
R8.
go. No, there won't be any government panchayat development officer.
ಅದೇ ಪಂಚಾಯತ್ ಇದಕ್ಕೆ ನೋಟಿಸ್ R8 ನೋಟಿಸ್ ಮೇಲೆ 1 to 7, 9 to 12 ಗೌರ್ಮೆಂಟ್.
No. For 8, there won't be any council.
ಇಲ್ಲ
Council will be there for the panchayat also.
ಪಂಚಾಯತ್
Who appears?
Belgaum district.
Belgaum.
Shivraj.
ರಾಯಬಾಗ್.
Shivraj.
Please.
Respondents 1 to 7 and 9 to 12. The APA takes notice. For respondent number 8, so and so, what is the name?
ಭೂಷಣ್ ಕುಲಕರ್ಣಿ ಅಂತ.
Bhushan Kulkarni is directed to take notice. The petition should show the copy of the petition.
My lord,
on the-
in connected matter, this honorable court, my lord, give interim order will not disturb a position, my lord. That's, since he was in position 80 years, my lord, for answer.
My lords, what is the order challenge is in there of dated 17/12/2019.
Looking at it, what is
Yes,
that order he
please.
is relying on?
Last pair.
When is this order passed?
Last pair, my lord.
No, I
If
saw that. What is the date of the order?
order
It's on
same, my lord.
29th October 2025.
Please, my lord.
What is impugned in this? Let us see.
17/12/2019, my lord, they give the respondent number,
Let us see, where is it?
page number 62, my lord. Within 30 days vacate the position, he give a
Please wait. 60?
62, my lord. Annexure K.
That is in my lords, Kannada language. That is in Kannada language, my lords. Lords, the order was passed on 17/12/2019. The directing the my
That is
lords,
question now.
that is question now.
Please.
That is question now.
Now
and
the
an interim order
respond,
granted in
now
that.
the respondent told, my lord, try to vacate the position of the
Please
petition.
understand, an order that's passed in 2019, why should the court presume that you are in possession of the property? Unless and until you file some document for the court.
My lord, kindly see, my lord, page number 35. He file application
Why
before
are you
the,
questioning this order? Why are you questioning it in 2020, an order of 19?
now the respondent number told, try to vacate the position of the property since he was a,
Please get instructions in this. This is matter next week. That's on 14th of.
my lord,
January.
not to position.
These kind of
Because,
orders cannot be passed.
my lord.
You are questioning an impugned order of the year 2019.
Same order,
No, I will not pass those kind
coordinate
of
bench of granted.
Please get instructions. What is the present stage?
Kindly see 30 page number, my lord. He file application before the Tahsildar, grant a Sagol cheat, my lord. The Tahsildar issued a Sagol cheat in the year of 1992, my lord. Since the 1962 till today, he was the position of the property.
My lords, admittedly, it is a forest land, my lords. Tahsildar has no power to
I will
issue
produce the
Sagol cheat.
R2, kindly see, my lord. 1962 till 1992.
Council, please understand this. You have come before this court questioning an impugned order that's passed in 2019.
Please, my lord.
Just because the other court has granted an interim order, I cannot grant an interim order like
No,
this.
I am not short. I am not
What
short
I'm
for
saying,
interim order, my lord.
understand. Let the government leader get instructions. I'll hear him and pass orders if you're entitled for an interim order on the next date of hearing. Let's just matter on, what is the date I've given? 14? Okay, 14.
Number
Yes, next.
29. Anand Kumar.
Next also same.
Same, on the same day. Yes, 38.
Seal number 30. Kulkarni, Sangram.
Yes.
Yes, my lord, the petitioner is a civil contractor undertaking civil works contract, my lord. The petitioner had undertaken the works of the government
Go
of,
to that, let us look at your prayer. What is the relief?
my lord, writ of mandamus, my lord, to consider annexure A to C. It is covered by the judgment as produced at annexure D, my lord. My lord, it is under the provisions of the GST, it is the service recipient who has to pay the amount. Since in order
Who
to,
appears to the respondent? The executive engineer.
Copies are not served.
No copies on that. We will see.
so it's
If
already
the
served.
Counsel for the petition.
Office
serves the
objection.
copy. He appears for all.
He appears for all.
So and so is the AG is directed to take notice on behalf of respondents 1 to 3. Land Counsel the petition is a copy of the petition on the council.
Please.
List this matter on 14th, not on 14th, 14th. By that time, please get instructions.
Please.
By the time the respondent shall get specific instruction, or else the orders will be passed in the writ petition. Yes, next.
Seal number 31, Nandish Patil.
My lord, I appear for the petitioner, my lord.
This
My
case, I
lord,
need some
the
time.
petitioner, my lord, is the consultant, my lord, is an employee, my lord, of the Merchant Trade Guarantee Corporation.
So I pray some time to file
Am I audible,
objections.
my lord?
Now let us just understand what is the case about. Please come
Please.
to the prayer.
My lord, the prayer, my lord, my lord, it's written in the nature of circular, my lord, quashing the impugned notice dated 31/5/2025, whereby, my lord, the account of the petitioner, my lord, has been frozen.
Please come to this, what is this, notice dated 31/5/2025?
Please.
Where is it?
Annexure A, my lord, in page number 18.
18, please.
Page number 18, my lord.
Let's read.
18.
Annexure A.
Annexure A, page 18, my lord. We would like to inform you that we have received a notice number so and so from Cyber Economics Narcotics Crime Police Station advising and authorizing us to freeze your account bearing number so and so with immediate effect as a part of a procedural review. My lord, my account was frozen, my lord, and that is why, my lord, I had filed this writ petition. My lord,
No,
please,
that is reference to a crime.
please, my lord,
Reference to a crime,
please, my
isn't
lord.
it?
Please, my lord.
Why should there be a direction without even understanding what is the case? What is
My
your
lord, I will
involvement?
just, please, my lord, may I just explain the facts, my lord? Am I
Yes.
audible, my lord?
Yes, yes.
Please, my lord. My lord, the petitioner, my lord, is working as an employee, my lord, with, my lord, the Merchant Trade Guarantee Corporation, my lord. My lord, it is basically a finance corporation, my lord. My lord, there was a transaction, my lord, in between one Raghavendra and one Azhar Khan, my lord. My lord, Azhar Khan, my lord, placed an order for T-shirts, my lord, worth around 2.7 crores. My lord, this 2.7 crores, my lord, was funded by the Merchant Trade Guarantee Corporation, and I am an employee there, my lord. I had, my lord, facilitated this particular transaction in between Azhar Khan and Raghavendra for the funding purpose, my lord. For that purpose, my lord, an amount of rupees 3 lakh was transferred to me as a commission.
Criminal procedure. Yes.
Please, my lord, insofar as the transaction is concerned, my lord, because the loan was funded through me as an employee, my lord, around 3 lakh rupees was transferred to my account, my lord, as a commission.
Yes.
Please, my lord. Now, my lord, other than that, my lord, there is no transaction in between myself and the entire crime, my lord. Now, my lord, the goods were sent to Dubai, but the same were not delivered. All other allegations are there, my lord. Your lordship may kindly see the interim order, my lord, that has been granted on the last date of hearing, my lord.
Yes.
My lord, that is, my lord, dated 23/8/2025, my lord. May I read the interim order, my lord?
Yes.
Learned AGA, upon instructions today, submits that accused number 1 has transferred a sum of rupees 3,34,463 to the account of the petitioner. If that be the case, the entire account of the petitioner cannot be frozen. Respondent number 1 is directed not to disperse the amount of 3,34,463 from the account of the petitioner till the disposal of the proceedings. My lord, in similar circumstances, my lord, there is one judgment, my lord, of this honorable court. Your lordship, my colleague will hand over the judgment, my lord. In fact, this matter can be disposed of with that observation, my lord. My lord, could your lordships kindly take para 3, my lord? In addition to reiterating the various contentions urged in the memorandum of petition and referring to the material on record, learned counsel for the petitioner submits that in respect of petitioner's bank account number so and so, out of the total transaction amount, the disputed amount is only 50,000, and that the petitioner has no objection for lien to be created on the said amount, and necessary directions may be issued to the respondent bank to defreeze the aforesaid subject account by marking a lien only to the extent of the disputed amount, which is
So
rupees 70.
where do you get the disputed amount?
My lord, it is there, my lord. They have only mentioned that.
Where is that?
My lord,
My lords, it is his assertion saying that he has received sum of rupees 3 lakh 30.
We shouldn't entertain
Yes.
these writ petitions
That's
because
matter is under
in
still in.
respect of a crime, you have a remedy before the criminal court for seeking this relief, so that the entire material will be before the court.
Yes.
Whether you're entitled for an order to defreeze the account and all, that will be decided.
my lord, the transaction of 3,30,000 rupees, my lord, I will place it on record. Your lordship may pass it on. Your lordship may pass it on, my lord.
Because for that I require the FIR. We require the FIR. If any charge sheet is filed, that we need to know. In furtherance of that, your account must be frozen.
Please, my lord. Then your lordship may have it next week, my lord. I'll place that records also.
Yes, next week.
Next. Seal number 32.
Obliged.
Salma.
Yes.
Miss Salma.
No representation, less matter in the month of February. Yes, 33.
Seal number 33. B.C. Jnanaya Swami.
Appearing for the petitioner, my lord. The petitioner here in challenge annexure B, my lord, issued by
Please
the.
come to the prayer.
Please, ma'am. Your lordship, the impugned notification, your lordship, issued by the fourth respondent, my lord, to establish a new shop, fair price shop in the village of the present petitioner. The present petitioner is the, my lord, fair price shop license holder. He is running the fair price shop, my
In
lord.
respect to which village, where is your notification, your appointment?
Please, my lord. Annexure A, my lord.
You are appointed in respect of which village?
Guggarhatti village, my lord. Same village, my lord.
Gukka?
Guggarhatti village, my lords, in Ballari Taluk and district. Lords, what he is contending that the license should not be given to the another person. The another license should not be given to the another person.
Then
Lords,
as per your guidelines.
Guidelines only.
What is the distance? What is the requirement? How
Distance-
many cards?
Distance is not
How
the.
many cards he is having?
My lords, if he is having more than 500 my lords, cards, he is.
How many cards that village
That
is
he has
having?
to
as a-
My lord, 1800, my submission is that, my lord, as per the notification, your lordship, if they are going to establish the new shop, your lordship, it is admissible in the fair price, your lordship, order.
No, basing on which provision you say that they cannot issue a notification?
Please,
Yes,
PDS control order, my lords.
yes,
That
where
is-
are they?
my lord,
Let him say, let him say.
section.
If he has only 500.
Control order,
It
your
is
lordship,
sufficient for him.
section 11, assignment of ration.
Control order
card.
number?
PDS control order.
PDS control order, your lordship, 11, section 11, my lord.
Give that.
Assignment of ration cards. Your lordship,
1 minute. Let's see.
second, your lordship,
Let's read the entire 11.
please,
Let's read entire 11 itself.
please.
After sanctioning and
After
authorization.
sanctioning an authorization to run fair price shop, authorized authority shall assign to the fair price shop certain numbers of ration cards belonging to the persons residing near the fair price shop depot. Second, my lord, the numbers of ration cards assigned to the,
So this is a rural area or an urban area?
it is,
Rural
my
area.
lord,
Rural area.
Guggarhatti is,
So rural area.
rural area.
So minimum is you should have 300 cards.
yes, ma'am.
Yes. Next.
But my lord, as per the notification, yes, I am agree, my lord, what my lordship said, but my submission is that now your lordship, the state government, your lordship, conducting a survey. In that survey, my lord, they are going to, my lord, cancel the illegal, my lord, rations cards. That survey should be complete. After that, my lord, how many cards will
That
be?
is not your concern.
Yes.
Now how many you are having is the only.
Yes, 18, more than 1800 cards, your lordship, I am.
So you cannot say that I should be only only the fair price shop dealer in that place.
Yes,
Because you are only, it's a rural area, you're
Yes, ma'am.
entitled, you shouldn't be less than 300. According to you, it is 1800. You can't cater to the needs
Yes,
of the people.
I'm not going to object, but my lord, till my lord, the survey should be complete. After that, my lord, how many residents?
Their problem, that's not your problem. Whatever is conducted,
Yes.
if it is less than 300, you can come to the court anytime.
And moreover, my lord,
His license
in
is
adjacent
cancelled.
village, my lord, what is the act of the, my lord, the state government? They are going to discriminate, my lord. In your lordship, neighbor village, my lord, more than 2,000 cards is there, but they are not going to take any action on that shop. Only, my lord, targeting my shop, my lord.
No, we'll take action one by one.
Please understand, there
Please.
can't be any equality for an illegality. You can't claim that under 226. Please come.
With reserving the liberty, my lord, if our cards is reduced, my lord, 300, I can approach before this.
My lords, admittedly,
After conducting the
1800
survey.
and more is
That
having.
is always there, that I'll observe.
Please.
If you're having less than 300, you're always at liberty to come before the court. They can't give that kind of,
With that observation, it may be disputed.
the present petition is filed, seeking the following prayer. Extract the prayer. It is stated that the petition society is registered and the cooperative societies, society is registered as a cooperative society under the cooperative society and authorized and also authorized holder of the fair trade shop situated at, what is this, Kuggara-Hatti,
Guggarahatti.
Taluk, Ballari district. And the society is distributing the food grains to the card holders without any complaint from any corner. It is stated that on 7/11/2025, the respondent number 1 has issued the impute notification for establishment of new shops, including in respect of Kuggara-Hatti area, and also invited the application from the public at large. After the issuance of the said notification, the petitioner made representation to respondent number 2 to 4, requesting for cancellation of the notification because they are running the shop since 1994 and distributed the food grains to all the card holders, and there is no any proposal from the public for establishment of new shop, and the establishment of new shop is not required. It is also stated that government has issued circular directing the deputy directors / assistant directors of the entire state to verify the eligible and not eligible card holders and submit a report. It is stated that the respondents have not taken any action till today, pursuant to the representation made by the petitioner. Hence, it compelled the petitioner to come before this court. Learned counsel appearing for the petitioner submits that in respect of this village, the government has issued the notification. Whereas in respect of the other villages where there is even whatever is the number of the cards, they are not issued, they are not issuing any notification or appointing any further fair price shop dealers. There is a clear discrimination on the part of the respondents. It is also submitted that when he has given a representation, the respondents ought to have considered the same. The notification that is issued by the respondent needs to be set aside. Next para. Learned counsel, the AGA has drawn the attention of this court to the Karnataka Essential Commodities Control Order 1992 and the Karnataka Essential Commodities Public Distribution System Control Order 2006. He has drawn the attention to, it's called, what is that, it's called orders, what is that 11 is called? It's control order.
Control
11.
order. Control 11.
Order 11. It is stated that as per control order number 11, the number of ration cards assigned to a fair price depot under subclause 1 shall not be less than 300 for a fair price depot in a rural area and not less than 500 for a fair price depot in an urban area. the authorized officer, if he considers it necessary in the interest of the ration card holders, transfer ration cards from one price shop to the other, provided that no such transfer shall leave any fair price depot with less than the minimum number of ration cards as specified in order 11(2) of the of the control order. It is submitted that in this particular case, the petitioner is having more than 1800.
1800.
More than 1800 cards, and this is in a rural area. In that, there has to the petitioner has to have a minimum of 300. In that case, the discretion rests with the respondents to issue a fresh notification, to bifurcate, transfer, or appoint new fair price shop dealers. It is submitted that the petitioner has no legal right that can be enforced before this court under Article 226 of the Constitution of India. Next paragraph. Having heard the counsels on either side, there is the material on record. Control order 11(1), 2, 3 makes it very clear that in a rural area, the minimum card should be 300, and in urban area, the minimum should be 500. If it is the case of the petitioner that though he is having less than 300 and still the respondent have issued a notification for appointment of another fair price shop dealer, then this court would come to the rescue of the petitioner. But that is not his case. When he is having more than 300, and it is, as it is said, it is more than 1800, in that case, petitioner has no legal right to come before this court, or he cannot seek an order from this court restraining the respondents from appointing new fair price shop dealers. Then the submission of the petitioner that the respondents are not doing the same in other areas is not that this court cannot consider. If the respondents are duty bound by the control orders and they have to act in accordance with law. If after the new fair price shop dealers are appointed, and if he is having less than 300 cards, then the petitioner is always at liberty to come before this court. Next, in view of the above discussion, the relief as paid by the petitioner cannot be granted by this court. Accordingly, the petition is dismissed.
No, sir, take notice for R1 to R6.
Huh?
Take notice for R1 to R6.
R1 to R7 called AGA. Yes.
Number 34, Subhajibati.
Yes.
My lord, the claim petition is filed under Motor Vehicle Act. After amendment of the Motor Vehicle Act, that limitation is not been, that tribunal has no power to condone the delay and entertain the claim petition. To that manner, that this issue has been pending before the Supreme Court, and several cases.
Let's see.
Please.
Let's look at that order dated 22/8/2025.
22. Hey, please.
What is the order?
Para 30, internal para 30. Order on IA number under section 5 of the Limitation Act. The advocate for the petitioner has filed a application under section.
See the amended act. Give the act.
Act, madam. Yes. 166.
Motor Vehicle Act. Amended act. 166.
166 plus 3, my lord.
Let's see.
My lord, here that specifically mentioned that no application for the compensation shall be entitled unless it is made within the 6 months of the occurrence of the accident.
It's not the rules act. Leave that. 166. Yes, please read.
My lord, 166 plus 3.
One?
166, sir.
Yes.
Subsection 3. No application for the compensation shall be intended unless it is made within the 6 months
Application
of
for
the occurrence of the accident.
No application for compensation shall be entertained unless it is made within 6 months of
Occurrence of the
accident.
accident.
So in this case, when the accident had taken place,
Accident occurred on 13/10/2022.
13,
10/2022.
when
And
is the,
claim petitions filed on 31/5/2023.
it will not be, no, the amendment is, what is the date of the amendment?
1/4/22 it is come into effect, man. 1/4/22. And that accident happened on the 13/10
And when is the insurance policy?
policy. My lord, policy was issued on 2/4/22.
24,
22.
20?
2. This after amendment.
No, please come to the order.
Please.
Now you said when it is filed on 31/5/2023.
Yes, ma'am. Impugn order. Internal page number 30, madam. There are 2 orders separately passed on the 2 separate application. And
Please come. Then comes for the petitioner submits that the accident had taken place on
13/10/2022.
13/10/2022. The claim petition was filed on 31/5/2023.
3.
And the amendment to section 166(3) or 4.
Motor Vehicle Amendment Act.
The amendment to 166(3) of the Motor Vehicle Act is on 1/4/2022. The insurance policy was issued on 2/4/2022.
Yes.
It is submitted that the amendment makes it very clear that no application for compensation shall be entertained unless it is made within 6 months of the commencement of the accident. It is submitted that when the act is very clear that there cannot be, the amendment makes it very clear that the court has no discretion to condone the delay. In such case, courts cannot condone the delay. It is submitted that in this case, when the claim petition is filed with a delay of 48 days,
48 days.
the petition, and for this case, section 5 of the Limitation Act is not applicable. And the court, without considering the same, has entertained the claim petition. Considering the submission of the land counsel for the petitioner, there shall be stay of all further proceedings in MVC number 360 of 2023 till the next date of hearing. Notice to respondent.
Please.
Bill number 35.
Yes. No representation. Representation on behalf of the petitioner. Is this matter in the month of March? Yes, 36.
36. Vinayak B.
This matter, I filed wakalat, my lord, my name may be shown.
Hmm.
After my lord was transferred from Bangalore, the earlier council's name is being shown, my lord. My name may be shown. Shivraj Bellak.
What's your name?
Shivraj Bellak.
So and so submits that he has filed NOC Vakalat.
Please,
NOC Vakalat registry is directed to print the name of, write on a paper and give
please,
of so and so. You're ready now?
please.
Copy is not there. Copy is not there, Your Lordship.
The council shall serve the copy on the learned government either. This is matter. When?
After 1 week,
This is matter on 20th of January.
please.
Yes.
Seal number 37 urgent, seal number 38, B.C. Jnanaya Swami. PC.
Appearing for the petitioner, my lord. Petitioner here in your lordship.
Let's see the prayer first.
Your lordship, annexure E, my lord, the impugned order passed by the learned civil judge and JMFC, my lord, page number 29, my lord.
29.
Please, it is a defendant's writ petition, my lord. Defendant's writ petition. The plaintiff, your lordship, filed.
Let's read. Read the order.
Please. Order on IA number 9, my lord. The counsel for the defendant number 2 has filed a IA under order 3 rule 2 of read with section 151 of CPC seeking permission to the general power of attorney holder of the defendant number 2 contest the case on behalf of the defendant number 2. Wherein the accompanying affidavit, it is stated that due to ill and eyesight.
Documents that are filed to show that you lost the eyesight. Any document is filed?
Well, before trial courts, they have produced, my lord.
But the court says nothing has been produced. You filed your chief examination, all IAs are filed by you. No, only no, not to face a cross examination.
She is suffering some illness, my lord. And it
Nothing has to be there before the court. Otherwise, how will the court believe? Read paragraph number
yes,
8.
my lord. On that ground, it was dismissed, my lord.
That was the correct observation. Why you have not placed anything before the court? Place something before this court.
They have produced, my lord, actually.
What is that? No. That's what the court observes. Read paragraph number 8.
Please. On perusal of the record, it reveals that, my lord, it is true that the defendant has got exam in DW2 and she also submitted affidavits in earlier stages. Further, it is relevant to state that when matter was shut down for arguments, the defendant number 2 herself came with IA number 6 and 7 seeking permission to lead evidence, and they were allowed in the hands of justice, and thereafter she got examined as DW2, and thereafter matter was set down for the chief examination of DW2 for several dates. Finally, the learned counsel for the defendant number 2 moved the instant IA 8 or not eyesight are not good and she is not able to.
The order of the court is the recent one.
My lord, as per my lord, the order 3 rule.
That's subject to the court has to accept all that. There should be the reason for filing the application.
But the power of attorney holder entering of the power of attorney holder, your lordship, it cannot be reject on that ground, my lord. This honorable court, my lord.
It all depends on the facts of the case. Nobody is saying that you can't be represented by the GPA. Take that. Pass on. Please read. Yes.
My lord. Page number 10, my lord. Your lordship. Page number 10, answer to point number 2. Whether the request made in the application to lead evidence, power of attorney can dismiss by stating that no grounds are made out. In view of my answer to point out
Point number 1, no application for permission is requested.
Here is a case, right from the beginning, he has been represented by a GPA holder. That's a judgment in those facts and circumstances. In your case, chief examination, everything has been done by you. You have been contesting the matter. Now, when it comes to cross-examination, you say that somebody else will come and as a GPA and do it. So this judgment is not applicable to the
Well,
facts of the case.
Before trial court, your last, some of the medical records, your last, they have,
Produce.
I will produce. Now.
Let's this matter on 20th of January.
Please.
20th.
Yes, next.
Preliminary hearing, the group matter. Bill number 39, Shurajas Balloli.
Please.
Dear Lord Khan.
For petitioner, my lord, here the petitioner agreed by the Gazette notification dated 5/1/2012, my lord, at annexure E. Insofar as declaring CTS number 2943A of Dharwad Gali, that is petition.
Which page is your prayer? Your prayer, where is your prayer?
At page number 9, my lord.
9.
One impugned Gazette notification, my lord. Second one is the order passed by the Chief Executive Officer, Karnataka State Board Work. At annexure
First,
F.
let us see this order, release B, where is that order? Dated 29/9/2012.
At annexure F, my lord, page number
Let's read.
90. It started page number 80,
We will take
82,
up
my
this
lord.
matter in the afternoon.
82, pardon?
No, we have to hear it finally, we will take it up in the afternoon. Yes, Pastor. Yes, next.
Bill number 40. Yes, Kamte.
This matter, my lord, arises under the provisions of the, my lord, work fact, my lord. The claim of the, my lord, the work board is, my lord, it is the property of work. But our contention is, my lord, it is our property and it is not a work property. My lord, ultimately the issue is, my lord, whether property belongs to, my lord, a private or work, my lord. But what has happened, my lord? This is a property, my lord. Initially, my lord, this is the Vatan property, Kulkarni Vatan property, which was regranted, my lord, in favor of my vendor's father. Long back, my lord, may I request, my lord, the
Work fact.
synopsis, my lord.
No, let me understand. What
Yes,
is
my lord.
the
So I will, my lord, just, my lord, give the, my lord, few facts of the case, my lord, so that.
1 minute?
Yes, my lord. The very first page, my lord, I have given, my lord, the synopsis, my lord, it gives a clear picture.
No, before going to that, let's
Yes.
go to this order dated 23/4/2014.
23/4/2014, my lord.
I think this has to be heard finally.
This has to be heard, my lord.
Pass over.
One small question that requires to be considered by the honorable court is, admittedly, it's a grave ad.
My lord, may I request some time, my lord? With the reason, obviously, my lord. Lord, so far as my lord, work property is concerned, my lord, recently, my lord, I have come across, my lord, the Supreme Court judgment, my lord. Merely, my lord, entry in the register of work, my lord, is not sufficient to say that it is a property. So he has to approach the proper court, my lord, get declaration. Then only, my lord, claim, my lord, that it is a work property.
Party will go to the court.
My lord,
The aggrieved party will go to the court.
aggrieved party should be, my lord, work permitted. That is, my lord.
In the, if that is there in the work register,
Yes.
whatever it is under which
It is for the, if suppose if, my lord, I am having, my lord, registered document, and if work board says that it is a work property, they're claiming, my lord, that it is work property. It is for them to, my lord, approach the, my lord, proper court under section 83 of the, my lord, work fact, my lord. Lord, I will place on that judgment also, my lord. Lordship kindly have it next week, my lord, any date, my lord, with great respect, my lord.
Let's just matter on 22nd.
Please.
22nd.
Please.
Yes.
Number 41 adjourn. Number 42, Dinesh M. Kulkarni. SCGP, B. Muhammad Ali, respondent number 2. Sadiq Pudwala.
There is a petitioner.
Dinesh M. Kulkarni. Seal number 42.
Seek a short accommodation. I seek a short accommodation.
Please. Suit is dismissed as not maintainable.
This is matter in the month of March. Yes.
March.
Please, madam.
Seal number 43. A.S. Patil, D. Lad Khan.
Order of the work tribunal is challenged.
Uh,
Suit of the plaintiff that is barred by time, and issue number 3 is
serial number?
43.
43.
43. Yes.
May I request 20th, my lords? You have to collect the papers, my lords.
Stale claim already.
Not adjourn it further. We'll have it on 20th.
Oh, no issue, no issue.
This is
Please,
matter on 20th at the request of the petition. No further adjournment will be granted.
please, grateful.
Yes.
Seal number 44 urgent. Seal number 45. Shuraj P. Mudhol. Shuraj P. Mudhol. Srinanda A. Pachapure for respondent number 5.
May it please, my lords, I appear on behalf of the petitioners, my lords. My lords, the petitioners herein are the parents of one Ramachandra, my lords. My lords, the third respondent has issued a heirship certificate with regard to respondent number 4 being the wife.
One second.
Please, my lords.
Where is this order dated 16/9/2021?
16 order.
Page 41, annexure G.
45 is the operative portion, my lords.
Page number
As far
37.
as this, the impugned order is concerned, file a translated copy.
Please, my lords.
Translated copy of the impugned order at page 41.
I will make it.
The petition shall file the issue.
Submission.
Huh?
It's only one submission. Lordship permits me, my lords. The issue is, my lords, they are denying that I'm not the wife of petitioner's son. He has died. Suit is pending, my lords, where the issue is framed whether she proves that she is wife of so and so.
Suit, who filed it?
Wife files it.
Present respondent, wife.
Has filed a suit.
She has filed suit. Specific issue is framed that whether you prove that you are wife of so and so.
Now, these proceedings are.
This
before-
proceeding, they challenge a certificate issued by Tahsildar that after the death of husband, she is also the surviving member of the deceased. There is a certificate. It's not an order. That is being challenged, my lords, under section 49 of KLR Act, my lords. That itself is not maintainable.
So first of all, how can the Tehsildar give such a certificate, legal hair certificate?
Survivorship certificate can be issued by Tahsildar, my lords. That is of no use.
Because
I have to
it can't
prove.
be used in any proceedings.
Yes, no, no, that is why I filed a suit. In the suit, my lords, there is specific issue, my lords, frame that says that, my lords, I have to prove it, and that is being pending. This is the first issue, my lords. Lordship may direct the petitioner, relegate us to the suit. Whatever is the outcome of the suit, that will be binding on the both.
That has no consequences.
Consequence.
The certificate has no consequence at all in the light of your suit itself.
Please, my lords.
No, that's certificate, my lords. After the death, my lords, an application is made. The village accountant comes and sees who are the surviving members. That is being issued. She is the wife, father, mother, whoever is there, my lords, he issues that certificate.
So now this
They cannot
present-
challenge that certificate. my lords.
No, the present certificate that is filed, what it says, who are the surviving heirs of that person?
Yes, my lords.
The
That is wife,
The petitioners are the parents, my lords,
parents,
and the
and
wife. So three
wife.
people.
3 persons. Their name is also there in the certificate. My primary content.
Contest the said suit.
Just with the finding that this certificate will not have a.
Not come in the way,
Please,
it
my lords, that may be. That observation may be had, my lords.
Please come.
My lords, may I pass on the e-court of the OS?
Here, madam.
It's posted for evidence, my lords, now.
ಅದೇ certificate ಕೊಟ್ಟಿದ್ದೀನಿ.
You are contesting that.
Yes, my lords, I'm contesting.
The present petition is filed seeking the following prayers. It's like the prayer.
My lords, one submission if I may make. Now, in the impugned order, my lords, he sets aside the appeal that is filed by me before the assistant commissioner, and he reconfirms the order that is passed by Tehsildar. So this order will have to go, my lords. The impugned order will have to go, and we may be
Tell
relegated.
the court, what is the consequences or implication of this
My lords,
order?
pursuant to this, she has also filed an application before the Tehsildar for record of record of rights as well, my lords. So therefore, that order will have to go and we may be relegated because even with regard to there is a government circular, my lords, wherein if there is a dispute between parties, we have to.
So that's what I'll observe is like now this either to claim any of the benefits, this can't be considered.
Considered, yes, my
It
lords.
can't be considered.
Benefit, no, sir. It's
No,
just
but
a
it will not
certificate.
No, if somebody is disputing that you're the wife and the suit is pending, no, for what purpose you can use this?
No,
No,
if,
they're already disputing the relation and the suit is pending.
yeah, dispute is pending, my lords.
Oh.
Now, certificate, whether they could challenge that in a revenue proceedings is a question, my lords. The appeal itself is not maintainable. Under revenue, my lords, section 49 if you look.
Basing on a certificate that's issued by the Tehsildar, you seek mutation or some other thing in the records, whether that can be done?
Yeah, my lords, if a husband dies, my lords, I am the legal, including, their name is also there. What I'm saying is, we are all the legal representatives. That right is available, my lords.
In the light of the pending suit, all this shall not inure to your benefit, the certificate, because you have questioned it before a competent court.
True, my lords. No, the validity of that certificate, my lords, again has to be tested before, my lords, the trial court, because suit is there. They are disputing. I have to prove.
Whether it will be independently done in respect of whether there is a certificate or not when you file the suit.
No, it will be an.
Basing on the certificate, the
Yes.
court will not decide.
It would be a corroborative evidence, my lords. Corroborative evidence. I have to independently prove, my lord, that issue. Along with that, my lord, these are documents.
If you say that this will come to your rescue in that proceedings, then we have to hear this writ petition.
Please, my lords.
No, what I'm saying is, my lords, if your lordship holds that there is the validity of the certificate in writ proceedings, then lordship would say, my lords, that this certificate has to be independently proved in the suit as evidence. But there is a procedure. My lords, when husband dies or anybody dies, my lords, an application is made to Tehsildar that we are the surviving members. It is not a succession certificate. It's only, my lords, a certificate saying that these are surviving members of the deceased.
What is the suit that is filed by you?
The partition.
And they have filed a written statement
in-
denying the relationship.
Yes,
that
yes,
is
they are
pure
there. Yes.
entitled.
So issue is also framed to that aspect. If lordship says the certificate, the validity of the certificate, my lords, that cannot be challenged in this proceedings is my contention.
How then?
49, what it says, KLR Act, my lords, lordship would see any original order passed by the Tehsildar. This is not an order. This is a certificate.
So
It's what it says is it's a letter.
no, you tell the court. Now, some random person who is unconnected with the family, if the Tehsildar without any basis says that he is the legal heir or surviving heir of the deceased, then what is to be done? That certificate will be that is valid. If according to you it cannot be questioned. There should be some remedy for that. Just
No,
like-
suit is the remedy, my lords. If they dispute the relationship itself, the
You
suit
have
is
to
the remedy.
independently prove it, irrespective.
Yes,
of-
yes. Independently, I have to prove it. But now, my lords, the validity of certificate, what I'm,
No, you please tell the court, like
Please.
a certificate of that nature.
please.
When the parties were disputing it, they cannot come before the court. Is your contention?
They can't, my lords, approach the revenue authorities, challenging the certificate. They can challenge the mutation entry, which comes under the Land Revenue Act, my lords.
That I've
The
challenged.
action, there should be a remedy, isn't it?
No, certificate, my lords, what I'm saying is, my lords,
Just
remedy.
like that, no, just like that for with a person who is unconnected with the family, if somebody gives the certificate, which is, and you say that it will have a corroborative evidence,
In the suit.
then there should be some remedy for that. For the party who is aggrieved by it.
Yes.
So you cannot say that it cannot be looked into. So that's why what I'm saying is, now in view of the disputes between the parties, and as already parties have approached the court, it has to be independently proved, and this cannot be a basis for either the trial court or any court to come to the conclusion that you are the legal heir.
Lordship would say, my lords, that it has to be proved before in the suit, my lords. Comprehensive suit is filed. That is a
Independently, it has to be proved. It will not have any value. How you have to examine the concern why he has given all this. In a way, it can't be. You yourself say it will not confer any right or in respect of any of the disputes. It will not, it can't be used in any other legal proceedings. That kind of, how can it be used?
No, it can't be used, my lords, if, my lords, there is a finding to the fact that, my lords, it is obtained by fraud. The authority has not issued the certificate in as the procedure contemplated.
Under which provision he has the authority to issue it? Please bring it to the notice of the court.
The certificate, my lords. Not under the land revenue. What they have challenged, that the appeal itself is not maintained. But I'll answer the lordship's query.
Which provision he has given the certificate?
Government would be the land revenue says 49 says if original order is passed in act itself says the act the object of the act is, my lords, land revenue related to land agricultural land or not the certificate.
The first what made them to come to the court is
Please.
a certificate is given to you. That certificate under which provision, when which authority vested with the tehsildar he has given, there should be some provision.
Yes.
Which provision is that?
No, your lordship may not reserve liberty to them to challenge it in accordance with law. But now at this under section 49, that cannot be done.
In accordance with law, that is already being dealt by the court. An issue is framed according to you.
True, my lords. The suit is pending, Lord, in respect of
In the suit, your contention would be even the tehsildar after looking at all the aspects has given the certificate. Whether can you use that certificate in a suit?
No, provided, my lords, if I prove that I am wife of so and so
Independently.
Independently.
The fact that the certificate is
Yes,
given to you.
then if I prove that,
Anyways,
Please.
in any ways, that certificate cannot be considered. That should be the finding now in this case.
no, now if lordship says that, my lords, the certificate is invalid.
I will not, I say, in the light of the disputed fact about your.
Which is pending in the suit.
With the deceased, and
has-
as the court is dealing with it, no, notwithstanding the fact that a certificate is issued, court has to independently deal with it.
Please, that's what.
Millards, then the certificate would remain, Millards. The certificate would remain, Millards.
No, the court cannot, that it has no evidentiary value. That's
I
what
am-
that would be the observation in this writ.
Yes, Millards.
No, their name is also there in the certificate.
But I am
The
disputing
tenure
that-
to the benefit of both of them. Photo ತೋರಿಸ್ರಿ madam.
The writ petition is filed.
ಇಲ್ಲ, ಇಲ್ಲ,
Seeking the following prayer. It is the petitioners are the parents of the deceased Ramachandra, and the fifth respondent is the wife of Ramachandra. It is the case of the petitioners that the petitioner's family and the father of the respondent and elders in the family have decided to conduct the marriage between the deceased Ramachandra, that is the son of the petitioner, with the fifth respondent. And the engagement function was held on 21/3/2003. And Vivaha Nichaya Yadi was executed between both families in the presence of the elders. The Ramachandra died unmarried, and fifth respondent is no way concerned or related to the Ramachandra or the petitioner. The fifth respondent has made an application to the fourth respondent seeking to issue survivor certificate contending that she is the wife of the deceased Ramachandra and petitioners are the father and mother, and requested the tehsildar to issue the certificate. The tehsildar issued a certificate dated 21/2012. In that it is mentioned that the fifth respondent is wife, even though marriage of the fifth respondent was not solemnized, and there is no reliable proof of the alleged marriage between Ramachandra and fifth respondent. The fifth respondent has made an application to the fourth respondent seeking to issue the certificate contending that she is the wife of the deceased Ramachandra and petitioners are the father and mother, and requested the tehsildar to issue the certificate. The tehsildar issued a certificate dated 21/2012. In that it is mentioned that the fifth respondent is wife, even though marriage of the fifth respondent was not solemnized, and there is no reliable proof of the alleged marriage between Ramachandra and fifth respondent.
including the name of father and mother. The certificate also contains the name of
Parents that will
petitioners.
contain. It is also stated that third respondent has issued an endorsement to the petitioner and said endorsement is non-speaking and it has no legal sanctity. Petitioners, being agreed with the certificate issued by the Tehsildar, have preferred an appeal before the third respondent. And the third respondent, after hearing both sides, allowed the appeal and set aside the order passed by the Tehsildar and remanded the matter for fresh inquiry by order dated 25/2/2019. The fifth respondent has filed a revision petition. Under which law they are doing this?
Under Land Revenue Act, that itself is not.
Has filed a revision petition under section 136(3) of the Karnataka Land Revenue Act. It is stated that the matter was adjourned from time to time. The second respondent passed the impugned order without hearing the petitioners. The fifth respondent made an application to enter her name in the property records in one agricultural land. The Revenue Authority certified mutation entry against which the petitioners have filed an appeal, which came to be allowed by setting aside the impugned order and remitted the matter for fresh consideration. It is submitted that it is the case of the petitioner that he has no other effective alternative remedy but to come before the court. Land counsel appearing for the petitioner submits that the Tehsildar, without any basis, has given the certificate, and basing on the said certificate, she is seeking the entries in the revenue records. It is further submitted that the suit that is filed by the wife seeking partition is pending before the
memo I have produced, it's a plain tender.
Senior Civil Judge Athani. That is OS number
171 of 2016.
171 of
2016.
2016. And an issue in this regard is already framed. It is submitted that the Tehsildar has no business to interfere in this disputed questions of fact and give a certificate that the respondent is a survivor of the deceased Ramchandra when the marriage itself has not taken place. Next para. Land counsel appearing for the respondent submits that the certificate that is issued by the Tehsildar is not a succession certificate, but it is a survivor what is it called? Survivor?
Lords, it's called as survivor certificate. Lords may say survivor
certificate. Already a suit is filed and an issue is framed in that regard with regard to the relationship of the respondent with the petitioners and their son. It is a contention of the learned counsel that all these issues will be decided in the pending suit. They cannot come before this court. They can't file an appeal revision against those orders, and they can't file a petition before this court. It is a submission that the trial court will independently decide all these issues between the parties, and the writ petition has to be dismissed. Next paragraph. Having heard the counsels on either side, there is a material on record. According to the fifth respondent, she is the wife of late Ramchandra. Late Ramchandra is none other than the son of the petitioners. According to the petitioners, there was an engagement ceremony performed between the petitioner and late Ramchandra, but the marriage had not taken place, and he died in the year 2011.
11 minutes.
In the year 2011.
20.
And the Tehsildar, without any basis, has given the certificate. The submission of the learned counsel for the respondent that certificate cannot be questioned before the court, and again is that a writ petition is not maintainable. This court is not able to appreciate the said submission. When an order is passed by an authority, there should be a remedy against the said order. These kind of certificates that are issued by the revenue authorities will not have any evidentiary value, and a party and when the parties are disputing, that has to be decided by the competent civil court after evidence is adduced by the parties. Now, when in this case, when the wife is claiming that, when the fifth respondent claims that she is a legally wedded wife of deceased Ramachandra, the burden lies on her. And once it is proved that she is the wife, then only should be entitled for partition. The certificate as issued by the Tehsildar cannot be a basis for the civil court to consider that the fifth respondent is a legally wedded wife of Ramchandra. Notwithstanding the issuance of this certificate, survivor certificate, as a matter is pending before the civil court has to independently deal with the issue and shall arrive at a just conclusion. In the light of the above discussion, this court is passing the following order. The parties are at in the pending suit, that is OS number so and so, OS number 171 of 2006, pending on the file of the
Senior Civil Judge Athani.
Senior Civil Judge Athani, JMFC Athani, shall decide the issue that is framed with regard to the relationship between the parties in a independent manner, not without considering the survivor the certificate that is issued by the Tehsildar. Yes.
Milords, one clarification, Milords. I did not understand whether the certificate would still remain, Milords. Please,
We are not, because your name is also there in that.
Please, Milords.
Yes.
Lordship would say, Milords, Lordship said, Milords, without considering, alone, Milords, that only on the basis of that certificate, the court can't. It can be used for a persuasive value.
That's what I'm saying. If you say that has to be considered, then we have to look into how it is granted. Then we have to go into that issue. Whether let us forget about, because you also find a revision against and one order that is.
Please,
if you say that it is not maintainable, why did you get it set aside?
No, but what the DC said was not what DC said. He relegated to the parties to the suit only.
Because the Tehsildar absolutely has no business to issue this kind of certificates.
No,
It is a case. No, I have to. If you say something else, I have to set aside that order of the Tehsildar in the light of the pending suit. That's why, without doing anything, I said it has to be independently dealt with. It cannot be the basis for the court.
If Lordship are right in saying so, Milords, the certificate is issued prior to the filing of the suit, Milords. Lordship said, Milords, such certificates have no value, Milords. That would genuinely, if there is a certificate issued, and on the basis of that.
You have to know, like all these. That's why earlier the Tehsildars used to give the succession certificates also.
Yes.
Most of the time, and they said that's not your business to deal with all this. That too, in these facts, when it was only an engagement, and according to them, there was no
in
marriage.
fact, no. Milords, Lordship see the memo, Milords. Along with the memo, what I have produced is, Milords, your Lordship would see the photographs. Your Lordship is kindly see the photographs, Milords.
Photographs will also look like a marriage photograph.
No, Milords, there is a Mangal Sutra. Yes.
Yes,
Lordship would say, Milords, nothing is said on the merits, Milords, because.
This court has not expressed any opinion on the merits of the
Yes,
matter.
please.
And whatever the discussion, the observations of this court are only for the purpose of deciding the present writ petition.
Please.
And uninfluenced by any of the observation, the court shall pass orders in accordance with law.
Great.
Grateful,
Number
Milords.
46 urgent. Final hearing matter, seal number 47. Anupji Deshpande, AGA.
Somebody was
seven.
made it, yes.
Serial 47. AG want to appear. Kindly have to next Friday, Milords.
Where is the counsel for the petition?
Anupji Deshpande.
None appears listed in the month of March.
Please.
Yes, 48.
Number 48, J. Shetty, B. Muhammad Ali, B. Kanvi.
I am appearing for the petitioner.
This also will pass over.
Oh, my lord.
We'll have it in the afternoon. Because it will take time.
Please.
We'll complete the list.
Yes.
Yes, I have pass over. Next.
Pass.
2:30 some other matter set.
No, you can come.
Yes,
Come, then we'll take up.
after finishing that.
Because there are other passovers also there.
Yes.
Seal number 49, Nisham Kulkarni.
Yes.
I'm appearing for petition, my lord. I seek a short accommodation because the senior has morning session only, they sought the time, my lord.
Accused of answer the petitioner lists this matter in the month of March.
My lord.
Yes, 50, no representation on behalf of the respondent.
Madam, interim order may kindly be extended.
Yes, in all the matters, wherever there is interim order, please extend it.
Please.
Yes, next.
Cell number 50, Prashant Matapati. Please, Durajas Balloli.
My lord, challenging the interim maintenance notes by the husband. 20,000 is, my lord, awarded. My lord, my submission is that, my lord, 5/5/2003, my lord's marriage was solemnized between.
No, what is your income?
Lords, my income is around 1 lakh, my lords.
Then what is the difficulty in
No, difficulty is that, my lords, first, my lord, the respondent has filed a divorce petition, which came to be dismissed.
Marriage was solemnized.
2003, my lord. Lords, initially, my lord, 2014, my lords, my wife has filed a divorce petition. The same came to be dismissed, my lord, with a detailed order, my lord. Thereafter, my lords, I filed a restitution petition. The same came to be allowed and directed to rejoin the matrimonial house. In spite that, my lords, suppressing earlier, my lords, divorce petition, she filed one more divorce petition. In that, my lords, she filed an application for maintenance. That came to be allowed, my lord.
All these were not discussed by the court?
No, my lords. That was not discussed by the
How can it
trial.
be, the divorce petition is filed on what ground?
That is on cruelty, my lords, and
Where is the earlier order? Let us see.
earlier I have produced, my lord.
Then you should have filed a petition before the court saying that this writ petition, the MC is not maintainable. That's what you are supposed
That
to
is
do.
what, my lords, that is what I am before this honorable court, my lord. On that ground only, initially interim order was
Filed
granted.
an IA that the MC is not maintainable?
Where, my lords?
Two issues.
Please.
The court passes an order on the interim maintenance, that is a different aspect. According to you, because earlier MC is filed on the same ground, it is submitted, there is no fresh cause of action, and the suit itself is not maintainable.
They have some
On
modified
submission, my lord.
Huh?
First petition was filed on the ground of desertion. Second one is filed on the ground of cruelty, and I'm relying on a judgment, my lord.
No, that is not required.
The
That's not
concept
required.
of res judicata will not.
Yes, that's what I'm saying.
Please.
Now, if you say after the restitution order is passed, you have united with, there is a separate cause of action for you, then
Please.
you can maintain. If he says that it is not maintainable, for him to file a petition before the court itself, that the petition has to be rejected, order 7 rule 11.
Please.
And my lords,
When it comes to the maintenance aspect, that we will not go into all those aspects.
please, please,
As for the interim maintenance is concerned, we will look at what is the income of yours,
please.
whether you are in a position to pay it or not.
Lords, in respect of interim maintenance is concerned, lords, when wife is not entitled for maintenance, my lords, there are three reasons. One is, my lords, she has to be in a relationship with the others, and my lords, if she has deserted the matrimonial house, her own. Lords, that was observed by the trial court in the divorce petition.
Mixing two issues, that
Please.
is 125 CRPC or saying about like when the wife who has voluntarily deserted. Now,
Please.
according to her, because after the restitution order is passed, she has cohabited with the husband again, and now she is claiming cruelty on the ground of
No, she was
cruelty.
never joined, my lord.
Let's see the petition. Come to the MC, present
Please.
MC.
Earlier MC, my lord.
Present.
Lords, earlier divorce petition, page number 12.
Please come to the present MC petition. Where is it? Where is the petition filed?
Lord, page number 12, my lord.
Page number?
12.
Let's see. Where is the way about, according to her, what is the cause of action?
Lords, cause of action, what is page number 21? Lords, clause 4. Cause of action, the cause of action of the action.
According to her, this is on 31/5/2018.
Please.
Let us see, when is, where is the other one?
My lord, another other one is, my lord.
Earlier, dismissed one.
Earlier. Page 60, my lord.
60.
60. This was on 15/12/2017. Divorce petition was dismissed.
Please raise that ground before the family court. That's what I'm saying. If you say that this petition is not maintainable, file an IA before the court.
Even
No
maintenance
cause of
also.
action for her,
Please,
huh?
please. Maintenance also she is not entitled. That is also my case.
Maintenance, we will not decide about the maintainability of the suit or of the MC.
But now, my lords, I had to pay maintenance, my lord. That if my lords, If I had filed that application, I had to go,
First of all, you could have filed even when you have received notices from the court.
Please.
And you say that it is not maintainable, you could have filed an application before the court, is it not? And even till now, this is which year? This is a repetition of 2023.
23.
Have you filed till now that application?
No, my lord.
Then
My lord, earlier divorce petition for a moment, page number 71. Page 71, my lord.
the court has entertained the MC, filed the IA. You cannot dispute on other aspects. If you are disputing that the MC itself is not maintainable, you have a remedy under law.
In fact, my lord, what will happen, my lord, there is, even my lord's wife can file another divorce petition also, my lord, on the other cause of action. When that is maintainable, my lord, in respect.
It will be decided not in an IA. It will be decided in a separate IA filed by you, saying that the MC itself is not maintainable, there is no cause of action for her to file the MC. That's for you to do it. In an IA, we will not decide all this. IA for maintenance, we will not decide all this.
Please, with that observation, my lord.
Now, by this order, the entire proceedings are stayed.
Please, my lord.
Is it so?
Please.
MC proceedings are stayed
Please,
from 2023.
It is not forthcoming in the order sheet, my lord, but there, my lord, they stayed all the further proceedings. Even in their prayer, they only sought for the
Where is the interim order granted?
on.
My lord, on 27/4/2023.
Please come. I'll confirm this order of 20,000 and I'll give liberty to you to.
My lord, in respect of 20,000 is concerned, my lord, earlier divorce petition for a moment. She is not entitled, my lord. That is my case. On one para, my lord, I may permitted to read. My lord, page 71, my lord.
But you are again coming back to the same point.
My lord, she herself left the matrimonial house, my lord. Sir, my conjugal my lord's petition is allowed. In spite of my lord's rejoining the my lord's matrimonial life, my lord, she filed such petition.
When was your conjugal petition allowed?
My lord, 2015, my lord, I filed, my lord, 2017 is allowed. My lord, in spite of my lord's rejoining the, my lord,
Didn't mention in this order, in this MC.
this, no, my lord, conjugal petition.
Let us look at the petition again.
Page 10, my lord, sir. As a last resort, the petitioner, page 18, my lord, sir, para 10. That means MC number is mentioned, my lord. On the ground of physical and mental cruelty in the said petition, the evidence of the petitioner was recorded.
Kindly at page number 19, para number 11, my lord, of my MC petition. It is respectfully submitted that those incidents of cruelty as narrated by the petitioner in the earlier divorce petition are entirely different from the incidents of cruelty narrated in this petition. My lord, I have already mentioned the earlier divorce petition, my lord, in this petition, present petition also.
Please come.
My lord, one para I may permitted to read, my lord. Page 71, my lord.
Agreed with the, where is the order? Page number?
Page number 58, my lord.
50?
56 to 58.
My lord, one more submission. Till today, they have not paid single rupees, my lord, from 2023.
Because no order is passed. Interim order is just like the granted.
My lord, divorce petition, my lord, page number 71, one woman, my lord.
You have children also.
Please,
Who will take care of them?
that is what, my lords, I may permitted to read one para, my lords, the cross-examination of the respondent. Then, my
No, the respondent directed to pay monthly maintenance per month to the petitioners.
my lords,
No.
she has not
let's-
filed, my lords.
No, let's forget about the wife. What will happen to the children?
Sons
Take
filed,
care
my
of
lord.
them.
They have not filed the, my lord, such maintenance.
Them also.
Only wife has filed, my lord.
Not necessary that they should all be parties.
That is what, my lords, one moment, my lords, page 69 for a moment. 69, I may permitted to, my lord. The petitioner in the cross-examination, who is the respondent, has stated that during the October 2013, she came to Belagavi to her parents' house on the occasion of Deepavali festival. She has very clearly stated that at that time her husband was in a college. This goes to show that the petitioner came over to the Belagavi along with the children without confirming the respondent, my lord. She was not informed me even, my lord, she has left. And what's next para, my lord, she has admitted that on every Saturday and Sunday in a month she used
The
to stay.
council forget about the wife. What about the children? You have a responsibility to maintain them. You earn 1 lakh. What is the difficulty in paying
But in respect
20,000?
of children also, my lord, page 71, my lord, here at para 6
No,
of
with
the
the wife
cross-examination, she admits that for the past 2 years she has not allowed her husband to see the face of their children, my lord.
Please come. The petition is agreed with the order that's passed in I number 2 in MC number 344 of 2018, passed by the Family Court Belgavi, whereby the Family Court has granted monthly maintenance of rupees 20,000 per month. The parties are referred to as wife and husband for the sake of convenience. It is a case of the petitioner husband that the marriage has taken place on 5/5/2023. The wife had filed MC number 314 or 24? 2014. What is the number?
344.
14 or 24?
344 of 2018.
14, 3?
My lord, 324 of 2014.
4 of 2014. Before the Family Court Belgavi seeking divorce. The petitioner in the year 2015 has filed a petition for restitution of conjugal rights. That is MC number 27 of 2015 before the senior civil judge Gandhin. What is that? What is that? How do you spell it?
My lord,
Where did you file the restitution petition? Gandhin?
Gadinglas.
Gadinglas.
Huh?
Gadinglas.
Maharashtra.
On 27/10/2016, the court had decreed the petition that's filed by decreed the MC that is filed seeking restitution of conjugal rights. And the MC that is filed by the wife the restitution of conjugal rights was allowed on 27/10/2016, and the MC that is filed by the wife on the ground of for divorce was dismissed on 15/2/2017. It is a case of the husband that after failing all the attempts not that. It is stated that the husband has made all the efforts to requesting the wife to join him, but the wife, without joining the husband, again filed the present MC on 18/6/2018, seeking maintenance, seeking divorce, and also in that she has filed an IA seeking interim maintenance. Learned counsel submits that the petitioner, next part, the learned counsel submits that the wife is not entitled for maintenance when once her petition for divorce is dismissed. On the very same cause of action, once she has filed it on the ground of desertion, now the second petition is filed on the ground of cruelty. The court ought not to have entertained the said MC filed by the wife and ought not to have granted maintenance of an amount of rupees 20,000. It is submitted that the wife who has deserted the husband is not entitled for any maintenance, and the IVA that is filed under section 24 of the Hindu Marriage Act ought to have been dismissed by the court. Next para. When counsel appearing for the respondent submits that the wife can maintain MC for MC on the ground of cruelty. Earlier one is filed on the ground of desertion. It is submitted that the wife is taking care of two children.
Please.
Two or one? Two children, and so
13 and
far
15.
the husband has not paid any maintenance, and he has failed to discharge his obligation towards the children and the wife. It is submitted that the court had considered all the aspects and had rightly passed an order, and the wife is not entitled. The wife is entitled for maintenance. Next para. Having heard the counsels on either side, there is the material on record. This court has perused the order that is passed by the family court. Family court has not considered any of the contentions that are raised by the petitioner. If, according to the petitioner, there is no cause of action for the wife to file a petition seeking divorce, the petitioner could have filed an appropriate application before the court seeking stating that the said MC is not maintainable. Admittedly, no such application is filed by the petitioner husband. Without even going into the aspect of relation between the wife, the husband, the earlier litigation, and all other aspects, the fact it remains in the wedlock, they are blessed with two children. The husband has a responsibility towards the children. It is also an admitted fact that the husband is not contributing anything towards the welfare of the children. What is the age?
15 and 17 as of now.
The children are aged about 15 and 17. The husband's income is 1 lakh.
80,000.
Huh? You said 1 lakh.
80,000 minutes.
Huh?
80,000 anta ide.
80,000 in 2023. It is stated that his income is 80,000 as on 2023. The husband has an obligation to take care of the interest of the children irrespective of the disputes between the parties. Secondly, when all these contentions are raised, the court ought to have considered all these aspects and should have passed a reasoned order. In the light of the above discussion, this court is passing the following order. The petition is at liberty to file an appropriate application before the court with regard to the maintainability of the present petition, and the same has to be considered by the court in accordance with law. Number 2, as far as the children are concerned, and considering the income of 80,000 of the husband, he has to the amount of maintenance of 20,000. The children are entitled, and as such, this court is of the view that the husband shall pay an amount of rupees 20,000 as ordered by the court. The order impugned is set aside, and the court shall consider the same after the court shall consider the respective contentions of the parties and pass an appropriate order. Till such time, the petitioner shall continue to pay an amount of rupees 20,000 towards the children. All the arrears, if any, at rupees 20,000 shall be paid within a period of 2 months from the date of receipt of the copy of the order. If the husband fails to pay the amount, the wife is at liberty to file an application before the court under section 151 CPC to strike off the defense.
Please.
Yes.
May I make a submission? My Lord, serial number 39, I'm a party therein. May I request it to be taken next week?
What happened to that?
It is passed over.
It is passed over in the afternoon.
Why it can't be argued today?
Yeah.
So the difficulty is the matters which are out of the list, they will not come again before this side of the roster. If you want adjournment, I'll give it only in the month of March, not before that.
Next week, next one,
The list is matter on 17th of February.
please.
17th.
Obliged, highly obliged.
Please.
Please call the next question.
List number 2.
The interim order may kindly be extended.
Interim order.
Interim order.
Please give that list. Here it is there.
List
Call the list.
2. Orders matter serial number 1. Chandrasekhar M. Hosmani. Chandrasekhar M. Hosmani.
For the appellant, responded.
The petitioner, the appellant shall do the needful within a period of 2 weeks, or else the appeal shall stand dismissed without further reference to the court. Yes, next. This also same. Number 2 also, the step shall be taken within a period of 2 weeks, or else the appeal shall stand dismissed.
Serial number 3.
In this case, my lord, appear for the petitioner.
Mahesh Vodaya.
This seems that my lord, respond number 16 has expired. Take steps, my lord, 2 weeks.
In the 3, for taking steps against deceased R6, 3 weeks time is granted.
Lord,
Or else
so
the
far as-
appeal shall stand dismissed against R6 as a 16 as abated.
So-
Then with regard to R4, R5,
5,
R11,
11, 12, my
R12,
lord, 1 week time, my lord.
a week's time.
Lord.
If the process is not paid, the appeal shall stand dismissed against those respondents. Then
That's-
what about R27 for third time?
R27, my lord, I'll file, my lord, I pay
Process shall
the
be
process
paid.
deficit,
1 week.
with deficit to 25,000.
Whatever it is, within 1 week,
Yes.
it's also default order.
File.
Yes. Next.
Serial number 4. Some Kalwad.
Yes, this also a week's time, default order. 5.
Serial number 5. Awaited.
Give that.
Withdrawal.
I'm sorry, in the third matter, interim order to be extended.
In all the matters, if interim order is there, extended till the next date.
Ganpati Ampat. Serial number 5. List number 2.
The memo is filed seeking to withdraw the writ petition. As the petitioner has an alternative remedy to approach the Karnataka Appellate Tribunal against Dharwad passed under section 39 and 41 of the Karnataka Sauhardra Sahakari Act 1997. Accordingly, the memo is taken on record and the petition is dismissed with the liberty to avail the appropriate remedy.
Serial number
Within
6.
a period of 1 month from the date of receipt of the copy of law.
Kind permission. Sale number 4, my lord. R2 is the SLO, my lord. He may be directed, take notice for this number 2. In sale, previous matters, sale number 4.
Respond number 2 is
In respect to
written by the
R2, my lord,
state.
steps to be taken.
R2
Is the SLO.
It's for the
government
state.
advocate.
AGA takes notice.
AGA.
Please.
Yes, in 4, it is for R2, notice to R2. And AGA is directed to take notice on behalf of R2.
Please. Next week.
Then there is I number 1 of, this is the land acquisition matter. Yes, this matter list next week.
Next.
Please.
Yes,
Please.
next.
Serial number 6. Urgent. Serial number 7.
Notice may kindly be dispensed with minutes.
Which one?
Serial number 7 minutes. Minutes, it's only a mandamus minutes to the trial court minutes to fix a date or expeditiously proceed with the matter and dispose of the suit minutes. What has happened minutes? A suit was, yes, please.
On dispose of as expeditiously as fixing a.
Only
time
that
frame of
relief
the
is
trial
concerned.
court. Which year is the suit?
Minutes, suit is in the 2019 minutes. Minutes, what has happened minutes during the pendency of the suit minutes? The defendants minutes have sold the property, and to that extent also minutes.
We have to find out this particular court, which year matters they're dealing. Yes, put on sir. As a registrar judicial to find out this, what are the oldest matters pending in this court. Yes, this is matter next week.
Next.
Yes, after lunch.
And any date minutes of lordships.
No, next week it will come.
In preliminary.
This signatures.
7. Obliged.
ಮತ್ತದವನ ಇದ್ರ ಮೇಲೆ ಮತ್ತದವನ ಇದ್ರ ಮೇಲೆ ಮತ್ತೇನು ಪೆಂಡಿಂಗ್ ಏನಂದ್ರದ್ದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಇದು ಲಿಸ್ಟ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 2 CMP ಧಾರವಾಡ ಪ್ಯಾನಲ್ ಆರ್ಬಿಟ್ರೇಟರ್ಸ್ ಕೊಡ್ತೇವೆ.
ಲಿಸ್ಟ್
ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 2 CMP ಅಪಾಯಿಂಟೆಡ್ ಆಫ್ ಆರ್ಬಿಟ್ರೇಟರ್. ಧಾರವಾಡದ ಒಂದು ಪ್ಯಾನಲ್ ಇದೆಯಲ್ಲ ಆರ್ಬಿಟ್ರೇಟರ್ ಅದನ್ನೇ ಕೊಡ್ತಿರಲ್ಲ
ಸೀರಿಯಲ್ ನಂಬರ್ 2 ರೀ ಥರ್ಡ್ ರಿಸರ್ವ್ ಆಗಿದೆ
ಹೇಳ್ರಿ ರಿಸರ್ವ್ ಆಗಿಲ್ಲ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಆರ್ಬಿಟ್ರೇಟರ್ ಇದೆ. ಸೊ ನಾ ಎನಿಬಡಿ ಫ್ರಮ್ ದ ಪ್ಯಾನಲ್ ಅಂತ ಧಾರವಾಡ ಲಿಸ್ಟ್ ಕೊಡ್ಬೇಕು.
ಅದೇ ಧಾರವಾಡದಾಗ ಆರ್ಬಿಟ್ರರ್ ಇಲ್ಲಿ ಧಾರವಾಡದಾಗ ಕೊಡ್ಲೆ
ಧಾರವಾಡದಾಗ ಕೊಡಿ. ಅದೇ ಅದರ್ ಸೈಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್ ಸರ್ ಅದು ರೆಫ್ಯೂಸ್ಡ್ ಆಗಿದೆ.
ರೆಫ್ಯೂಸ್ ಆಗಿ ಸರ್ ಆರ್ಬಿಟ್ರೇಟರ್ ಯಾರಿಗೆ ಆರ್ಬಿಟ್ರೇಟರ್ಗೋಸ್ಕರ ಬಂದಿದೆ ಯಾರ ಹೆಸರು ಹೇಳ್ಬೇಕಾ?
ನಾನು ಹೇಳ ಅವ್ರಿಗೆ ಬಿಟ್ಬಿಟ್ಟೆ ಎನಿಬಡಿ.
ಅದೇ ನಾವೇ ಕೊಡ್ಬೇಕು ನಮ್ಮ ಕಡೆ ಇದೆ ಲಿಸ್ಟ್ ಅದ್ರಲ್ಲಿ ಯಾರು ಒಬ್ರು ಕೊಡ್ತೀನಿ
ಕೊಟ್ರಿ
ನಿಮ್ಗೆ ಕೇಳಿದೆ
ಧಾರವಾಡದವ್ರು ಯಾರು ಆದ್ರು
ಧಾರವಾಡ ಲೋಕಲ್ ಇದ್ದವ್ರು ಕೊಡ್ಬೇಕು ಹೇಳ್ತೀನಿ ಹಾಕಿಸ್ತೀನಿ. ಮೀಡಿಯೇಟರ್ಸ್ ಲಿಸ್ಟ್ ಅಂತ ಇದೆ ಇಲ್ಲಿ.
ಮೀಡಿಯೇಟರ್ ಬೇರೆ ಆರ್ಬಿಟ್ರೇಟರ್ ಬೇರೆ ಕಾಣುತ್ತೆ.
ಆರ್ಬಿಟ್ರೇಟರ್ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜಸ್ ಇರ್ಬೇಕಲ್ಲ ಹಾಕೊಂಡು ಸರ್ ಅಥವಾ ಮುರಾರಿ AP ಮುರಾರಿ ಸರ್ ಮಿತ್ತಲ್ ಕೊಡ್
ಹಾಕಿ ಮೆಟಲ್ ಕೊಡು ಯಾರು ಬೇಕಾದ್ರೆ ಹಾಕಿ
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್
ಕೊಡಿ ಸ್ವಲ್ಪ ಲಿಸ್ಟ್ ಕೊಡಿ ನೋಡ್ಲಾ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 39 ಡೇಟ್ ತಗೊಂಡ್ರಿ ಸರ್ ಮಿಸಾಳೆ ಸರ್
17 ಫೆಬ್ರವರಿ
ಸರ್
17 ಫೆಬ್ರವರಿ ಡೇಟ್ ಹೋಯ್ತು ಸರ್ ಅದು
ಆಯ್ತಲ್ಲ
ರಮೇಶ್ ಸರ್ ಬಂದು
ಅಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಆಗಿತ್ತು ಅದಕ್ಕೆ
ಪಾಸ್ವರ್ಡ್ ಆಗಿತ್ತು ಡೇಟ್ ಇಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಒಂದು ವೀಕ್ ಹೋಗಿತ್ತಲ್ರಿ
ಇದು ಮಿತಲ್ ಕೋಟ್ ಹಾಕ್ಬಿಡ್ತೀರಿ
ಹೇಳ್ತೀನಿ ನಾನು ಲಿಸ್ಟ್
ಆಮೇಲೆ ಅದ್ರ ಒಂದು
रिस्पेक्ट सर रोशन और 4 है नहीं अच्छे देखना चाहिए किताब निकाल
ಆಮೇಲೆ ಅದ್ರೊಳಗೊಂದು ಒರಿಜಿನಲ್ ಅಗ್ರಿಮೆಂಟ್ ಹಾಜರು ಮಾಡಿದೆ. ಸ್ಕ್ರೂಟಿನಿ ರೈಸ್ ಮಾಡಿದ್ರು, ಸ್ಕ್ರೂಟಿನಿ ಬ್ರಾಂಚ್ ರೈಸ್ ಮಾಡಿದ್ರು ಒರಿಜಿನಲ್ ಅಗ್ರಿಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೆ. ಅದನ್ನ ರಿಟರ್ನ್ ತಗೋಬೇಕಾಯ್ತು ಅಷ್ಟೇ. 230 ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ ರಿಟರ್ನ್.
ಹಲೋ ಲಿಸ್ಟ್ 1 ಅಲ್ಲೇ ಲಿಸ್ಟ್ 1 ಅಲ್ಲೇ 41 ಯಾನ್ ಹೌದ್ರಿ 21/1 ಡೇಟ್ ಕೊಟ್ರ ಇಂಟರ್ಮೋಟ್ ಆಕ್ಷನ್ ಡೇಟ್ 42 BBB ಅವರಿಗೆ ಆಗಿದೆ ಅಲ್ಲೇ ಕೊಟ್ಬಿಡಿ ಸರ್ 41 ನಿಮ್ಗೆ ಬಂದಿಲ್ವಾ? ಆಮೇಲೆ 21st ಕೊಡ್ಬೇಕು ನೋಡ್ರಿ ಅದು 14% ಅಜ್ಜ ಒಬ್ರು ಹೇಳಿದ್ರಲ್ಲ ಅಜ್ಜ ಒಬ್ರು 14% ಹೇಳಿದ್ರಲ್ಲ ಅದು ಡೇಟ್ ಯಾವ್ದು ಕೊಟ್ರಿ? ಚೇಂಜ್ ಮಾಡಿದ್ರ 25th ಕೇಳಿದ್ರೇನ್ರಿ ಅಜ್ಜ ಅದು ಮೇಡಮ್? ಅದು 25th ಸಂಡೇ ಬರುತ್ತೆ ನೋಡ್ರಿ ಅದು 25th ಜನವರಿ ಅಲ್ಲ ಸಂಡೇ ಬರುತ್ತೆ 27th ಕೊಟ್ಬಿಡಿ. ಅಲ್ಲ 21st ಕೇಳಿದ್ರಿ ಅವ 21st ಕೇಳ್ಯಾನವ 21st ಕೊಡಿ ಹೇಳ್ತೀನಿ 21st ಅಂತ ಹೇಳ್ತೀನಿ. ಈಗ ನಿಮ್ಗೆ 41 ಬಂದಿಲ್ಲ ಅಲ್ಲೇ ಲಿಸ್ಟ್ ಒನ್ ಎಲ್ಲ ಕಳ್ಸಿನೂ 41 ಬಂದಿಲ್ಲ.
ಅಲ್ಲೇ ನೋಡ್ಕೋಬೇಕು ಅವ್ರು, ನೋಡ್ಕೊಳಕ್ ಅವ್ರು ಗಾಬರಿ ಬೀಳ್ತಾರ ಅವ್ರು ಸರ್.
ಅಲ್ಲ ಹಾ?
ಈಸಿಲ್
ಅದ after ಮತ್ತೆ matters
ಕೇಳ್ತೇನೆ
ಲಿಸ್ಟ್ ಅಷ್ಟೇ ಮಾಡ್ಬಿಡೋಣ ಡೇಟ್ ಅದಕ್ಕೆ ಈಗ ನಾ ತಗೊಂತೀನಿ ಫೈಲ್ಸ್
ಎಷ್ಟು ಹೇಳ್ರಿ ಸರ್ ನಂಬರ್ ಅದು?
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಅಲ್ಲ ನನ್ಗೆ ಇಲ್ಲಿ ಹೇಳ್ಬೇಕು ನೀನು.
ಅದು ಮೇಲೆ ಇಟ್ಬಿಡ್ತೀನಿ ಸರ್ ಇದು
ಹಾಕ್ರಿ, ಹಾಕ್ರಿ. ಅದು ಇದಾದ್ ಬಿಡ್ರಿ ಅದ 18 ಅಲ್ಲ ಹೋತದ 18 ಫೆಬ್ರವರಿ 18 ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರು. ಹೌದು ಹೋತಾರ ಅದು ಆರ್ಡರ್ ಕಾಪಿ ಐತಿಲ್ಲ
ಐತಿ ಡಿಸೇಬಲ್. ಇದು ನನ್ನ ಹತ್ರ ಇಟ್ಕೊಂತವ್ರು ಬಂದಾಗ ಹಾಕೊಂಡು
ಯಾವಾಗ ಬರ್ತಾವ
ಹಾಕ್ಬೇಕು ಸರ್ ಒಂದ್ಸರಿ ಹಾಕಿ
ಒಂದು ಸಲ ಅಲ್ಲಿ ಭಾಳ ಸಲ ಬರ್ತದೆ.
ಅಲ್ಲ ಸರ್ ಅದು ಬರ್ತ
ಯಾವಾಗ ಬರ್ತಾವ ಹಾಕ್ತಾನೆ ಇರೋದ್ರೊಳಗೆ.
ಹೌದು
ಅಲ್ಲ ಇದು ಒಂದೇ ಬರ್ತಾ ಪದೇ ಪದೇ ಬರಲ್ಲ. ಒಂದೇ ಬರ್ತ ಒಂದೇ ಸರಿ ಬರೋದು.
ಇದು ಒಂದ ಕಾಪಿ ಹಾಕೊಂತಿರೋ.
ಈಗ ಹಾಕ್ಬಿಡ್ತೀನಿ ನಿನ್ನ.
ಅಲ್ಲ ಅವನು ಒಟ್ಟು ಚೇತನ್ ಮುನ್ನೋಳು ಇಲ್ಲೇ ಬರ್ತಾವ ಮೇಲೆ ಎಲ್ಲ.
ಹೌದು ಮತ್ತೆ ಅವ್ರಲ್ಲ 6 ಮಂದಿ ಅದಾರ
ಚೇತನ್ ರಘುವೀರ್ ಸತ್ಯಗಿರಿ
ಎಲ್ಲ ಒಂದೇ ಹೆಸರು ಬರಬೇಕಿಲ್ಲ ಒಬ್ರು.
ಇಲ್ಲ ಇದು ಈಗ ಅದು ಇದನ್ನ ಕಳ್ಸಿವ್ರಿ ಕಾಮನ್ ಆರ್ಡರ್ ಕಳಿಸ್ತಾರ ಅವ್ರು. ಇದು ಈಗ ನಿನ್ನೆ ಅರ್ಜೆಂಟ್ ಅಂತ ಹೇಳಿ ಮಾಡಿವಿ ನಾವು.
ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಇತ್ತಂತ ಹೇಳಿ ಮಾಡ್ಸಿದ್ ಸರ್.
ಸರ ಯಾರ್ಯಾರು ಗೊತ್ತಾ? ಚೇತನ್ ಮುನ್ನೋಳಿ, ಸುರ್ಪುರ್
ಸೆಂಡ್
ಕುಲಕರ್ಣಿ,
ಮಾಡೋಣ.
ಲೋಕೇಶ್ ಹೆಗಡಿ, ಸಂಗ್ರಾಮ್ ಕುಲಕರ್ಣಿ.
ಆ ಕಾಪಿ ನಾನು ಸೆಂಡ್ ಮಾಡ್ತೀನಿ.
ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ, RM ಕುಲಕರ್ಣಿ. CRC ಬೇರ್ಸ್ ಇರ್ತಾರಲ್ಲ ಇದ್ರಾಗ. ಅದೇ ಅದೇ ರೀ ಅಲ್ಲ CRC ಬೇರ್ಸ್ ಇರ್ತಾರ.
ಪವರ್ ಲೋನ್ ಮಾಡಿ
ಕ್ಲಾಸ್ ಬಿ ಬರ್ತದಲ್ಲ ಸರ್ ನಿಮ್ದು.
ಮತ್ತೆ
ಕೇಳ್ಬಿಡ್ರಿ ಅದ ಸರ್. ನಾಳೆ ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ನಾ ಹಾಕಿಬಿಟ್ಟಿವಿ ಅದಕ್ಕೆ.
ಎಷ್ಟದ ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಎಷ್ಟದ ನಾಳೆಗೆ?
ಒಂದು 40 ತನಕ
ಡೇಟ್ ಲಿಸ್ಟ್ ಕೊಡುವಂತದ.
ಒಂದು 40 ತನಕ ಅದಕ್ಕೆ
ಇಲ್ಲಿ ಬರುತ್ತೆ.
ಅಲ್ಲ ನಾನು ತೆಗೆದು ಕಳಿಸ್ತೀನಿ.
ಡೇಟ್ ಮ್ಯಾಟ್ರ್ಸ್ ಒಂದು ಲಿಸ್ಟ್ ತೆಗಿ.
ಅಲ್ಲ ಅಲ್ಲಿ ತೆಗ್ದಿವಿ ಕಳಿಸ್ತಿತ್ತು ನಾನು. ಕಳಿಸಿವಲ್ಲ ತೆಗ್ದಿವಲ್ಲ ಅಲ್ಲಿ ನೀವು ಕೇಳ್ಬಿಡ್ರಿ ಲಿಸ್ಟ್ ಹಿಂಗಂತೇಳಿ. ಯಾರು ಮಾಡೋದು ಬೇಡ ಒಂದೇ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ.
ಒಂದ ಮಾಡೋದು ಮಧ್ಯಾಹ್ನ No. 4 1 ಯಾವ್ದು ಯಾವ ನಂಬರ್ ಇರುತ್ತೆ ಸರ್ ಅದು?
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಕರೆಸ್ಬೇಕು. ಬ್ರಾಂಚ್ ಬ್ರಾಂಚ್ನವ್ರು ಕಳಿಸ್ತಾರೆ. ಸರಿ ಸರ್, MFA ಬ್ರಾಂಚ್ ಅಲ್ಲ ಅದು? ಇವ್ರೆ ಲಿಸ್ಟ್ 2 ಇವತ್ತು ಕಾಲೇಜಲ್ಲ ಇವತ್ತಿನ ಕಾಲೇಜಲ್ಲಿ ಏನಾಗಲ್ಲ ಇಲ್ಲ ಏನಾಗುತ್ತೆ ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ ಸ್ವಲ್ಪ ಹಂಗೆ ಹೋಗಿ ನೋಡೋಣ ಅದು ಬಿಬಿಬಿ ಎರಡು ನಂಬರ್ ಬರೆಯೋ. ಬರೀ ಅವನೇ ಮಾಡ್ತೀನಿ ಫೈಲ್ ಹಂಗೆ ನೋಡ್ಬಾರ್ದು ಕಟ್ಟಿವಿ ಅದೇನು ಅಂತ ಹಂಗೆಲ್ಲ ನೋಡ್ಬಾರ್ದು ಸರ್. ಅದು ನಯೇ ಇಂಕ್ಲೂಡಿಂಗ್ ಸಿಲೆಬಸ್ 12ದಲ್ಲಿ. ಹಾಂ ಸರ್. GM 10 ಎರಡು
ಇದಲ್ಲ ಮತ್ತೆ ಇದು ಇರೋಗ್ಬೇಕಂದ್ರೆ ವಿಜಯ್
ಡೇಟ್ ಇಲ್ಲ ಓಕೆ. ಟ್ವೆಲ್ 120 Sir, list continue. Sir, 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 list 2 continue. List 2.
ఇది సబ్జెక్ట్ వైజ్ వచ్చారండి అదన్నా మీ డేస్
No, sir. ಮತ್ತೆ ಮೆಮೊ ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಫೈಲ್ ಹೆಂಗ್ ಬರುತ್ತೆ ನೋಡಿ. ಎಲ್ಲಿ ಕಳಿಸ್ತಾರ ಅವ್ರು? ಅಲ್ಲಿ ಕೆಳಗೆ ಹೋದ್ರೆ ನಮ್ಮ ಫೈಲ್ ಕೊಡಂಗಿಲ್ಲ ಅವ್ರು ಮೆಮೊ ಬರಲಿಲ್ಲ ಅಂದ್ರೆ. ಫ್ರೆಶ್ ಫೈಲ್ ಮಾಡಿದ್ದು ಫೈಲೇ ಕೊಡಂಗಿಲ್ಲ ಅವರು. ಸ್ಕೂಟಿನ ಮಾಡಂಗಿಲ್ಲ ಫಸ್ಟ್ ಆಫ್ ಆಲ್.
ಹಂಗ ಬಿದ್ದಿರ್ತಾವ.
ಹ್ಞೂ ಸರ್.
ಇಲ್ಲಿ ಕೊಟ್ರ
ಹೌದು, ಇಲ್ಲಿ ಮೇಲಿನವ್ರ ಆದೇಶ ಹೋದ್ರೆ ಬರೋದು ಅದು.
ಸರ್
ಸರ್ ನಿಮ್ಮ ಕೇಸ್ನಾಗ R1 ಅಪೀರ್
ಅದು 9. ಹೌದಾ? ಸೊ 3ರಿಂದ 7 ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿಸ್ತೇನೆ ನಾನೇ.
ನಾವು ಕಾಂಟೆಸ್ಟ್
ಅದೇ 1 and 2 ಕಂಟೆಸ್ಟಿಂಗ್. ನಾನು ಫಾಸ್ಟಾಗಿ ಹೇಳಿದ್ದೆ ಅಲ್ಲ 3
ಹೌದು ಅವ್ರು ಸ್ಕೂಟಿಂಗ್ ಮಾಡಂಗಿಲ್ಲ ಲೀಟ್ ಬಿಡ್ತಾರೆ ಸರ್. ಎಲ್ಲ ಬರ್ತಾವ ಅಂತ ಹೇಳಿದ್ರು ಸೆಷನ್ ಸಾಹೇಬ್ ಹೇಳ್ತಾರೆ ಅವರು ಹಂಗೆ ಅವು ಬರೋಂಗಿಲ್ಲ. ಹೌದು ಸರ್
ಇವತ್ತು ಬೇಕು ನಾಡ್ದಕ್ಕೆ ಬರ್ತಾವೆ.
ಈಗ ಕಮಿಟಿ ಇರ್ತಾರೆ ಸರ್ ಅಧ್ಯಕ್ಷರಿಗೆ ಹೋಗಿ ಬಟ್ಟಾಗಿ ಅಂತ ಹೇಳಿ ಎಲ್ಲ ಸಮಸ್ಯೆ ಆಗ್ತೈತಿ ಎಲ್ಲ ಕೋರ್ಟ್
ಇಲ್ಲ ಸ್ಕೂಟಿ ಮಾಡಲ್ಲ ಕೆಳಗೆ ಸ್ಕೂಟಿನ ಮಾಡಲ್ಲ.
ಹೌದು ಅಲ್ಲಿ ಹುಡುಕ್ ನೋಡ್ರಿ ದೂರ ಬರೋಂಗಿಲ್ಲ ಸರ್ ಅವ್ರು ಮೊನ್ನೆ ಹೇಳಿದ್ರು ಬೇಲ್ ನಮ್ಮ ಒಂದು ತಿಂಗಳದು ಬೇಲ್ ಬರೋವಲ್ಲ. ಇವತ್ತು ಕೊನೆಗೆ ಒಂದು ಮಾಡ್ತೀರಿ ಸರ್.
ಸೋದಿ ಇದ್ದಾಗ ಅಲ್ಲ ಸೋದಿ ಇದ್ದಾಗ ಫಸ್ಟ್ ಎಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಸಾಹೇಬ ಹೆಂಗ್ ಮಾಡ್ತಿದ್ದ ಸಿಟ್ಟಿಂಗ್ ಇದ್ದಂಗ 12 ಗಂಟೆ ತನಕ ಸಡನ್ ಆಗಿ ಎದ್ದು ಆಫೀಸ್ ಒಳಗೆ ಸ್ಟ್ರಿಕ್ಟ್ ಅದೇ ಚೆನ್ನಾಗಿರ್ತದೆ. ಇವನ್ ಜಡ್ಜ್ಗಳು ಚೇಂಬರ್ ಹೆದರ್ತೀವಿ. ಒಂದು ದಿವಸ ನಮ್ಮ ಮಾಡಲಿಲ್ಲ 2 ದಿವಸ
ನಾವು ಬರ್ತೀವಿ.
ಅಲ್ಲೇ ಸಸ್ಪೆನ್ಷನ್ ಅಲ್ಲೇ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತೀವಿ. ಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಸಸ್ಪೆನ್ಷನ್ ಆನ್ ದಿ ಸ್ಪಾಟ್. ಅದಕ್ಕೆ ಟೀ ಕುಡಿಯೋಕೆ ಆಮೇಲೆ 10 ರೂಪಾಯಿಗಿಂತ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ.
ಏನು ಹೇಳಿದ್ರಿ? ಹ್ಞೂ ಸರ್. ಮಾಡ್ತಾರೆ ಅಷ್ಟಾದ್ರೂ ಸಾಕು. ಎಸ್ ಎಸ್ ಥ್ಯಾಂಕ್ ಯು. ಬಟ್ ಹ್ಞೂ ಸರ್ ಇದು ತಗೋತಿದ್ರು ಮೇಡಮ್ ಎಲ್ಲ ಯಾಕೋ ಇದ್ದಾಗ ಯಾಕೋ ಟೇಸ್ಟ್ ಚಲೋ ಡಿಸ್ಪೋಸ್ ನೀವಿದ್ರಲ್ಲ ಅವಾಗ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲೇ.
That's one submission, Lords. List number 1, serial number 2, my Lords, CMP petition. My Lords is pleased to hear the matter and reserved for orders. In that, my Lord, as per the scrutiny branch requirement, there was a direction to produce the original dealership agreement. That may kindly be ordered to be returned to the petitioner.
Serial number?
2, my Lord, under list number 1.
One. What do you want in this?
In this, my Lord, the scrutiny branch has raised the objection to furnish the original dealership agreement containing the arbitration clause that I have submitted on 21/4/2025. That may kindly be ordered to be returned to the petitioner.
Right, yes, even the original agreement.
Yes, my Lord.
Agreement by way of a memo, the same may be returned, which is a reserved matter.
Much obliged.
Yes. Continue the list. We'll call the passwords later.
Well, it has shown that await some service of summons, my lord.
After service of notice to.
Next week, 2 days back, the notice has been served, my lord. Acknowledgement are yet to be received. Kindly be taken next week.
That's what, once it is received, it will be listed.
Please, ma'am.
List this matter after service of notice on Art 13. Yes, 18. 8 also same.
For the petitioners. In this matter, I have filed wakalat on behalf of respondent number 1.
3 to 7, my lord, only for.
R.H. Changdi.
Serial number 9.
9, yes.
For respondent number 1.
3 to 7 are formal parties, my lord.
R1 and R2 you have filed.
Only R1, my lord.
R1. What about R2?
R1 and R2 are contesting, both are, my lord.
No, he says he's representing only R1.
It's awaiting notice, my lord, R1, R2.
Mr. So-and-so submits that he has instructions to appear on behalf of R1.
Yes.
R1 notice is awaited. Then what about R3 to
R3, they are formal parties, my lord. Even in the cost title, I have stated that they are not necessary parties.
Let's see, where is it?
In the cost title itself, my lord, I have mentioned, they are only formal parties. Note type.
It is stated in the cost title itself that the respondent 2 to 7 are formal parties. And only the contesting parties for respondent number 1 and 2. Hence notice to R3 to R7 not necessary. Yes.
So interim order.
Interim order earlier granted is extended to the next date of January.
Please.
This is yesterday's matter. Lord, corporation was directed, my lord, to furnish, my lord, certain information, Lord, regarding, my lord, on the interim order granted by this honorable court. Lord, Advocate Prashant Tesich was directed to accept notice, and my lords.
I'm online, my lords. I appear for the corporation in this matter.
Yes.
My lords, kindly look into the interim order that was granted on the last occasion by this honorable court.
Yes.
It has, may I read the paragraphs, my lords? the second para. Learned counsel appearing for the petitioner would only submit that this court has already negated the applicability of the judgment in Secretary State of Karnataka and others, and others, and the circular dated 4/9/2013 itself was issued on the basis of the said judgment. Next sentence. Considering the submission made, the respondents are restrained from terminating the petitioners from service till next date. The next interim order is, in case the petitioners are occupying the quarters of the respondents, they shall not be dispossessed till the next date. My lords, the first submission here is, I am the corporation which engages an agency for appointing of contract workers. I am not in charge of either terminating or appointing any of these workers. In fact, he has to make the contractor party to ensure that there is enforceability of this interim order. I hold no control over these contract workers. The second interim
Now
order
the
may be
direction
applicable.
is given to whom?
Direction is to the respondent corporation. My lord, facts are like this.
But
My lord, earlier, my
I
lord, this
can't
honorable
terminate
court had
anybody.
directed.
Yes.
I cannot terminate anybody, nor can I appoint anybody. These
Who are
petitioners
the
are not.
respondents, Mr. Come to
The
the
respondent is the KPCL.
Let's see. Respondent is Managing Director, Karnataka Power Corporation.
Yes, my lord, that's me.
Engineer, Karnataka Power Corporation.
Yes, my lord. And second respondent is the chief engineer, who is also of the KPCL. I have no disagreement there. I am saying we engage the services of the contractor, who in turn engages the services of these contract workers to conduct certain works for the corporation. Therefore, if there is to
Who has
be
engaged you?
That is misleading, my lord. These certain facts,
no,
my lord,
no,
I
no,
have to
no, no, no,
clarify.
please don't say that.
My lord, the issue is like this, my lords. Earlier, this honorable court had referred, my lord, the matter to industrial tribunal. Lord, for adjudication of the, my lord, the issue, my lord, whether there exists an employer-employee relationship between the respondent corporation and the petitioners. At ink page, my lords, your lordship may kindly come to.
Come to this 19/6/2025 endorsement.
Exactly.
My lord, this endorsement is issued in the contempt proceedings.
No, come to that, your question.
Please, my lords.
Page number.
33, my lords.
I may request the other side counsel to start from para 10 of page 32. That will assist the court better, my lords.
I will start from para 10.
May begin starting from page 32.
This being the
which actually
factual
makes a reference
situation,
to the Supreme Court
in
judgment
this
of
regard,
Devi.
I'm reading. Correct.
Yes.
In this regard, the government of Karnataka has issued a circular dated 4/9/2013, wherein it is made clear that in all cases of regularization of workers, the guidelines issued by Supreme Court in Devi was the state of Karnataka has to be followed. The relevant portion of the judgment extracted in the circular states as follows. It is clear that adherence to rule of equality,
To the next
please,
paragraph. That's not relevant.
therefore consistent with the, my lords, will come, my lord, to the next part. Hence, in light of the above guidelines, which clearly stipulate that all decisions to regularize and absorb any temporary or contract employees must be in accordance with the principles enshrined in the Constitution. Any decisions or directions for regularization which run counter to the same would stand denuded of their status as precedents. By considering the above explained facts and law enumerated in the above paras and its reasons, the claims for absorption and regularization of your, that is, first party workmen services in ID number 55/2007 cannot be considered in accordance with law, and hence it is rejected. I will state certain facts. My lord, in ID 55/2007, this issue was referred by this honorable court for adjudication of employer-employee relationship. My lord, the industrial tribunal, my lord, held that, my lord, there exists an employer-employee relationship between the petitioners and, my lord, the respondent corporation, and, my lord, directed to regularize our services in accordance with law.
No,
That
no,
order,
no,
my
no.
lord, is
That's an
page,
incorrect
my lord,
statement.
194.
My lords, I want to correct my learned
I'm
counsel.
taking ink
There
page
is no
194.
direction. There is no direction to regularize. May,
So
if
let
I
him
kindly turn to
show.
page 194, we'll read the
Counsel for
directions
the
very carefully.
respondent. Let
My
him
lords?
show. If he's saying something, he has to show it to the court.
Grateful, my lord.
Let's see.
Grateful.
Let's see.
Ink page 193, my lords.
Yes.
My lord, the last portion, my lord, from 6 lines, therefore, under these circumstances.
Where is the starting of that order?
My lord, starting, my lord, is.
Order is at page 194.
The conclusion. My lord, starting is at 138.
Yes, let's see.
138. My lord, there are 13, my lord, claimants. The same parties, my lords.
So who is he? The Prakash Gavaskar, class 3 contractor, KPC Colony.
My lord, respondent number 1, my lord.
No. Probably that is your case that through these 3, 4, 5, 6
No,
contractors.
this issue is settled, my lord. Now issue is settled. Now we are no more contracting, my lord, laborers. This labor court has held that we are the employees of the respondent corporation. I will take your lordships directly, my lord, to ink page 193.
Yes.
193, my lords, last 6 lines.
Yes.
It starts with therefore. Bottom, my lord, last 6 lines. Therefore, under these circumstances and upon appreciation of entire materials on record, I hold that the first party workmen have established the relationship of employer-employee between the second corporation and these first party workmen, and they are working directly under the control and supervision of the officers and engineers of the second party respondent corporation, and hence the first party are entitled for the relief as sought for. Hence, I answer issue 4 and 5 as indicated above. And my lord, operative portion order.
This order is dated
This, my lord, order is dated 30th June 2012.
30th June.
2012.
After that, what happened?
After that, my lord, they file a writ petition before this honorable court, my lords.
Where is that order?
That writ petition order, my lord, is at ink page 294. This writ petition order, my lord, is at ink page 294, annexure H. My lord, relevant portion, I will take your lordships to para 41, that is ink page 313.
1 minute. Page number?
313, my lords. Paragraph 41.
Yes.
This court has considered the judgments relied on by the parties. Though the petitioner corporation tried to take shelter under judgment of Apex Court in Umadevi case, the facts of the case and the documents placed on record would justify the claim of the respondents in terms of law laid down in Umadevi case. The respondents have established, that is, my lord, the petitioner in this case, have established more than 10 years of continuous service and the said services without any aid of the interim order of the court. The corporation has not raised any dispute about the qualification of the respondents. Given the fact that they were working since 1991 to 1993 and still working during the pendency of this petition, this court has to hold that respondents were discharging the duty on account of vacancy. So far as sanction for the post is concerned, it is to be noticed that petitioner is a corporation and is not required to obtain a sanction from anyone else for employing the respondents who are basically laborers. Then, my lordship may kindly come to ink page 316, operative portion. Since the demand for regularization is pending close to 20 years, petitioner corporation shall take steps to take appropriate action in terms of direction issued by industrial tribunal. Then, my lord, they challenge, my lord, this writ petition order in writ appeal.
1 minute. This order is dated?
This order, my lord, is dated February 20, my lords, 2024.
Yes. Where is the writ appeal order?
Writ appeal order, my lord, is dismissed. My lord, that is at ink page 347.
It was withdrawn, my lords.
Annexure K 347. My lord, this was connected, my lord, in the contempt petition, my lords. Contempt was filed by the petitioners, and my lord, writ appeal was filed by the respondent corporation. Both were clubbed together, but my lord, when my lord, the Advocate General, my lord, had appeared in this matter, and my lord, he was asked, my lord, to comply the order of the learned single judge and the industrial tribunal. They made a submission, my lord, that they will comply the order of the industrial tribunal and the learned single judge. And then after, my lord, 4 weeks, my lord, lapsed, they withdrew, my lord, the writ appeal, and that was dismissed at, my lord, withdrawn. That is ink page, my lord, 350. Then, my lord, contempt order is at ink page 393, my lords. My lord, now, my lord, the findings, my lord, given by the learned single judge in the earlier writ petition, my lord, have attained finality. Regarding, my lord, my Umadevi, my lord, criteria, I fit into the criteria of Umadevi judgment. They did not challenge that, my lords. They have withdrawn the writ appeal. Now, my lords, in content, my lord, after withdrawing the writ appeal, they issue endorsement, stating, my lord, that I'm not entitled for regularization. And, my lord, the division bench, my lord, reserved a liberty.
Order at 393.
Lord, 398.
93.
393 is a contempt order, my lords.
Let's see that also.
Please, my lords. Annexure, yes, 393, my lords. Relevant portion at ink page. Lords, well, read, my lord, the para 2 as well. That is very important.
This is 19/6/2025 is impugned in this writ petition.
Yes, my lords. That endorsement is issued in this contempt proceedings.
So they said that the orders are complied with. of the
Exactly.
legislature.
The order is complied in the sense, my lord, order is complied only, my lord, in so far as issuing, my lord, endorsement is concerned. But validity of endorsement, my lord, again, I approach the Honorable Apex Court, Supreme Court. They have reserved a liberty, my lord, to challenge, my lord, the endorsement before the, my lord, Honorable.
That's what, so the contempt is closed. because they
Contempt is
complied with
closed,
the order.
but, my lord, findings have attained finality. The learned
Oh.
single judge findings, that has attained finality. Now, my lord, that endorsement is issued only to overcome the findings. Because they withdrew the writ appeal, they issue endorsement just to overcome the findings. Now, my lord, they are making, my lord, the petitioner to run around the, my lord, the.
Come to that order at page number 294.
The service particulars also, my lord, highlighted at ink page 308.
So please come to page number 311. Counsel for the respondent. Yes. 311. Top
Yes,
of
my
the
lord.
page.
The court
Please
had
read
muted me. I'm just unmuted myself. 311. Should I read para 36, my lords?
Above para 36.
On consideration of these records, the court is of the view that the industrial tribunal is justified holding the respondents who were employed by the petitioner corporation, not by contractors.
So,
I read that, madam. Yes,
in the
madam.
light of, in the light of this observation of the court, and in the light of the fact that you have withdrawn the writ appeal, and now you cannot submit before the court that I have not engaged the petitioner.
No. My thread of the arguments was not on that lines. The thread of the argument was the learned counsel for the petitioner raised an allegation on the last occasion that we have violated the order of the interim order which is granted in this. My only submission in this regard was I have neither employed them nor have the opportunity to terminate them. If it is anybody who can do it, it is the persons who have employed them. So he should
No,
make
that
them.
submission of yours, is it not running contrary to the findings of the court?
I agree. I will not dispute there, my lords. Only
You can't afford to submit that now.
I will not submit. I'll retract all
You
that
have to,
submission.
you have to comply with the order.
Yes, my lords. I'm only saying then there is this cannot be affected on me because I cannot terminate them. If there is any allegation, firstly, my lords, I have instruction to state that we have not violated this interim order. That is the first statement I would like to make before this court. And if my lordship, he has a grievance in this, let him file an application with an affidavit of who has really violated the order. I will respond according to that application, my lords. My submissions are based on the instructions which I have is we have not violated the order, interim order as it is. We have neither terminated anybody nor have we put anybody out of their employment.
So according to you, you can submit something contrary to the an order that is already attained finality, which you didn't even want to pursue.
My lords, I would like to make my submissions on the argument whether it has attained finality during my merits. But what I would like to submit here is, my lords, if one turns to the contempt order, which is at page where it was disposed of, my lords, may kindly turn to the order of the contempt order.
We don't have to mix up all these issues.
No. It is important. Just
no. Please understand. Please understand.
Yes.
One,
Yes,
the order passed by the learned single judge, where they have said that you have engaged them, and that finding you have not questioned. You have questioned and you have withdrawn. That means you are accepting it.
My lords, if my lordships may kindly turn to page 398, my lords. It is the order of this honorable court by the division bench in the contempt proceedings. If one may read that. Page 398, my lords. My lordships has a page 398.
Yes.
Having regard to the endorsement dated 19/6/2025.
I've read it.
May I just submit this? I would just like to impress upon this court one fact, my lords. Having regard to the endorsement dated 19/6/2025, issued to the petitioners, we are satisfied that the same would meet the directions issued by the learned single
We'll
judge.
ask the Advocate General to appear in this and say what he wants to say. We'll ask the Advocate General.
My lords.
Advocate General has submitted before the division bench. We'll ask them, like, can the government take this kind of counter stance?
No, I'm not on that, my lords. All I'm submitting here is.
Please don't say that you're not on that. You're trying to, you can't blow hot and cold at the same time. At one stage you say that I have not engaged, and the other stage you say that whatever are the findings of the court, then you go to the contempt order. How can it be?
My lords, all I'm submitting is this, my lords. I am submitting that this was the grievance which was taken by the petitioners to the single bench. The single bench made its findings. The direction part of the order was only for me to consider the order passed in the industrial tribunal. The industrial tribunal order direction is only to consider their representation, my lords, which was already read out by the petitioners' counsel.
That is not the concern of the court now.
Yes, my lord.
Now, the learned single judge has passed an order. According to you, you have complied with the order, and the contempt is closed on that ground in the light of the endorsement issued by you. That is not at all in dispute. Now, what is in dispute is, now the learned single, my predecessor has passed an order saying that you cannot be terminated. You say there is no question of terminating. Me terminating because I have not engaged them. That submission you cannot make in the light of the earlier order, because as per the earlier order, you only have to have engaged them.
Yes, my lords. But in the contempt proceedings, what happened was the endorsement.
No. I think that is not I'll clarify this.
May I just bear with me for 1 minute, my lords? I shall. My lords, then I may be allowed to file an affidavit saying that I've not violated any interim orders of this court.
No, you put it in writing, whatever you are submitting before this court, you place it before the court, you place it, write it, file an affidavit of the concern.
My lords, I have no difficulty doing that. All I'm saying is.
Please do that. Please do that. The coordinate bench of this court on 9/12/2025 has passed the following order. Extract the order. Learned counsel for the petition submits that in spite of an order dated 9/12/2025, the respondents are not allowing the petitioner to discharge his duties, and as far as the court is concerned, there is no issue.
Quarters they have not dispossessed.
They have not.
And also they're not paying wages. They're not paying wages also, my lords.
They're not
paying wages.
They're not letting the petitioner to work, and not they're paying the wages to the petitioner.
May I
Learned
just make
counsel-
one submission, my lords? There is an interim prayer which was made for payment of wages. No order is paid on the wages. As per the interim order.
The learned counsel appearing for the respondent submits that they have not violated the interim order. According to them, according to the counsel, they have not engaged the petitioners. Question of he terminating the services of the petitioner will not arise. The learned counsel for the petitioner, in response to that, has drawn the attention of this court to an order passed by the where is the ID of where is the what?
193, my lords.
183.
193.
93.
Cooperative version. It starts from 140.
The order in ID number 55 of 2007, where the corporation is directed to consider the claims of the first party workman for absorption and regularization of the services in the posts held by them in accordance with law.
Before that,
Questioning the said order, the corporation has filed WP number 7567 of 2013. That came to be that came to be dismissed by confirming the orders passed in the ID dated by order dated 2024. In the said order, the
347 data.
in the said order, the learned judge has observed that on considering of these records, the court is inverted commas. This court is of the view that the industrial tribunal is justified in holding that respondents were employed by the petitioner corporation and not by the contractors. And finally, the order dated 36/12 passed by the industrial tribunal is confirmed. As the demand for regularization is pending close to 20 years, the corporation shall take steps to take appropriate action in terms of the directions issued by the industrial tribunal. The matter was carried in writ appeal, that is by filing writ appeal number 100592 of 2024. In the writ appeal, it was observed that Learned Advocate General appearing for the Karnataka Power Corporation fairly submits that the appellants be permitted to withdraw the appeal and further submits that the appellant corporation would comply with the directions issued by the learned single judge. The submission of the Learned Advocate General is placed on record. Further, it says that a memo is also filed by the learned counsel for the appellant seeking to withdraw the appeal, and the same is placed on record, and the appeal is dismissed as withdrawn. Later, the petitioner has filed a contempt. That is CCP number 1000079 of 2025 that came to be closed by order dated 7th July 2025, wherein it is observed that having regard to the endorsement dated 19/6/2025 issued to the petitioners, they are satisfied and the same would meet the directions issued by the single judge. This endorsement dated 19/6/2020, this was carried to against this you filed an SLP.
I filed SLP, my lords. That operated. Please, my lord.
SLP was filed and SLP was, the petition was given liberty to assign the endorsement dated 19/6/2025. Questioning that endorsement, the present petition is filed. And the learned judge, considering all these aspects, has passed an order on 9/12/2025. This court is not able to appreciate the submission that is made on behalf of the respondent, saying that they have not engaged the services of the petitioner, and in fact, the contractor has engaged. The order that is passed in WP number 75671 of 2013 has attained finality. And these kind of submissions cannot be appreciated on behalf of the respondent corporation. The respondent corporation shall file an affidavit before this court. Why the order dated 9/12/2025 was not complied with, and as submitted by whether the respondent can submit before the court that the petitioner is engaged by the contractor and he has no nexus or no employer-employee relationship with the petitioner. List this matter on 10th of February.
10th.
Grateful, my lord.
Interim order may kindly be extended.
Yes. Yes, interim order.
Please.
Yes, next.
Seal number 11. Patil Shivsai.
Suit for such a performance. Suit for such a performance. Plaintiff's writ petition. During the pendence of the writ petition,
I think notice is ordered, notice is awaited, I think.
please,
Yes, the list after service of notice.
may be permitted to file impleading application against the proposed.
I think there is.
Please.
Yes.
Seal number 12.
I pray may request it on Monday, Millets. They have served the impleading application yesterday. We'll file objections to the impleading applications.
Only one submission.
It's a tender
with
matter.
regards to- Let them, Millers, take a chance. One submission with regards to Millers, the order which has got by the petitioner during the Millers, the vacation bench, that is on 26/12. That is Millers, the order, contrary to the Millers order, which is passed by the Honorable Court in another writ petition which is listed today, serial number 20, wherein Millers, the very specifically Millers, the court has directed.
Matter along with 20.
Only thing is
Let's,
Millers.
there are two
now
more matters. It may
entire
be connected
tender
along
process.
with those matters.
That is,
For
let- I
this
can,
matter along with 20.
please. Right.
That's one more
Please.
submission.
We will see, wait. Yes, fall along with 20. Yes, next matter. 20.
Along with 20.
20.
Seal number 13.
List after service of notice, 14.
Seal number 14.
Serial number 13,
Prakash,
may I make a
13?
submission? This
Serial number 13.
13, please. 13. The order passed on section 14 of Surface Act is under challengement. I am ready to pay the amounts, some accommodation if the accommodation is granted.
If you are waiting, notice is ordered without an interim order. Why should we grant an interim order?
There's
now?
no interim order assessment. I'll file an affidavit, Mayor, to that effect. Considering my affidavit, my lord, so
Where is the affidavit?
I'll file it, Mayor. Within a day or 2 months, I'll be filing.
What is outstanding?
Outstanding amount is around 4 crore 13 lakhs, my lord.
So what is the affidavit that you are going to file?
Within a period of 4 months, Mayor, I'll be paying the entire
You'll
amount.
pay the entire amount. Pay.
I'll pay the entire amount.
Does this matter on,
Monday, Mayor?
not Monday, on 14th January?
14th
Please,
January.
great.
It is submitted that the petition is ready to pay the entire outstanding amount, and in that regard, he'll file an undertaking affidavit before this court.
Please.
Yes.
Great.
Seal number 14. Prakash.
Today's matter was passed over. My lord, as of now, if regularizing the account, my lord, the petitioner is ready to deposit within a particular, within stipulated time, for regularization of the account, my lord, NPA account. My lord, I am ready to deposit the outstanding, the loan as on today.
Oh, that's what, to regularize the account,
Yes,
whatever is
yes.
the amount, you are ready to pay.
They are
You said
like-
something yesterday.
Yes, my lord, he has to.
And where is the affidavit?
No,
Affidavit, undertaking affidavit.
No, my lord, since my lord, that petition number 2 is not keeping well, my lord, I could not secure it. My lord, tomorrow I file,
Tomorrow or on Monday?
day after tomorrow.
Day after tomorrow, court is not sitting.
Yes, then Monday, my lord.
Monday, this is matter on Monday, by the time the undertaking affidavit shall be
Please,
filed.
please.
You gave him the correct details?
Yes,
About
ma'am.
what is the amount?
Yes, total amount, my lord,
No,
7
to
lakh
him.
20.
Give it to him,
Yes, madam.
so that they'll file the.
Yes,
As on,
Yes.
Hearing on I, seal number 15. Harishas Maigur. Harishas Maigur.
My lords, claimants will for enhancement of compensation, my lords. There is a delay of 54 days in serial number 15
I number 1 of 22 is filed to condone the delay of 54 days, condone.
and in 15.1, my lords, there is a delay of 37 days.
Yes, I think that IA is not listed, that's in 15.2.
15.2.
This delay.
15.2, my lords.
15.2, there is a delay of 37 days. All these appeals admit. Courts for final hearing, call for the TCR.
My lords, records are required. Please,
That's what I said.
please. my lord.
TCR call.
Yes, next.
Serial number 16. Sharnappa Espoli what? 16.
I'm filing a withdrawal account.
You're seeking
for
withdrawal.
My lord, I have filed objections, my lord. My lord, I am
Objection
challenging
not
liability,
filed.
my lord. Insured vehicle is not at all involved in the accident, my lord. Immediately after accident, my lord, unknown vehicle dash next to the motorcycle, my lord. Even FIR and charge sheet is also shows that unknown vehicle is there, my lord. In charge sheet is shows that, my lord, insured vehicle is fixed, my lord. Considering the material facts, my lord.
TCR is ready.
Yes, ma'am.
TCR is.
Then I'll hear this matter on 19th.
Please, please.
List this matter for hearing on 19th.
Please.
Serial number 17.
Look, here is the case which I spoke to my lawyer.
Appear for
Yes.
petitioner.
They had challenged the order where the district court, where I have been pursuant to the direction by this court, I have been permitted to withdraw the money. There is.
Lights are on.
Mic on, Vijay.
ಇದೆ.
Yes.
I'm ready to, I told them also, there is an execution petition which is pending against my grandfather and my father also. Even they included me also as a party, my lord. Wherein there was a second appeal which is pending, and the crops have already been sold in auction, and the money is deposited before the appellate court as well as the trial court. They have moved an application there, wherein I wanted to withdraw that money and repay the amount, my lord. So in the meantime, they filed a writ petition challenging that order, permitting me to withdraw. So which I suggested that I will withdraw that money and pay the money. So that undertaking.
My lord, my prayer is, I'm seeking mandamus, permitting the petitioner bank to settle that amount with the loan amount, my lords.
Which should you? 107. It is a CPC matter.
Yes, ma'am.
Please, my lord. Petitioner is a Taluka Primary Cooperative Agriculture and Rural Development Bank, my lords.
This is a decree holder.
And the
Where is the impugned order?
propositor of the.
Annexure
Please
G, my
tell
lord.
where is impugned order, then I'll understand what it
My lord, Annexure G, my
See
lord.
page 37.
Annexure G, my lords.
Operative portion is at page 39, my lord, 38, 39. 38. You have the order of the Honorable High Court. So in respond number 1, there is entitled to withdraw 50% of the amount before the trial court.
What is wrong with this order?
Lord, what happened? The propositor of the respondents has availed loan from the petitioner bank, my lord. After that, creating charge over his property. After that, he died, my lords, and he executed will in favor of his grandson. That civil proceeding also pending, my lord. OS and then RA and then RSA is pending before this honorable court, my lords. There was an award in my favor, my lord. I have filed an execution petition. In that, they have consented for adjustment of that deposited amount with this loan amount, my lord, pending loan amount. After that, they have consented before the trial court, and after that, in RSA, they moved an application and.
Let's see that consent what you are referring, where is
Lord, there was a garnish order issued by the trial court, my lords.
from the pay, please point out that.
Please, my lords. My lord, kindly peruse page number 25A, my lords. Order dated 12/7/2024.
1 minute. Yes.
My lord, in this, my lord, IN number 2 filed by the petitioner bank, my lord, seeking to attach the amount deposited in both the trial courts, my lords. In that, on 12/7/2024, no objection to IN number 2, my lord. Means they have consented for the IN number 2, my lord.
Yes.
After that, my lord, at page number 28A, my lord. On 21/9/2024, there is a issue of attachment of 8 FD, my lord. After this 12/7/2024 order, my lords, they have moved an application in the RSA, my lords. And sought for suppressing this fact, they have sought for the withdrawal of the deposited amount, my lords.
What is the outstanding amount? What is the decree, that award amount?
5 lakh and
Now it is, I have to,
execution petition is,
I have to ascertain. the-
Lord, I have observed the copy. Entire execution petition, what they have filed, I have just raising it.
What is the award?
5,50,000.
5,50,000.
Yes.
Against that, you have preferred?
No, the amount deposited is more than that before the trial court, which I am telling them that I am ready to withdraw that and clear up the loan.
Award amount is 5
Okay,
lakh.
no, I have not understood the facts correctly.
Sorry, my lord.
So please tell the court the award is for an amount of rupees 5,50,000. Please.
This award.
Then after that, what happened?
They filed an execution petition,
Yes.
wherein this particular respondent number 5 was not originally a party at all. He was not arrayed as a party.
The beneficiary of the will,
Yes, my lord.
which is mortgaged to them.
Yes, my lord. Now, what has happened is there was a will executed by my grandfather, who was a judgment debtor. Now there is a dispute, that is the second appeal is pending before this honorable court. In the second appeal, we requested the court that there is a recurrent crop is there, that arrangement is going on, that every time that crop is put in auction, amount is taken and it is deposited before the trial court. And now what I mentioned before the court is there is an outstanding loan which I have to clear. Please at least give the 50% of the same, which this honorable court has permitted. I filed an application before the respective trial courts to withdraw that money and to clear up the loan of the petitioner itself. Now that permission to withdraw, that order has been challenged before this court.
Please
Now-
come to the award. Where is that award?
Page number 20, 37, 38 and 39. No? 38 is 13/11/2024. In view of the order of the Honorable High Court of Karnataka, dated so and so, in RSA number so and so, the respondent number 1 therein is entitled to withdraw 50% of the amount before the trial court and first appellate court. As such, office to release 50% of the amount to deposit in favor of the respondent number 1 in said RSA under due identification. So page number 38 and 39, that is of the writ petition. And this is pursued,
RSA is filed against which order?
page 35, page 36, below, which they are producing. It's an order dated 2nd September 2024. Is not in this disputed by the defendant that the respondent number 1 has made expenditure on the land of growing areca nuts. Even the appeal is considered on merits.
Against which order RSA is filed?
My lord, on will, suit was filed by the fifth respondent, grandson of the
What is the
respondents.
suit filed?
Please, my lord.
What is the suit
Suit for
filed?
declaration.
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 So what is the nexus between
So-
their execution and your?
No, they were not at all parties.
Yes.
What has happened, my grandfather had availed a loan and there was an award. Execution is pending. This is a dispute between among the brothers, which has come up to this honorable court. There's a concurrent finding wherein I am a respondent, wherein they also, my uncles have also filed an application.
True.
Yes, ma'am.
Now, as far as the bank's case is concerned and their EP is concerned, they have nothing to do with your, with the
Nothing.
interstate disputes.
No, my lord. No, my lord.
No, my lord,
What
sir.
has happened
Charge-
is the amount,
Wait,
Yes,
let him complete.
amount which has been realized out of the sale of this areca nuts have already been deposited before the trial courts, before in the OS and as well as the RM, my lord. Wherein I mentioned clearly before this honorable court saying that at least 50% of the said amount may be cleared to clear up my loan. That was my reason. That is how this honorable court permitted me to withdraw that, where I filed an application before the district court where the amount is deposited. That order has been challenged by the bank. Bank has already filed an application. They say there is already garnish order is there, which I say that I am ready to deposit and clear up the loan. Now what has happened, my lord? Instead of pursuing those two IA, they have already filed another application to put my property on auction.
No, because that's what they can do.
No, that there is
They will
already.
not wait, they will not wait till you sell the areca nuts, the crop. Whatever you realize from that, they will not wait for that.
No.
They have an award in their
What,
favor.
that
They
is
want
what,
it
that is what
executed.
I am ready to file an affidavit also before in this case. That is why I told my
So
learned
how
friend.
many years it will take? 40,000, 50,000? How many years you will withdraw that and deposit there?
No, my lord. I am ready to. That is why, that is my, actually in my application before this honorable court, I clearly stated this bank's loan is there. I had to clear off this loan because after availing that loan, that crop is.
So you are mixing two different aspects and issues. That is your suit for declaration, your disputes, inter se is altogether different.
Yes.
What is the order that is passed by the court in that and all has no bearing on them. There is an award. They have filed the EP.
Yes.
EP has to be executed.
Yes, my lord. That's.
Uh,
Now they challenge the order permitting me to withdraw the money in the RA pursuant to the direction by this honorable court.
In RA, they were not parties.
No, madam.
Please, my lord. That is a dispute between the family
And
members.
how are you then when you are not a party
Lord,
to that?
my lord, the property, the charge is
So
created.
first you tell the court, this order which you are challenging, are you a party to that?
No, my lords.
And then how can you question it? You have filed your EP.
But the subject
No,
matter of this
you have
suit.
filed you have filed the EP. In the EP, you can get your relief.
But what happened, my lord? They have consented there, my lord, for adjustment of the amount with the loan amount, my lords. After that, suppressing that fact, they have obtained order from this.
Now, it is acceptable to you that you will not auction that property and whatever he pays out of the sale proceeds, you are happy to receive it.
Yes.
Is it the case of the bank?
Please, pardon me.
No,
Sorry.
if I pay clear the entire loan amount after receiving that money, will it satisfy because they will not push for the auction?
I may be permitted to withdraw and get it settled. Otherwise, they will put an again conditions.
That's what I'm saying.
Penalties or
EP,
any.
you can't auction the property.
Already there is an order passed, my lord.
Already there is some.
Why are you bothered about all this?
After, my lord,
No.
that is the subsequent development after this writ petition, my lord.
What
Lord,
has happened?
this writ petition on November
Here, what has
2024, my
happened, my
lord.
lord?
Not able to understand what the bank wants to do. You have your separate proceedings. There is an order for auctioning the property. Do it. Sell the property. How are you bothered about what you're saying is now you will not auction the property. Whatever the sale proceeds that are received from that property, you will satisfy yourself with 50,000, 20,000. Is it the case of the bank?
No, it's more than.
What happened, my lord, after this filing of this writ petition, now
In
there
the month of March. Yes, next.
My lord, may kindly be posted on Tuesday, my lord. Because there is an interim order is operating. Because my entire money is that there is an interim order which is operating. I'm unable to withdraw that money and clear off their loan, my lord. Because they are challenged in order which is pursuant to the direction by this honorable court, I am permitted to withdraw the money. Neither I am able to withdraw that money and clear off their loan. They themselves have obtained the interim order here.
The question of clearing of the loan will not arise. They will only recover from you by selling your property. No, they will not accept money from you.
The two IAs are also pending. That is why I may kindly.
The month of March. Yes, next.
At least on Tuesday it may kindly be posted.
Yes, next.
Seal number 18, SM Kalwad.
And 50% of the award amount already deposited, my lord. I produce a receipt of week's time may be granted.
The accounts for the petition submitted as the order date 17/10/2025. The amount is deposited. Yes, sir. No, notice is complete. Yes, admit post for final hearing call for the DCR. Yes,
Please.
19.
Delay application.
Delay is there.
Yes, ma'am.
I number 1025 to condone the delay of 31 days in filing the appeal for the reasons stated condone. Yes, 19.
Bill number 19.
There is delay of 3 days in filing the appeal, my lord.
Yes, there is I number 1025 is filed to condone the delay of 3 days in filing the appeal condone.
And
Yes.
sought interim order, my lord.
Delay condone.
Yes, next 20.
Seal number 20. Sunil Desai.
Yes.
I was about to submit regarding, my lord, the.
First, give the earlier matter.
Please.
Serial number 20.
Let's see what is the writ petition about.
The writ petition, let's see, seeking a writ of mandamus to declare that the entire tender process should lapse by virtue of a notification that is issued by the government. Please.
Process of tender, questions of the tender notification after expiry of validity period is illegal and arbitrary. To call for the fresh tender. What are the facts?
The facts are, a tender was floated by the government for the purpose of disposal of sand blocks. Now the tender comes to the publication was made on 12/8/2025. But the last date for submitting the applications was on 15/9/2025. It was extended to 18/9/2025. Now, if I may take your lordship's to the government notification that is circular, page 95 for a moment. The manner of process has to be after the date, final date, within 30th day, a technical bid has to be opened.
No. First you said it is 15/9/2025.
Is a tender notification.
18/9/2020.
18/9/20.
After that, what happened?
After that, technical bid doesn't get opened.
When the technical bid has to be opened?
30th day from the date of final, last date.
18 plus 30 days.
Yes, ma'am. It comes to on 18/10/2025.
18/10?
2025. That should have been opened. That has not been opened. And thereafter, from that date, on 35th day, the financial bid has to be opened.
Yes.
No, nothing has happened. So I sought for a declaration, the mandamus, to declare that the tender process has lapsed by virtue of this circular and a fresh tender be called for.
Let's see what is this, what is the nature of the circular? Read it.
Yes, ma'am. The procurement entity as defined under section 2D of the Karnataka Transparency in Public Procurements Act 1999 is required to procure goods and services only by inviting the tenders as per the procedure outlined in the Karnataka Transparency in Public Procurements Act 1999 and Rules 2000. Rule 28 of the KTTP Rules 2000 prescribes the evaluation of tender and award of contract shall be completed as far as possible within a period for which the tenders are held valid. Hence, in order to complete the evaluation of technical and financial bids in a time-bound manner and to ensure transparency in the procurement process, it has been felt necessary to prescribe the timelines for each stage of the evaluation of the tender. In view of the above, the detailed timelines for each activity are prescribed as below. Opening of technical bid is within 48 hours. Evaluation of the technical bid to be completed is on or before 30th day. Opening of financial bid is on or before 35th day. Evaluation of the financial bid to be completed is on or before 50th day. Awarding of the contract and issue of letter of intent is on or before 70th day. Furnishing of performance security and entering into agreement on or before 90th day. Issue of work order, purchase order should be on 91st day from the date of final last date. Now, let's kindly mark the bottom there. Yes, ma'am. Any relaxation in the above timeline shall be specifically authorized by the authorized superior to the tender accepting authority for the reasons to be recorded in writing.
So, this is not absolute, it is subject to
Yes, ma'am.
the written
Yes,
authorization
ma'am.
by the authority.
Yes, ma'am.
Next.
Next, ma'am. All procurement entities shall ensure that the above guidelines are strictly followed. If any, it may be noted that any violation attracts a penal provision under section 23 of the KTPP Act. Now, my lords may kindly take the statement of objections that are filed by the state.
Yes.
May I request your lordships, para 15, how they produce all the records before your lordships to say that the entire process as if it is transparent. Now, para 15 is except a self-serving statement on oath. Yes. It is submitted that petitioner relied upon Rule 22 of the Karnataka Transparency in Public Procurements Rules 2000 and the government circular dated 29/11/2021. In the case of Mrs. Geo Consultancy Service versus State of Karnataka and others, in writ petition number so and so, passed by the Honorable Court has clarified that failure to complete within validity leads to automatic lapse of the tender under rule. A copy of the order dated 3/7/2019 is produced herewith as Annexure R7. As such, the present case in hand, the respondent authorities will within 90 days validity of the tender process, that is the District Sand Monitoring Committee in its proceeding dated 29/9/2025
So let
has.
us see, where is that authorization that is filed by them?
That is not authorization.
As
of,
per the circular, if
yes.
they have to extend the timeline.
There's no other, that is not produced. They say there's a decision that is taken. Your Lordship, the next month, if Your Lordship, what
I've
else?
read it, I've
Yes,
read it.
now they say that it is taken, but it is not placed on record. And kindly see the further paragraph, they say that they will take it. Thus, in a present case, respondents extended the timeline upon the considering the reasons which recorded in rating. And also each extension of time schedule was intimated to every bidder as per the third para of the government order dated so and so.
Get that they would take. They didn't say so. They said they have already taken.
They have taken. Now, my lord, any such further requirements will be taken is what they intend to say.
Where did they say? The present case in hand, the respondent.
This say that they have taken it on 29 and 2025, which is not placed before Lordship's. Now, all other documents are produced from R1 to R7. If this was done, they would have certainly produced before Lordship's.
What is the prejudice cost to you?
No, without extension, they cannot proceed. It gets lapsed. That is what the rule says. The circular is binding on them because it is their own.
Thing is, you are the unsuccessful tender.
No, if it has lapsed, they'll call for the fresh tender. Now, the intent is this, my lord. They want to.
Have you participated in the tender?
We have participated. Now, technical bit was not opened. If it is not opened on or before, on within 48 hours.
It is not open, and according as per the circular which you are relying on.
Yes.
If they obtain the permission of the authority superior to the one who has issued.
Then I don't have case. I cannot even argue with it.
Yes.
Para 27 of my statement.
Para?
Para 27 of my statement of objections.
27 of?
27 of statement of objections.
No, this is.
27.
You have only 20 paragraphs.
27 of my statement of objections.
Page 27.
Page.
Sorry. Page number 27. Well, the Malords, the
One
Sand
minute.
Committee has taken the Malords to pass an order. That is Malords, in view of the Malords, the class 15 of the Malords, the tender notification itself. Page 15 Malords, in page number 44 of the Malords, the writ petition, which clearly says, class 15 Malords.
No. Where is permission obtained by you or who authorized?
District Sand Committee has taken a decision.
Please, sir.
Please.
Should be by superior authority.
Just.
Who is who has floated the tender? Who has issued the tender?
Tender is by the Malords, the district Malords.
Senior geologist of the department.
Malords, the District Sand Committee by the Deputy Commissioner. Sand Committee.
District Sand Committee.
Yes, Mr.
Malords, in page number 44 of the writ petition may kindly be seen. Class 15 of the tender notification, Malords. The timetable may be amended by the state government, district and committee through issuance of corrigendum and addendum to the tender document. Note, if any short-term tender notified by the district and sand committee should follow the KTP rules. The timeline shown above is based on the calendar days. Due dates will be updated if any holidays are announced by the government or by the district sand committee in the intervening period. The district sand committee have reserved the rights to update, change or modify any of the above time period. In accordingly, my lords, in my statement of objection, I have produced the document of the proceedings of the district sand committee.
Where is that?
Yes, my lords. In my lords, annexure R4, dated my lords 29/9/2025.
Dated 29.
29/9/2025, my lords. Relevant portion is my lords, in page number 27.
What it says, read.
It says, my lords, it has been extended for, my lords, 1 month.
This is passed on 29/9/2025.
Yes, my lords.
This is by the same officer who has floated the tender.
Please come back to your, first of all, you have to look at the auction conditions.
Yes.
Yes.
Then you have to look at the
Yes,
government
yes, ma'am.
circulars.
Yes, ma'am.
So please come to 9:15.
Yes, ma'am, I shall. If any short-term tender notified by the district sand committee should follow the KTTP rules. The timeline shown above is based on calendar days. Due dates will be updated if any holidays are announced by the government or by the district sand committee in the intervening period. The district sand committee have reserved the right to update, change or modify any of the above time period. Now this, so far as circular is concerned, Millard, it relates to post the notification. Now this relates to Millard before the last date of applications and other things can be modified by the very same authority. That is what is empowered millets by condition of this tender notification at number 15. They don't have a power millets to change.
No, they're referring to the above time period. Where is that above time period? Where is the time periods stated? They're referring.
There is no mention about that in the tender notification. About the
bids are
time.
Submitted, no. Come to 14.
40, yes. Process of tender bid. The bidder shall submit a technical bid and financial bid as specified in clause 11 and 12 of this tender document. Only those bidders are found to be eligible in accordance with the terms and conditions of eligibility specified in the bid document, and whose price offer is equal or between ceiling price and cutoff price shall be considered for evaluation. If the total number of eligible bidders are so and so, this doesn't mention about that. Technical bid and financial bid are concerned billets. Submission. The timeline is not provided in the entire tender notification. So, millet, my submission is this. What could be changed by them is till the date of floating the tender is concerned, they have a power to change it. So, whereas the power to millet's extent is concerned is only it will vest only with the superior authority. Now, what my learned friend refers to is that of a sand monitoring committee.
Also, kindly see, my lords, the circular is only in directory in nature, not mandatory. My lords,
That is interpreted by coordinate bench of this honorable court and said that once there is a timeline fixed, you are bound by it.
Circular is directory in nature, not in.
Those circulars are being issued by you.
Yes.
You only say what is the procedure to be followed. If there is any deviation, violation, what should follow.
Yes.
So you say that if these have to be like whatever the timeline, if you're not able to, you want to modify, you have to take the permission of the authority, which is superior to the one who has issued the tender notification. Now, this timetable, clause number 15 of the auction condition, what you are referring to, that will not clarify this issue. It will not
That is one of the condition of the Miller's tender committee. When he accepted the
different issue, conditions
conditions,
changing, in the tender conditions, nowhere you say that on this day the financial bid will be opened, on this day so and so. That is governed by that circular, when it should be done.
That we have not mentioned. That's my humble submission is when he is a participant to the Miller's notification, he should abide by the conditions of the notification.
I can understand that, provided you have stated so. Provided you have stated in the tender conditions.
Yes.
And my lords, there was a my lords in connected case, serial number my lords 20.
No, let's complete this.
There was a stay by this honorable court.
We will go to that also. First, we clarify this. Now, as it stands now, what you have done is contrary to your own circular. And the objections that you have filed, they do not answer the contentions that are raised by the petitioner. You have not placed any piece of paper before this court that for not adhering to the timeline as per the circular, have you taken the permission or not? Except making saying something that you have followed the procedure. So as far as this writ petition is concerned, it is clear. Well, give the next writ petition.
One submission, adding to the Miller's submission.
So for his application? No,
Only-
he
only
is an
to-
impeding applicant. I'm sorry.
Only to assist regarding timeline, Lordship has got. I have produced some documents, which is the part of the Miller tender notification at annexure.
In which case, next case?
In the is the case on impleading application I have filed, wherein Millers I have produced, page 23, page 12, serial number 12,
1 minute,
please.
Yes.
I have produced Millers documents, which is the part of notification.
Hmm.
The page 23, it is a timeline Millers wherein specifically is clear regarding Millers, how Millers the tender has to be proceed. Wherein bid validity period is 90 days. That is, they are not disputing. Next, may I read Millers?
Yes.
Last date and time tender, where is the clarification? Is 29/8/2025. And last date and time of receipt of tender 18/9/2025. This is very important. 18/9/2025 is the Millers the period wherein Millers the notification circular which they are reading has to be read from the date of 18/9. 18/9 is the last date and time of receipt of tender. That is Millers the circular says, that is Millers 29/11/2020 government circular says, timeline from the last date of submission of the tender, which has to be Millers read from the date of 18/9/2025 only for the present notification, tender notification. If that is so, 90 days till today is not been completed. 90 days, period of 90 days is not been completed. Till my lords, there is a period for the consideration of tender process.
So according to you, from 18/9/2025,
Please,
you will have 90 days to complete it.
please. And
So it will
regarding
come when 10, 11,
technical,
12, that is
please.
18/12/2025.
There is an intervention period of my lords stay, which is my lords, I like to submit. My lords, after 24/11/2025, there is an interim order in the connected matter.
No,
There-
forget about the, no, forget
No, no,
about the
that
interim order.
90 days is
What
not
you-
been completed, please.
No, not about the, no, what about this
Technical.
circular? With
Circular,
regard
what, that is what I'm saying. That is what I'm saying. Circular is very clear. I'm not disputing whatever their submission is. Their submission is, my lords, according to the circular, they are not acted. According to circular only, my lords, I'm saying 18/9 is the date. Thereafter, my lords, technical bid has to be, my lords, open. 29/2025 technical bid is open. That is within the period of 30 days.
So 18/9/2025.
Please.
So where is that circular? Page number?
Millets, your lordship secretary at page number 95 minutes.
Page number 95.
Yes.
That is, my lords, timeline from the last date of
Opening of financial bid on or before 35th day. When would be the 35th day?
35th day. Financial.
20th. No, 18/9 is the 35
23rd.
days.
It would be 20, next,
35 days will be 23rd.
it would be 23/9.
23/9. So.
Evaluation, my lords. Next,
Correct.
financial bid.
23/9/2025, opening of financial bid.
Please. Technical bid, I am saying. Technical bid is, my lords, 48 hours.
Technical
Thereafter,
bid-
my lords,
one
30th day.
Technical bid should be 18/10/2025.
Please.
Should be the technical bid. 23/10/2025 shall be the opening of the
Financial,
bid.
yes.
No. 30th day is the, my lords, date for opening of technical bid. That is, my lords, 29/2025. In the present case, they have opened the technical bid. Let's serial number 2 in the circular.
Confused with the dates.
Yes, serial number 2
No.
regarding, my lords, technical bid. I am saying 30th day. Serial number circular.
It says on or before 30th day.
Please.
That 30th day will come, will be on
How? 18/9, my lords, last date of submission.
evaluation of the.
Lord, my
technical
learned
bid.
friend, in fact, it is not so. Technical bid should be opened within 48 hours. Evaluation will be on the 30th day.
Evaluation shall be on the 30th.
On 30th day.
Within that period, my lords, they have
So that's why please tell the dates, looking at this at page number 95.
Please.
So opening of the technical bid, when it was opened, within 48 hours it should be opened.
How?
When it was done.
20th/9/2025.
20th,
9/2025.
then it is within 48 hours.
Please.
Then.
Thereafter, final
Evaluation.
Evaluation. Evaluation period, my lords.
What is the date of
It's supposed to,
evaluation?
my lords, open on 25/11. 25/11. Financial bid, 50 days.
From 18/9/2028, on or before 30th day would be 18/10/2028.
18/10/2028.
The evaluation has to be completed. Was it completed?
No.
It is not completed.
It is, my lords, regarding interim order passed by honorable court. It has been, my lords, stopped.
When was the interim order?
Interim order was passed on 24/11.
18/10 is first or 22/11 is first? How will the interim order will come in the way?
35 financial bid. In the mid, my lords, they have sought for extension of 30 days. That is.
Will not go into that. Let's clarify this. Now, evaluation shall be done of the technical bid shall be completed by 18/10/2028. Interim order according to you is in the
50
month
days.
of November.
Please.
So there is failure on the part of the respondents in doing it. Next is a financial bid. Financial bid shall be on the 35th day. 35th day would be 23rd.
Opening and evaluation is 50th.
Opening
day.
is
50th.
23rd.
35 days is 23rd of 10.
Please.
If it was not done.
No, according to their objection, in fact, they are about to open, and in the meantime, they have approached the court and order was obtained.
Order passed.
Order is passed in the month of 11th of 24.
That we can't consider.
Please.
The only issue now that has to be submitted by them is, as per their circular, their own circular, whether there was any, whether they have obtained the permission from the concerned or not.
Extension of time, please.
That's the only thing, nothing else. Yes.
For extension, we have not taken, my lord. This is
Then-
district stand committee has taken a
Then we'll
decision.
set aside this for, then and call for a fresh one.
My lords, the proceedings, I have stated in my statement of objections, my lords, my lords. Para 8 of my statement of objection.
Para 8
Para 8 of my
your objections.
Yes.
Yes, read.
It is submitted that the district sand monitoring committee is in its proceedings.
It's meeting held on 29/9/2025.
I have discussed the disposal of sand blocks, and in respect of the said tender notification dated 12/8/2025, it was recorded that there were 157 people are participated as the bidders. Further stated that the most of the individual bidders are participated for the more than one sand blocks. As such, on verifying the same, the member secretary submitted that more time is required for the scrutiny of the documents uploaded by the such individual bidders. On considering the said issue, the district sand committee taking in view of the clause 15 of the table.
So where is it? Let us say,
Yes,
as per your own, whatever you say, let's take it on the,
yes.
where is that resolution, decision?
That meeting proceedings I have produced, not that is.
Where is that?
That is in Kannada.
That is what he referred to, by the very same authority, which is floating the tender. They want to refer to that resolution, which he, my learned friend, again referred to. He is reiterating that.
Since the clause 15 of the, my lords, the tender notification itself envisages, my lords, district sand committee to extend that time.
But you have not prescribed any time in the tender about
In the
when you will
original.
open the technical bid, when you will open the financial bid.
That
That you have not said. So there is no question. Then in that case, that circular will come into play.
not circular, my humble submission is only in directory in nature, as far as my submission is concerned. If the wordings of the circular is seen.
This is not an act, shall,
Yes,
may,
yes.
not that.
You understand?
For transparency in doing the things,
Yes.
you have issued a circular. When you are not, why you are not adhering to that, there should be some reasonable answer to that.
And Millets, if a fresh tender is floated, all of us will participate, Millet. No prejudice will be caused to anybody, Millet.
Seconded to come. Yes.
No prejudice will be caused to anyone. This is not a case where someone is benefited out. I'm sorry.
No, yes.
It is not a case of someone being benefited out of this. If fresh tender is floated, everyone will get a right to again participate, Millet. Because now the intention is this, Millet. They want to oust the people whom they don't want. After now, because there seems to have got some information with regard to who is eligible, who is not eligible. That is the only modus as to what can be gathered from this. Though I cannot make direct allegations since I cannot get any documents.
Yes.
And their circular, Millet, has a statutory force in terms of, Millet, sir.
Which is the judgment you are relying on?
Millet, one with regard to 90 days is concerned, Millet, where a rule. Last time. They have relied on the earlier bench. In fact, this was cited in that matter. I'm sorry. This was cited in that end.
Give that.
In fact, from the date of submission, my lords, 90 days will not be expired. That is my lords admitted fact. 90 days completely agodula. Till there is a period of my lords consideration of process. Only my lords, technical issue is financial bid as per the circular, my lords, had to be short of my lords, 13 days. There is no issue. But in otherwise also, my lords, the intention of my lords, the tender has to be, my lords, secure after the my lords, projection of final bid only. Announcement of final bid, they come to know that my lords, who is the eligible candidate, so who is the my lords, successful bidder. Until then, my lords, there is no my lords, issue at all regarding my lords, what they are my lords, saying. There is some my lords,
No, let's say that there is nothing,
please.
but they have to follow what their own circulars, and they have to conduct this process in a transparent manner. If they are not able to do, why they are not able to do, some reasonable explanation shall be forthcoming.
Please.
That which is not there in this case, we'll set aside,
But
let
my-
them
let the-
complete the process.
One submission, my lord. Whatever that my lords, the tender process, my lords, are going on in general, it is my lords, directly my lords, affecting the exchequer of the my lords state. They can't my lords, proceed only for the technical my lords, the issues. Their contention is my lords, throughout their writ petition, 90 days is not completed. They have to my lords, follow the rules, that is circular. But there is no issue at all my lords, regarding 90 days. 90 days till my lords, it is short of my lords.
Not on 90 days.
No, that
We are on the other issue.
Lordship has my lords, considered there is no issue at all regarding the financial bid. It has to be opened in the 35th day. But only for that reason, my lords, that reason, if Lordship has considered, it is my lords, again, my lords, the comes to the my lords, public policy. Because my lords, these tender notifications, it is affecting my lords, the public and exchequer of the state.
For that reason, you have to do it in a time-bound manner.
But I'm not saying that my lords, there is a short of my lords, the opening of financial bid. I'm not disputing. But regarding my lords, the entirety 90 days, if that they have not followed, because my lords, the reason is 159 applications for my lords, they have to my lords, scrutinize the entire applications of 159. If there are my lords, less number of the participants, they can my lords, approach. That is my perception. So for that reason, my submission would be my lords, the 90 days till this day, there is a my lords, awaiting. They have to my lords, proceed. Within that period 90 days, if they are not completed, then my lords, the grounds for my lords, the petitioner is for the my lords, saying that my lords, the validity of.
According to you, what is the prejudice that is caused to you?
That is what I'm saying, that my lords.
Me, my lords.
The prejudice caused.
Now, my lord, they want to circumvent the circular and want to open this.
No. One thing. Now, if they do it, whatever the result that is followed after the due date.
Yes, ma'am.
If the same result is even before, as per their time slot.
Yes.
So then where do you stand?
No, they can't do it for the reason that circular mandates that it gets lapsed, my lord. That is what they.
Yes, one, I understand.
Yes,
I understand what is it. Now, what is the prejudice?
No, we are not sure as to what has happened thereafter, my lord. They have opened it, my lords, without, my lords, making it known to everyone. They seems to have got some information and gathered that who are eligible, who are not eligible. They want to favor a particular class of people who have come with an implementing application. Otherwise, there was no need for some applicant who was not sure that whether he will be eligible or not.
This is all the unfounded allegations.
That's
They don't know who is the successful bidder.
This is what my lords,
One
earlier.
minute.
No, now application is filed now.
No, let us see your writ petition.
Yes, ma'am.
Where did you say?
That I have not pleaded that in the writ.
What is
I
not
cannot, because I don't have a material, I cannot make allegation. The only inference that can be drawn is.
We will understand.
Yes.
We'll understand from your writ affidavit and the grounds.
Yes.
What are the reasons for?
My only ground is with regard to circular is being not followed. It lapses. Yes.
Impute action of the respondent continue the tender process in contravention of the circular is illegal. In their portal itself, the ability of the tender and in terms of the process is required to be completed. Probably he's submitting about this 90 days and that interim order.
Please.
In the year
Yes.
2000. Yes.
Yes.
Till today, the technical bit is uneven after explain the process for himself. So you are not attributing any
Because I can't.
malafide to them.
No, I don't have any material, my lord. Otherwise, the only inference I can draw now is, now, my lord, once the tender has lapsed, if a fresh tender is called, no one will be, my lord, it will only lead to, my lord, further, my lord.
Heard reserved.
Very good.
My another submission, my impleading otherwise my lords, my submission would be.
In which case?
In both the cases, my lords.
Yes, I number. you are the.
One of the participants.
successful bidder.
Participants.
Participant or successful
No,
bidder?
no,
No, there's
participants.
no opening
Finance-
of technical.
Opening of bid is pending.
Yes.
That is what their contention. 90 days has to be complete.
IA number, where is your IA?
That's in both the cases.
A
that's
number?
IA is pending.
One, I see in 20.
Please, Tolu Millers, they are now.
20 and 21.
Please.
IA number 1 of 2025 in both the cases is filed by the party who has participated in the auction. It is submitted that as a stay is granted by this court for opening the technical, or for completing the formalities of the tender process, is also one of the affected parties and a proper and necessary party to this petition. Accordingly, I number so-and-so is ordered.
Grateful. And the investment Millers has to be considered because
What has to be considered?
investment Miller, because every bidder has to Millers pay for the Millers evaluation of the Millers point. Whatever the Millers point as having Millers evaluation, they have to percentage wise, the percentage they have given in the, that amount has to be deposited Millers while filing the application for bidding.
And will
Please.
consider all the aspects.
Please.
Third, reserve.
And
The same,
Yes,
both are
both in
taken.
20,
Both are
21 I have
taken.
ordered.
there are
Appears in
some,
20.
there are some
He is
matters.
appearing in 20.
Yes.
Grateful.
There are other some matters in similar notification.
Those two matters are not,
I will
clubbed.
give
That's
a-
what we made a request, that other matters are not come. When they are listed minutes, we'll bring to your lordship's notice on Monday or two.
I'll give
We'll
a
move it
list.
tomorrow, since you, this,
Yes,
that,
no, we'll have it tomorrow
Yes.
and it will go along with this.
Please,
Because
yes.
arising out of the same.
yes, please.
Take those two.
We'll give a
Post WP so-and-so tomorrow.
good number.
It is submitted that the connected matters or so-and-so, so-and-so. List those matters tomorrow.
Please.
Can go along with.
Yes.
Yes.
And one more, let's, in the 20th matter, what I was about to submit, after the order of stay, there is a modification order regarding the tender process will go on. Direction is given by the Assembly
That
Court.
was a concession that was given. It is not on, it's not an order.
No, no.
Passed
order.
on minutes.
Well, order there.
He
order.
had given a concession.
It is an order, submission of the joint.
It is not an order. Ultimately, on the merits of it, the order will be
Yes,
passed.
order
That is
has to
what,
be
that is
passed.
what.
That is what.
Yes, next.
Till your lordships are passing, there's an interim order which shall be extended till the order is pronounced.
Interim order is extended.
Please.
Yes.
Serial number 21. Vidyavati Kotur.
Please, my lord, I appear for petitioner. Now they have served a memo stating that, my lord, they are permitted the petitioner number 2 to participate in the general party meeting after issuing the notice. I have questioned the notice which they have left the director, one of the director in the first petitioner society. Without issuing a notice to me, they have they have issued they have scheduled to be held a meeting, madam. That is Annexure A. It's in Kannada, my lord. Actually, they have issued a notice, but they left me. They have not issued a notice to. I am the one of the director of this society, respondent number 1 union, my lord. But they have not issued a notice to me. Therefore, I have questioned before your lordship. The respondent number 1 called a meeting without issuing a notice to me. I have called in question. This honorable court granted an interim order. Now they are filing a memo. Now they have served a copy, filing a memo stating that, my lord, after issuing the notice to me, they will conduct a meeting.
Right of it will dispose of this report.
Please, my lord, taken on record, my lord, the memo.
That memo.
And also one more request, my lord, the last date is 9th to delegate the director to respondent number 2, that is the state federation. 9th is the last date, my lord. If your lordship fix a date tomorrow by mode of whatever mode of service through WhatsApp or mail thing, fix a date meeting, my lord, then they will send a delegate to on 9th only.
Yes, please. The presented petition is filed, seeking the following prayer. The facts of the case are the petitioner is a milk producer cooperative society. The respondent number 2 is the State Cooperative Federation. The petition number 1 society, member of the respondent number 1 union, by resolution dated 23/12/2021 has authorized the petitioner number 2 to represent petition number 1 society. The petitioner number 1 society has declared uncontested as a director from milk producer cooperative societies among the 48 members in the list. The petitioner, being the director of the respondent number 1 union, has attended the meetings regularly as prescribed under the Act, rules and bylaws. It is stated that respondent number 1 passed a resolution on 23/5/2025 that in the pending writ petition 103377 on 2025, the respondent number 1 is not a party. And if any orders are passed, then the same would be considered by respondent number 1. The election of the petition number 1 society is declared on 22/9/2025 as per the direction in SLP number, as per the direction by the Honorable Supreme Court. Thereafter, petitioner made representation to respondent number 1 regarding the declaration of the result by the Honorable High Court. It is stated that in WP number 103377 of 2025 dated 22/7/2025, directed the returning officer to hold an election from the stage where it has been interrupted. The returning officer on 22/9/2025 fixed the date of the election on 30/9/2025. On 27/10/2024, in the writ appeal, the Honorable Court directed not to announce the result. The petitioners have carried the same by filing SLP number 26208 of 2025. What is the interim order in the SLP?
SLP is to declare the result.
The Honorable Apex Court has directed to declare the result. Then a resolution was passed on 15/11/2025, authorizing petitioner number 2 to be the representative of petition number 1 society in the respondent number 3 union. The respondent number 2 federation, by letter dated 18/12/2025, informed all the regional cooperative unions to send delegation from respondent number 2 on or before 9/1/2026, addressed to Chief Executive Officer of respondent number 1. The respondent number 1 union, being one of the regional union, deliberately has not informed the petition number 1 and has arbitrarily by surpassing the director, has issued impure notice letter dated 15/12/2025.
The Honorable Court granted an
Stated that the respondent union with malified intention has issued the notice, assuming that there are some lacunas in respect of petitioner number 2, and has arbitrarily assumed that the director position of respondent number 1 union is vacant, despite the fact being that the petitioner number 1 is the director and petitioner number 2 is only the representative of petition number 1 society, and the fact that there is no disqualification of petition number 1 under section 21 and 29C of the Karnataka Cooperative Societies Act. Land counsel appearing for the petitioner submits that in this matter, submits that On 19/12/2025, a coordinate bench of this court has passed an order the court has granted interim order till 23/12/2025, and the said order is extended from time to time. Today, a memo is filed before this court by which respondent you are?
Respond number one.
Huh?
Respond number 1 and 2.
By a memo is filed before this court by the respondent number 1. That they have filed IN number 2 of 2025 for vacating the stay. However, they are not pressing the same. And also, it is stated that they will issue notice to all the directors, including petitioner number 2, by way of all the modes of service and for the knowledge of all the directors, including petitioner number 2, to participate in the meeting on or before 9/1/2026. It is stated that if the delegation has not forwarded to respondent number 2, the time already scheduled on 9/1/2026 by respondent number 2 may kindly be extended to receive the delegation from respondent number 1 under the unavoidable circumstances. When counsel appearing for the petitioner submits that in the light of the above memo, the writ petition can be disposed of. Considering the memo that is filed, this court is passing the following order. What is that you are asking, when it should be?
Tomorrow, if the meeting is scheduled, madam.
Tomorrow is 8.
8. Day after tomorrow is the last date, my lord. Therefore, if tomorrow meeting is scheduled, but to communicate to all the directors, my lord, then they will delegate on 9th, my lord. The same will be.
It can be done.
It can be done, my lord. If you will also fix a date, my lord, immediately hand delivery is made. Immediately the respondents will communicate them by way of all mode of service, my lord.
Meeting is on 9th.
Meeting, my lord, last date of the delegation form sent to respondent number 2, which is the state federation. The respondent number 1 is the district union, regional union, my lord. They have to send one delegate to participate in the election scheduled in the month of March, my lord. If they have not conducted a meeting tomorrow to delegate some director to the
Meeting has to be conducted in your
that respondent number 1 has to be conducted a meeting
tomorrow
by calling all the directors.
The meeting shall be conducted tomorrow, that is 8th.
Please,
and the same shall be communicated to, notices shall be communicated to all the
directors, including petitioner number 2.
Including the petitioner.
Petitioner number 2.
Petitioner number 2.
Please, my lord.
Accordingly disposed.
The operative portion may kindly be handled. Please. Grateful.
Seal number admission matter, seal number 22 urgent, seal number 23. Sangram S. Kulkarni.
My lord, the appellant has challenged the order passed in P&AC 8 of 2002, my lord. It is a common judgment that was passed along with OS number 335 of 2013. The judgment in OS has been challenged in RFA 1,83,000 of 20.
In this notice is also not ordered till now.
No, my lord, because it was.
Notice.
Seal number 24.
Kindly post along with another MFN 103618 of 2023, my lord.
Notices are served.
Please. And one more matter is connected with this matter.
I admit, post along with so and so, call for the TCR, post for final hearing. Yes. 25.
Seal number 25. Hanmantar Latu.
Contesting respondent and for the respondent. Claimants appeal for enhancement on only two grounds. One is dissolvity and interest. And it is a ECA matter. Interest awarded from the 30 days of the award, my lord, instead of 30 days from the date of accident, my lord. Treated doctor issued dissolvity to 30% to the lower limb. Is such a malunited fracture of left tibia and fibula. The commissioner took only 10%, my lord, as one third. So treated doctor issued dissolvity. It is the ECA matter. At least 30% which is assessed by the doctor can be considered in the WC matters, my lord. Only on two grounds I filed an appeal for enhancement. Regarding the interest, my lord, I will leave it to the court.
Because that interest is as per the act.
Regarding the disability, it is an admitted fact that your worship kindly peruse the para number 40 of the judgment. At the first instance, he was discharged against the medical advice. And he went to some other hospital where he has taken the treatment and he has sustained on the fracture.
Please come to that particular finding.
Please. Para number 41.
41.
Please.
Yes.
May I read it? In the cross-examination, doctor has admitted that the patient was discharged against the medical advice in the first hospital. It is admitted that petitioner had rib fractures and there can be no assessment of disability for the rib fractures.
What it will be, if he has not assessed a whole body disability, it would be 1/3 of it.
In respect of the limb, he has given the disability in respect of the limb matter.
Then what, how much the court has considered?
10%. Court has considered at 10%.
It is correct.
But it is WC matter, my lord. In MUC cases, it is correct because in the WC cases, the income, 60% of the income considered to the loss of earning capacity.
What is the law on that? That the limb, the 1/3 of the limb disability is a whole body disability. Generally, that's what we are taking. We are saying that in WC matters, it can't be taken. Which judgment says so?
But the judgment no, but in all cases, in many cases, they considered. And also, one more submission, my lord, the treated doctor issued. In non-treated doctor issued, my friends in all cases submits that is not a believable doctor, something. But in this case, it treated doctor issued the disability is sustained two fractures, tibia and fibula.
No.
But not a tibial spine only.
Only tibia. Have to clarify this aspect, why it shouldn't be 1/3.
Because in the double.
Not with your arguments, with some judgment next week. Yes, next.
Next. Bill number 26.
Interest on the considered matter.
My lord, appear for claimants. It is a case for enhancement of compensation and it is case of injury case, my lord. It is only quantum, my lord. The PW2 doctor assessed the disability different.
Please come to the table. Where is that MFA table and all? Keep it. Yes, come to the table in the judgment. Table in the award.
My lord, please. Page number 22 of the impugned judgment, my lord.
Page number?
22, my lord.
How many are the injuries?
Lord, as per the PW2 doctor assessed disability 80%.
What disability? How many are the previous injuries?
Sorry.
Read from the judgment. Come to pain and suffering.
My lord, pain and suffering 40.
Sustained one grievous injury and two simple injuries. Court has granted 45.
45, my lord, under the head of pain and suffering 45, my lord. 45,000, my lord.
Then
loss of
how
future
many
in,
days in hospital?
my lord, 17 days inpatient, my lord.
Incidental expenses 17,000.
My lord, to under the heads of attendance charges 8,000 was awarded, my lord.
No, altogether it is 17,000. Yes, then
And conveyance 5,000, my lord, only.
put together I'm saying 17 days 17,000. Then
And my lord,
expenses as it is.
my lord, amenity is only 5,000, my lord.
1 minute. 8,000. Loss of future income. What is the evidence of the doctor?
Doctor, my lord, PW to assess the disability, my lord, different organs fractures, my lord.
See, let's read it.
My lord,
Come to page number 29.
para 12 of the impugned judgment, my lord.
Please read.
PW2 is the doctor who has given the evidence wherein it is stated that after clinical,
Straight away come to
please.
page 18. As per PW2, petition has suffered disability to the extent of 25%. Nasal bone,
Yes, ma'am.
25% to the left knee joint.
And total
Petition may have disability to the extent of, so even if you take it as it is,
trial court taken only 10%, my lord.
25% to the left knee joint, then what would be 1/3 of it is?
And the 25% the court not
Nasal-
considered, my lord.
Nasal bone fracture would not lead any disability.
Yes.
Nasal bone. And he was a driver, 22,000 was considered as an income without any basis. 22,500 was considered for auto driver.
And
And 10% is also added towards future prospect. That is not at all a case for adding future prospects in this case, my lord. What is awarded under the loss of future earning is just and proper. Other heads, it can be enhanced, my lordship, as per.
Lord, as per the lordship,
Because-
see the evidence of PW2, my lord. Apart from the 3 fractures, one is, my lord, communicated fracture of,
It itself is one.
please,
Where are 3 fractures? There is only 1 fracture.
one fracture, my lord, but other 3,
Case injury is only 1.
kindly see the,
What we do is, pain and suffering 5,000 is enhanced, incidental expenses 17,000. Loss of future income, from what she is saying, if you have to.
at least 1/3 to be, lords may consider, my lord.
1/3 of what?
The PW doctor assessed 80%, my lord.
80.
80, my lord. 80, my lord. The
No,
trial
no.
court considered only 10%, my lord.
Oh, no.
No,
Please read it. Where did the doctor say? To the extent of 25%.
Well, PW doctor, my lord.
How can there be 80% of disability with this?
Lord, the 25% due to fracture of penis bones and fracture of both nasal bones, and 30% in the right knee joint due to comminuted fracture of shaft of right femur bone, and 25% left knee joint due to undisplaced fracture of lateral condyle.
When you if you look at paragraph number 13, please look at it. You have sustained only 1 grievous injury and 2 simple injuries. And what is this evidence of the doctor?
May I read? There are 12 of the impugned judgment. 12 of.
Yes.
PW2 is the doctor who has given the evidence wherein it is stated that after the clinical examining the petitioner and on perusal of the documents produced by him, as petitioner was complaining difficulty in walking as he has been operated to the right thigh, and there was a fracture of on the left knee joint, and there were interlocking nails and 2 screws which were inserted, and looking to the injury there is a malunion fracture of bones, and he has.
Yes, this doctor for that particular knee joint, yes, he is giving separate.
And both legs are interlocking and screws were inserted. Exhibit P14, 3 photos are produced, my lord, marked, my lord. Kindly see the photos, my lord. Exhibit P14, 1, 2, 3 photos. Considering, my lord, 1/3 deserve to be considered, my lord, instead of only 10%, my lord.
Now, if you see the doctor's report, all pertaining to the nasal bone, he has given 101
That's
fractures.
Yes.
That's only 1 fracture. Left knee, nasal bone.
Yes.
There are only 2 injuries.
Yes.
See what has been stated.
As per the photographs, my lord, 2 legs, my lord, interlocking.
It's only left knee, even from the photograph also.
At least 20% disability, lord.
Why should we take 20% disability?
But 3 fractures, my lord, one femur bone is a fracture, my lord, right?
In your court is not a doctor.
I leave it, lords.
What we do is, for the loss of amenities, we give some more amount.
Only 5,000 was given, madam.
That we will enhance. Take this.
And loss of laid up period was not awarded, my lord.
20, page number, where is the table?
22, my lord. Internal.
Loss of future income, we will take as it is. Then loss of income during the laid up period,
3 months can.
how much is the income taken?
22,500 was considered.
Still you have not
It's
filed your
double,
appeal.
double the income which is stated in the
Because
chart.
he is auto
You
rickshaw
have not
driver, my
filed your
lord. We
appeal.
have produced
Yes,
the
my lord,
driving
we
license,
have
my
not.
lord.
So loss of income during the laid up period, 66,000. Then loss of amenities, how much was considered by the court?
Trial court considered only 5,000, my lord.
Percentage of disability?
8%.
8% will grant 30,000. Legal expenses, 10,000. There is it's coming to 4,42,360 against 3,32,360. Please come. Agreed with the award passed in embassy number 1988 of 2022 dated 21st February 2024 by so and so. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees. How much?
Lord,
225 lakhs for the injuries sustained by the claimant in the accident. The tribunal has awarded the compensation as per the table given below. Extract the table at paragraph number 13, end of paragraph number 13. Then counsel appearing for the petitioner appellant claimant submits that the claimant had sustained a nasal fracture and also a left knee joint fracture. And according to the doctor, the disability is 50%.
50%.
50%, but the tribunal has taken
Only 10%, 8%, my lord.
8% as a disability. It is submitted that the court has not granted any amount under the head of loss of income during the later period. Under the head of pain and suffering, the amount that is awarded is not appropriate, is not a just and reasonable compensation. It is submitted that no amount is granted under the amount for the disability the appellant has sustained. Court had granted only 5,000 as loss of amenities. It is submitted that on all the counts, the compensation that is awarded is not just and reasonable. Next para. Land counsel appearing for the respondent insurance company submits that the compensation that is awarded by the tribunal is on the higher side. Without there being any evidence, just because the claimant is a driver, the court had taken the income at 22,000 and granted the compensation, which is on the higher side. As far as the disability is concerned, the court had rightly considered the evidence of the doctor and rightly granted the compensation, and there are no grounds to interfere. Next para. Having heard the counsels on either side, there is a material on record. The petitioner has sustained one grievous injury and 2 simple injuries. Under the head of pain and suffering, this court is granting 50,000. Coming to the incidental expenses, he was in hospital for 17 days. This court is granting an amount of rupees 17,000. The medical expenses, the court had rightly granted 8,000 and no interference is called for. Coming to the loss of future income, the court, considering the evidence of the doctor that 25% is a disability to the lower limb, 1/3 of it has been taken, and for the nasal injury was also considered. The injury to the nasal bone will not amount to any disability, and the court had rightly taken 8% as a disability and granted the compensation. Hence, this court finds no reasons to interfere with the same. Coming to the loss of income during the later period, the court had not granted any compensation. This court is granting an amount of rupees 66,000, that is 22,000 into 3. towards loss of amenities, considering the 8% disability, this court is granting 30,000. In the light of the law laid down in Mekala versus so-and-so, towards legal expenses, this court is granting 10,000. Altogether, the claimant is entitled for an amount of rupees 4,42,360. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 3,32,360 to 4,42,360.
My lord, one submit for removal of two screws for future medical expenses.
Was it recorded?
Nothing is recorded because
That has come in para 13, my lord. Interlocking nails and two screws which were inserted in.
In his submissions, no amount is granted for the future operation. For the future operation, 20,000, give it. Hence, this court is granting 20,000 towards the future operation.
interest at 6%. 6% interest.
That it will be 6%. 20,000, it comes to 4,62,360. The enhanced amount shall carry 6% interest. You ask them for the order copy. They'll have certain, as it is, you have to take it. Yes, next.
Please, grateful.
What? Yes, bill number 27, is number 2.
Beneficiary appeal, morning session, notification is same, what is this difference?
In which case?
Morning, serial number 25, say beneficiary appeal.
That's what I'm saying.
Yes, yes.
Serial number is?
Serial number 25,
25.
Same order.
Same order.
Serial number 25, just verify from them, same order.
And 30 also same.
Also, notice also, yeah, the government feeder takes notice. Yes,
30 also same.
30 also same.
Yes.
Yes, next.
Yes. Seal number 28.
My lordship,
Arunal
this is the
Nilopan.
order challenging the dismissal of application, my lordship, seeking temporary injunction against the plaintiff.
Where is that?
Impugned order is at page, starts from page number 13, my lordship.
Page number 30.
Yes, my lordship.
1-3.
Yes, my lordship, 1-3. My lordship, respond number 1, suit for partition and separate possession, my lordship. Respond number 1, that is plaintiff filed a suit for partition and separate possession. Petitioner is the defendant number 4 in the suit. Defendant number 4 has taken up the specific contention that there was an earlier suit wherein the item number 5 and 7 of the present suit are held to be the exclusive properties of the defendant number 4. That suit also have produced, my lordship. It's OS number 38 of 2017.
Come to the reasoning part, let's read.
Please, my lordship.
Yes.
It starts at page number 17, my lordship. Point number 1, learned advocate for defendant number 4 submits that.
Defendant number 4.
Please, I am for defendant number 4. Petitioner herein is in defendant number 4.
Read.
Learned advocate for defendant number 4 submits that in OS number 38 of 2017, already the defendant number.
What is this?
That OS was also for the partition itself, my lordship.
Between the same parties.
Between the same, to some other extra parties were there. In that suit, I am held to be the owner of the properties. Please, my lordship. Learned advocate for the defendant number 4 submits that in OS number 38 of 2017, already the defendant number 4's right is adjudicated and the rights between the parties is also adjudicated. And it is specifically held that the defendant number 4 is the owner of suit item number 5 and 7 properties. And therefore, the plaintiff who has not at all challenged the said judgment and decree which has attained finality cannot again continue with the suit, this suit, and hence seeks for allowing the application as the plaintiff under the grab of filing this suit is interfering with the defendant number 4's peaceful possession and enjoyment of the suit item number 5 and 7 properties, and hence seeks for allowing the application. Para number 8, my lordship. In support of his contention, he draws my attention to the judgment and decree in OS number 38 of 2017 and draws my attention to page number 33 of the said judgment and prays for allowing the application. On the other hand, the learned advocate for the plaintiff submits that the present application is in the present form filed by the defendant number 4 is not at all maintainable, and the cause of action to file the present application and the cause of action for filing of the suit are different, and hence the present application in the present form deserves to be dismissed, and hence seeks for dismissal of the application. Para number 10, my lordship. In support of his contention,
Sought injunction in this case, in his
please, my
suit.
lordship.
You sought for injunction in his suit.
Yes, my lord. I being the defendant sought injunction against the plaintiff. Since there was an earlier decision,
Yes.
please, ma'am. Para number 10. In support of his contention, he draws my attention of the judgment of Honorable High Court of Karnataka in the case of Veerabhadrappa versus Mayappa reported in ILR 1993, Karnataka 161 and submits that the application in the present form is not at all maintainable.
Notice to the respondent. This next.
Sure.
Notice.
Grateful, my lordship.
Till number 29? 29?
My lordship, in this case, I have filed I am the plaintiff, my lordship. I had filed an application seeking relief of depositing the amount before the trial court, rent amount, partition, my lordship.
Between the same parties.
Between same.
Notice in this.
No, not that, my lordship. This is different, sorry.
Leave that.
I apologize.
Seal number 30, adjourn, seal number 31.
Genealogy is at page number 6, my lordship.
Yes.
C. Hanumantu is my father, Jayama is mother, Shankar and Prasad are my brother, C. Chhatrapati is myself, my lordship, that is plaintiff. I filed a suit for partition and separate possession of 3 to 4 properties, my lordship, wherein item schedule A property is purchased by father, since it is allotted to the by housing board, my lordship. Which application was filed by father earlier and it was allotted in the name of defendant number 1. All the installments are paid by my father. So I had included that property. In that, it is an RCC building wherein there are many shops. So I filed an application seeking the shop rented persons like tenants to deposit rent amounts in the court proceeding. Court, my lordship.
Let's see.
That came to be dismissed, my lordship. Dismissed on the grounds that fair and debatable case with regard to the claim of the plaintiff, and one more ground quoted by the trial court is that if I succeed, if the plaintiff succeeds in the court case, he can claim for means profit. On these 2 grounds, the application came to be rejected, my lordship.
What was the age of the defendant number 1 on 8/4/2002?
21, my lordship. He was just aged 21. So that entire installment amount to the housing board is paid by father of the plaintiff also, plaintiff, my lordship. Even the plaintiff has produced the receipts having paid the amount.
You can pass orders finally, no notice, you can take out personal notice.
Please.
Hand summons on the counsel appearing to the respondent before the trial court and shall file a memo to that effect. Once a memo is filed, this is matter.
Grateful, my lordship.
Yes.
Seal number 31, Shivasayam Patil.
Lordship, this is national authority matters, my lord. Lordship, yesterday, the court directed me to produce the calculation. What has happened is admitted amount has been paid, my lord. Now it is regarding the enhancement amount. 80 rupees square feet has been awarded, SL award, which is called. That amount has been paid. Now the 80 rupees has been enhanced to 994. So that is under dispute.
What I have asked you yesterday.
Please, ma'am.
Now please come to the order. What is fixed by the land acquisition officer?
SLO.
SLO 80 rupees square feet. Please. Then the land loser approached the arbitrator. That is the deputy commissioner. He has enhanced it to 994 per square.
994. Basing on what?
Basing on the NA potentiality he has, and depending upon the adjacent lands.
Then what is wrong in that?
My lord, my submission is NA potential. There is no classification in NH Act. So that NA potentiality gives the ambiguity. So those matters are pending for consideration before division bench. So there is gap is too much. The land adjacent to the agricultural land and converted land, that cannot be differentiated. That is the case of the land loser. So my submission is, we'll deposit the amount, give us some time. If we succeed, or if otherwise, the amount may be.
Deposit the entire amount.
Yes, ma'am. Yes, ma'am. That is the submission I have made, and division bench has also passed an order to deposit 50% within 4 weeks and 50%. That I have produced. Today, ma'am, also I have produced the order copy. That flags, page number 3 I have produced. My fair submission is that I am ready to deposit because they have filed execution petition and they are pressing the matters, and we cannot work if the attachment orders are passed. And it is the charge on the Consolidated Fund of India, and we won't run away.
In this, it is 50%.
Yeah.
Land council appearing for the appellant submits that the SLO has fixed the market price at 80 rupees and the same is enhanced to 994 without any basis. It is stated that the reason for enhancing the same, where is the order? Is that,
Please, ma'am.
where is the order?
Arbitration appeal is dismissed. Even this annexure B is the arbitration award, ma'am.
Page number.
Page number 53. It is in Kannada, the last question. But it is been clear that from 80 rupees it has been enhanced to 994.
990. It is submitted in the similar matters. The division bench of this court has granted stay on the condition that they should deposit 50% of the award amount along with the interest before the executing court within a period of 4 weeks and remaining 50% of the amount to be deposited within a period of 10 weeks from the date of order. And the executing court is directed to invest a certain amount in fixed deposit for an initial period of 1 year with an automatic renewal clause. When counsel for the appellant submits that the same order may be passed in this petition. Considering the submission and in the light of the order passed by the division bench, same order.
Notice has to go, Your Lordship. Notice has to go.
Notice.
For respond number 1,
You take.
One is party.
I'll take for notice for respond number 2, Your Lordship.
Respondent number 2.
Please.
So accepts notice on behalf of respondent number 2. Who are the other respondents?
Respond number 1 is the claimant, Your Lordship.
One is claimant, land loser.
Please. One respondent, one issue notice to respondent number 1.
32 also same, man.
IA 1 of 2025 is filed, dispensation certificate copy of the arbitral award for the reasons stated. IA is ordered. 33 also same order. In that also notice.
Same.
32, serial.
32 also same, man.
Yes.
Serial number 33. Serial number 33.
Which time may be accommodated?
Aye.
Which time may be accommodated? Correctment is out of session.
For deposit to be filed. Interim order is on 30/10/2025.
That is, stay is granted. Stay is granted.
Stay is granted. Where is the proof of deposit?
We'll deposit in with,
Which time is granted for filing the proof of deposit?
please.
Yes, or else the stay granted by the court stands vacated. Yes, 34.
34, preliminary hearing matter.
This is petition pertaining to the grant of general parole lordship.
Huh?
Parole lordship. Grant parole lordship. There is the convictee, petitioner is the son of the convictee lordship. Convictee is convicted under section 302 of IPC lordship. Now he, the convictee is under jail lordship from 11 years lordship. That's page number 33 lordship. The certificate issued by the respondent to lordship. Now I seeking the parole lordship on the ground that.
No, petitioner is accused in.
Please lordship.
Huh?
Petitioner is the son of the convictee lordship. By name Kumar, son of Ramaya lordship. He Kumar Ramaya is convicted under 302 of the IP. He is under custody lordship from 11 years lordship. Since he is entitled to the general parole for 90 days lordship. In the same setup, the Sanva Court enlarged granted the.
How it comes before a single judge? What is this parole in?
Under section 56 of the Karnataka Prisons Act.
Huh?
And it says, my lords, release of the convicted person.
Huh?
Release of the convicted person on parole. My lords, the grounds which are raised in the section 56 of the my lords, the.
Let's see that.
56. Karnataka Prisons Act 1963.
56, sir.
56 of the Act.
Release on parole.
Yes, ma'am.
Always these matters will come before the High Court.
Yes, ma'am. When the authority rejects the Mallards their application, they came before the High Court for Mallards under section 220, 226 to 227 of the articles of the Constitution of India. And this honorable court in similar circumstances pleased to pass orders granting in case of serious offences only 30 days.
Generally, like, this is not the procedure what we used to follow in Telangana.
Yes, ma'am.
Similar set of paragraphs, this envelope.
When
In
is
this case,
that? Please pass on that.
30 days may be granted.
in this case also 302 Lordship.
What is this request?
Mallards.
The residential house of the convict is collapsed
That is the one of.
during the rainy season.
Yes.
To reconstruct the house, presence of the convict is necessary.
Please, Lord.
How can it be?
No, Lord, so the same application given by the convict before the authority itself only. Lord. We cannot go beyond.
No. Even assuming that as per the so-and-so provision, you're entitled for a parole, there should be for some reason. You are there, what is your reason? For constructing the house, his presence is necessary, for that parole should be granted.
He is only one person. He is the only person, Lord. The photocopy also produced, Lord.
Even on these grounds also parole is granted. Generally, I am asking.
Yes. For the reasons, Mallards, there, section 56 of the Mallards Act says for specific. Section 56 of the Act says
But it
for
doesn't,
specific.
it speaks about
Some reasons.
reasonable causes of
Yes.
health reason or some other reason.
Yes.
That too in a 302 case.
Yes, 302. Mallards. Only consideration is he has substantially undergone the sentence of 11 years. That's the reason.
Temporary, Lord. It is continued.
We'll have it on Monday. It took something, Monday.
Monday, 12. Seal number 35, Jagdish Patil. Mrityunjay
Of the
Tata
petitioner, my
Bank.
lords. There was a direction to the government advocate to secure the report with respect to the encroachment.
What is this?
Without proper procedure on without initiating acquisitions, without proper procedure, my lords, without initiating acquisition
See,
proceedings.
what is your prayer? Directing the respondent to
Page number
initiate
7.
acquisition proceeding with respect to and direct the respondent and then not to interfere with the property of the petitioner, including that of encroachment, trespassing, construction.
Construction.
Lord, since I have filed my memo for appearance on the 5th, ma'am, may I request in the next week? Need to get certain instructions, my lord.
What did they do?
There
They
was
already
there was a direction to the government.
taken possession of your property.
Yes, ma'am, they already encroached it. And in fact, there was a report also by the ADLR in which that they have found that the portion of which has been encroached.
Half of which respondent?
Respond number 1. I have to-
Union of
Mrityunjay
India.
Tata Bank. Respond number 1.
In fact, on the last date of hearing, there was a direction to the government advocate to secure the report with respect to the encroachment.
Yes. Direction to the government.
Government advocate, on the last date of the hearing, my lords, to secure the report.
17/12/2025.
Of encroachment.
Learned government advocate is directed to secure the report relating to the extent of the encroached portion.
So I'll take instructions.
On 17/12/2025, there's a direction to the government advocate to secure the report relating to the extent of the encroached portion. The government advocate requests time. This is matter on 19th of January. By that time,
Interim order may kindly be extended.
instruction shall be placed on record.
Interim order may kindly be extended.
Interim order earlier granted is extended till then.
Copy of the petition made
Huh?
copy of the petition made available to you.
You appear for the,
Copy of the petition minutes is not served on.
not served.
I will serve it.
Then how he was asked to get instructions?
I was not
The
aware.
petition should serve the copy of the writ petition on the counsel for the respondent.
Please,
For
please,
the
ma'am.
AGA.
Please.
Seal number 36, Shuraj Parole, please.
Appealing for the
Deepak S. Kulkarni.
petitioner, my lord.
My lord, they may be directed to give us the copy of the writ petition. We are the caveator. We need to file objections.
Yes, the land council has served the copy of the writ petition on the counsel for the respondent. When to recess matter?
Next week.
This is matter.
My lord, interim order may kindly be extended.
This is matter on 21st of January. Interim order earlier granted is extended till then. Then 37.
Seal number 37,
Please.
Satish Raichu.
Yes, my lord, I am for the petitioner, my lord. The petitioner has filed application under section 10 for the stay of the suit. And I would like to refer to the impugned order, page number 47, my lord. Page number 47.
Yes.
Paragraph number 9 and 10 I would like to read. But it is pertinent to note here that the plaintiff has filed his suit by seeking half share in 1/4 share of defendant number 1. But in OS number 149/2012, even though the Honorable Court has allotted 1/4 share to the defendant number 4, who is the defendant number 1 in this case, but as he has already sold the property through sale deed, hence share of present defendant number 1 were allotted to present defendant number 5 and 6 who are purchasers as per the judgment and decree of OS number 149/2012. Present defendant number 1 has no any property, therefore present plaintiff will not get any property towards her share. So this observation, my lord, that has been taken in consideration of disposal of this IA number 10, wherein the plaintiff has sought for the stay of the proceeding since the FDP between the respondents herein is pending as per the decree in OS number 149/2012. And earlier the defendant number 5 who has filed objection to my application, a similar application came to be filed by him, wherein the plaintiff counsel has submitted no objection. That IA is still pending consideration. And the impugned order, the trial court comes to the conclusion that the suit itself is not maintainable. And after disposal of this order, passing of order on this application, the matter was posted for hearing on maintainability, and now it is posted for orders on maintainability. While disposing of the interim order, interim application, court cannot come to the
You are
conclusion
aware
of
of the suit that is filed in the year 2012. You wait till 2025 and you seek the FTP proceedings to be stayed. How can it be?
No, stay of the proceeding, the impugned order, stay of the proceeding was earlier, IA number 9 was filed by defendant number 5. We came to know about the pendency of the FDP. We have no knowledge about the earlier OS number 149 by 2012. And subsequently, when we came to know that the defendant number 1 share is to be carved out in the FDP.
As it is clear that in the year 2017 itself, plaintiff and the counsel were aware about proceedings of OS number 149 of 2012.
Yes, that was thereafter the IA number 9 was filed by the defendant number 5 to stay the proceedings.
Notice to the respondent.
It is posted on 9 for orders, my lord, on maintainability. My writ petition will become infructuous. Till then, at least the court should not pass, trial court should not pass any orders on the merits.
Appeal for petitioner.
Yes.
My lord, my friend respondent takes notice for respond number 1 and 2 for work board. He is a panel advocate.
So and so takes notice.
1 and 2.
Half of respondent,
1 and 2.
3 notice has to go.
Notice my friend appears.
You file your wakalat?
Yes, Lord. File mod.
So and so.
Undertake to file wakalat.
Submits that he has instructions to file wakalat on behalf of third respondent. Yes.
Page 6 of my prayer, page 6.
Hmm.
There are two prayers.
Respondent number 1 to pass orders appointing respondent number 2
As a
administrator, election officer to respondent number 3 institution under rule 54 of the work rules. 2 to take charge of respondent number
second
3
prayer, I will not insist, my lord, I will not press for second prayer. Kindly turn to annexure A in page 8.
Page?
8. My lord, in this, my lord, at serial number 5, 6, 7 and 10 are the petitioners.
Hmm.
And serial number 1 is respond number 3.
Hmm.
My lord, this committee was formed on 10/2/23. Their term expires on 10/2/26. 3 years.
What do you say?
3 years term is there in accordance with 54 Millard. Rule 54 enshrines that before expiry of the term, they have to constitute succeeding committee. So that process.
Get 54.
Please. Rule 54. Clause
54.
2. Clause 2. Such committee shall initiate process of constitution succeeding committee as per approved scheme.
50?
54(2).
54 to the notice referred shall be served.
It's not section 1, rule 2017. Rule 54(2), Work Act rules 2017.
Yes, yes.
Subsection 2. Such committee shall initiate process of constitution of succeeding committee as per approved scheme of 3 months prior to expiry of term of committee and shall complete the entire process of constitution of succeeding committee within 2 months prior to expiry of committee.
What do you say? Now it is completed already.
This term is before expiry, they have to start the process of electing a succeeding committee. That process has not been started. So the petitioner is seeking directions from this honorable court, directing the board to appoint an enrollment officer and also election officer. So in accordance with the rule, the board may consider the representation.
Yes.
That is my submission, my lord.
You are the existing
President of that
the committee.
committee.
The present petition is filed, seeking the following prayers. Then counsel for the petitioner submits that is not pressing for the second prayer. The facts of the case are the petitioner, respondent number 3 and others were elected as managing committee of respondent number 3 institution on 10/2/2023 for a period of 3 years. The term of the committee expires on 10/2/2026. As the term of the committee expires on
A request is there.
10/2/2026.
A request is there from the committee.
2026, the petitioner made a representation dated 1/1/2026 to respondents to call for general body meeting and immediately start election process as contemplated under Rule 54 of the Act, 54 of the Waqf Act Rules 2017. It is a grievance of the petitioner that the
It is, sorry, Milan, it is rules 2007. Yes. Yes, yes, rules.
under Rule 54 of the Waqf Act Rules 2017. It is a grievance of the petitioner that the respondents have failed to comply with the same, which made him to come before this court. Learned counsel appearing for the first respondent submits that they will consider the representation in the light of section 50, Rule 54(2) of the rules of the Waqf Rules 2017. 17. Accordingly, this court is passing the following order. The writ petition is disposed of, directing the respondents to consider the
Respondent number 1. Only
respondent number
respondent.
1 to consider the representation dated, where is that?
My lord, annexure B, my lord. Annexure C,
Page dated
please, my lord. 5/1/26.
5/1/26, in accordance with Rule 54(2) of the Waqf Rules 2017.
1/1/26, not 5/1/26. Representation dated.
1/1/26 in accordance, accordingly disposed.
Much obliged.
Number 39,
Some time limit,
Kumar Chettiman.
some time limit.
It is expiring on, in the month of.
My lord,
February.
what rule says is 3 months prior to expiry of term. That has to be commenced on 10/11.
By end of this month,
To consider appointing the election officer
whatever
and
it is, the whole process shall be completed within a period of 30 days from the date from today.
Please.
From the date of receipt of the copy of
the
law.
entire process will not be completed, my lord. Only appointment of election officer and enrollment officer. This will be considered by the board
Appointment of election officer
and enrollment officer
officer shall be completed
within 1 month.
1 month from the date of receipt of the copy of the order.
Please, much obliged.
Yes.
Seal number 39,
For petitioner, my lords. The husband of the petitioner died due to the electric shock on, my lords, 19/6/2025, my lords. Thereafter, the inquiry committee is submitted report to respondent number 1, my lords. Thereafter,
To issue a writ in the nature of mandamus directing the respondent number 1.
to take further action.
Further action on the report submitted by respondent number 2. Who is
Please.
respondent number 2?
Respondent number 2 is the deputy engineer, my lords.
Huh.
Deputy electricity inspector, my lords. He has submitted report to the respondent number 1, my lords.
Who appears for the respondents?
Bhushan Kulkarni, my lords.
What is the name?
Bhushan B. Kulkarni.
So and so is directed to take notice on behalf of the respondent.
For respondent number 2 and 3 and 4, sorry, my lords. 2 and 3, my lords.
Who?
Bhushan Kulkarni, my lords. 1 and 4, my lords.
Kulkarni.
1 and 4, my lords, government, my lords.
1 and 4 government advocates, serve the
Please.
papers on them.
Please, ma'am. Already
This is-
served, ma'am.
This is matter on 14th January.
Please.
14. Preliminary hearing, seal number 40 and 41 adjourned. 42. Charangiri.
Please, my lord. Appearing for petitioner, my lord. My lord,
This 42 will have tomorrow, 42 tomorrow.
Please.
And all these fine hearing matters, 43 to, these are all MBC matters. List these matters on 13th. 30.
please, interim order.
30. What is the password?
Password.
Oh, password matters.
This one seal number
Interim order in 42 may kindly be.
If any interim order is there, extended.
Please.
Yes. 40?
48. This one.
48, we'll have it on 13th,
13.
13th,
Okay.
13th to 13th.
13 to 13. 13 to 13. Will it go?
Serial number 46, Your Lordship. Serial number 46.
Final hearing matter. All the final hearing matters, it will come next week.
Much out.
ಇಲ್ಲಿ 55 ಇದೆ ಎಲ್ಲ 13 ಇವೆಲ್ಲ 13 ಡೇಟ್ 42 ಎಂಟ್ರಿ ಮಾಡ್ರಿ ನೋಡಿ 42 ಅಲ್ಲ 42 ನಿಮ್ಗೆ ಕೊಟ್ಟೆ ನೋಡಿ ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ
Court officer? Court officer? Sir, 13 Jan ಗೆ ಹೋಗಿದ್ದೆಲ್ಲ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್?
ಹೌದ್ರಿ 13
ಆಯ್ತು, ಥ್ಯಾಂಕ್ ಯು.
ಎಲ್ಲಿದೆ ನಮ್ಮ ಕಡೆ ಎಲ್ಲಿದೆ 1963 ಇರ್ಬೇಕು ಇಲ್ಲೇ ತಡ 1963 22 ಅಲ್ಲ 20 or 22 ಅಲ್ಲ ಇಲ್ಲಿ ಬಿಡ್ರಿ ಇಲ್ಲಿ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ನಾನು ಈ ಹಾಕ್ಕೊಳ್ಳೋ ಅಣ್ಣ 63 ಪ್ರಿಂಟ್ ಒಂದು ಕೊಟ್ಬಿಡಿ 48 ಏನ್ ಕೊಟ್ರಲ್ಲ ಅದು 13 ಎಲ್ಲ ಅವ್ರಿಗೆ ಕಳಿಸಿದ್ರಿ ಇವೆಲ್ಲ ಕಳಿಸಿ ಬಿಡ್ತೀನಿ ರೀ ಇವೆಲ್ಲ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅವರೇ ಮಾಡ್ತಾರ 13 ಡೇಟ್ ನಾವೆಲ್ಲ ಬರ್ತೀನಿ ಹೌದು
मैडम इनको नहीं जरा
सर हाँ
तुम्हें गुलबर्गा छोड़ के आज मालूम नहीं मैं सर दादा में
JTR सर
सर
फाइनल
जरा
हियरिंग मैटर कಳಿಸ್ತೀನಿ ಸರ್
जरा मैं फोन करना तुम्हें मोहम्मद MUHAMMED MUHA
ಅಲ್ಲ ಇಶ್ಯೂ ನೋಟಿಸ್ ರೀ ಏ
मोहम्मद अली A अल B ಅಂದ್ರೆ ಇನಿಷಿಯಲ್ ಒಕಲತ್ ಹಾಕ್ತೀನಿ ಮೇಡಮ್
39 14-1 ನಾವು ಸಿಕ್ಕಾಪಟ್ಟೆ ಬುಕ್ಕ ಸಾಕಿ ಸಿಕ್ಕಾಪಟ್ಟೆ ಬುಕ್ಕ ಸಾಕಿ ನಾನು ಸಾಹಸ ಬರ್ತಾವ್ರಿ ಭಾಳ ಬರ್ತಾವ್ರಿ ನಾ ಯಾವ್ದು ಅಡ್ವಾನ್ಸ್ ನೋಡಿ ಎಲ್ಲ ಇಟ್ಟಿರ್ತೀನಿ ನಾವು ತೊಗೊಳೋದಿಲ್ಲ ಅವು ಹೋಲ್ ಬಿಡೋದು ಬಿಡ್ತೀವಲ್ಲ ಅವು ತೊಗೊಂಡ್ಬಿಡ್ತಾರೆ ನಮೀಗ ಸುವರ್ಣ ಮೇಡಮ್ ಕಾಲ್ ಮಾಡಿಬಿಟ್ರು ತಕ್ಷಣ ಮಾಡಿಬಿಡ್ತಾರೆ ಎಷ್ಟಾಗಲ್ಲ ಮೇಡಮ್ ರಿಸರ್ವ್ 3 ಆಗಿದೆ ಬ್ರಹ್ಮಣ ಬ್ರಹ್ಮಣ ಬರ್ರಿ ಮೇಡಮ್ ಕರೀತದ.
ನೋಡ್ರಿ ನಂಬರ್ ಬರ್ಕೊಡ್ಬೇಕಾ ಸೀರಿಯಲ್ ನಂಬರ್ ಬರ್ಕೊಡ್ಬೇಕಾ? ಸೀರಿಯಲ್ ನಂಬರ್ ಬರ್ಕೊಡ್ತೀನಿ ತಗೊಳ್ರಿ.
ಮೇಡಮ್ ಮೇಡಮ್ ಇದಾಗಿಲ್ಲ.
ಎರಡು ಬರ್ಬೇಕು. This one is not a